Bismillah ar-Rahman ar-Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Introduction to Paralegalism, 9th edition. Chapter 6, narrated by Omar Mohsen Ibrahim Fouad. Attorney Ethics and Paralegal Ethics. Chapter Introduction. Chapter Objectives. After completing this chapter, you should be able to discuss the 25 major ethical guidelines for paralegals. Explain how attorneys are regulated, including the sanctions that can be imposed for unethical conduct. Compare and contrast the relationship between attorney codes and paralegal codes. Identify how the standard of competence applies to paralegals and list ways in which paralegals can stay competent. Identify the major ethical rules that govern attorney and paralegal fees. List ways in which wrongdoing by paralegals can lead to sanctions against their supervising attorneys. Summarize the duty to preserve confidentiality and list the times when an attorney can reveal confidential information. Distinguish confidentiality, the attorney-client privilege, and the attorney work product rule. Define conflict of interest and summarize the major conflicts that can exist. Explain how a paralegal can contaminate a law office and the ways in which disqualification can be avoided. List the ways in which an attorney illegally assists another in the unauthorized practice of law. Explain the components of effective supervision of paralegals by attorneys. Describe what a paralegal should do when faced with an ethical violation on the job. What if you have worked with your supervising attorney, Lee Ann, for years? You know her family, have been to her house, and have been invited to birthdays, weddings, and graduation parties. Everyone knows how close you are to Lee Ann and knows that you would do anything for her. Lee Ann knows that too. Over the course of the last few months, you have seen a change in Lee Ann's behavior. She is distant and short-tempered, very unlike her. You notice she is staying unusually late at the office and keeps her door shut most of the time. You want to approach her and see if anything is wrong or see if there is anything that you can assist with, but she puts up barriers, especially with you. Some of the other partners have noticed the changes in Lee Ann and ask you what's going on. Your response is always the same: everything is fine. Just lots of work and cases coming to trial. No more than usual. As a trusted employee of the firm, you have access to the firm's trust and operating accounts. Lee Ann frequently instructs you to access the accounts for different reasons, and you have a pretty good idea what the balances are. One afternoon, as you access the client trust account, you know that it is substantially less than it was the day before, $55,000 less. Concerned, you bring this to Lee Ann's attention. She walked over to the door and closes it. She tells you that she is aware of the balance and then tells you that she just borrowed from the account temporarily and will pay it back next week. She tells you not to tell anyone, especially the managing partner of the firm. You say nothing and leave her office. What to do? As shocking, perhaps, as the facts may seem, this scenario is not that far-fetched. Paralegals, attorneys, and other legal staff may be presented with a similar situation and have to decide how to manage it. We will review the ethical and professional responsibilities of both attorneys and paralegals, and the numerous ethical implications of our facts. What we will now delve into is the complex world of legal and professional ethics and how to respond to the ethical situations you will be presented with as a paralegal. 6-1 Ethics in the Real World. Ethics are rules or standards of behavior to which members of an occupation, profession, or other organization are expected to conform. Ethics governing attorneys are called legal ethics or codes of professional responsibility. As you know from the media, a fairly large segment of the general public does not have a favorable opinion of attorneys. Elsewhere in this book, we examine some of the reasons for this hostility. Here in Chapter 6, we confront one of the main reasons, the perception that attorneys are not very ethical, or more cynically, the perception that attorneys are ethical only when it doesn't cost them anything. Courts and legislators have responded to this problem in different ways. Every law school must offer a required course in legal ethics. Many state bar associations require practicing attorneys to attend annual continuing legal education, CLE courses or seminars on ethical themes. State disciplinary bodies have hired more attorneys and paralegals to investigate claims of ethical violations by practicing attorneys. Of course, attorneys are not the only individuals under attack for ethical misconduct. Some commentators claim that the problem is rampant throughout society. Our focus here, however, is the legal profession. As paralegals, you are about to enter a very special work environment. You will meet many different kinds of attorneys whose ethical behavior is beyond reproach, attorneys who engage in blatantly unethical behavior, and attorneys who sometimes walk a thin line between ethical and unethical behavior. Which of these categories of attorneys will one day be your employers and supervisors? The short answer is that you don't know. Hence, you need to prepare yourself for any work environment. In the abstract, it's easy to be ethical. We all agree that the proper course of conduct is to do the right thing. The problem, however, is that pressures in the real world, particularly financial pressures, can interfere. The nice ties of ethics can sometimes give way to the desire to win, the urge to retaliate, or the fear of losing a job or a client. Pressures such as billable hours, overhead costs, and technology cause people to take shortcuts, like extending the length of cases and lying about billable hours. With these sobering thoughts in mind, you should begin your paralegal career with the resolution of becoming an arch conservative on matters of ethics. Our goal in this chapter is to provide you with tools that will enable you to become this kind of conservative. We begin by presenting an overview of some of the most important ethical guidelines that we will study. Carefully read, indeed memorize, the 25 guidelines in Exhibit 6-1. Exhibit 6-1, 25 major ethical guidelines for paralegals. 1. Disclosure of status. Be sure that everyone with whom you come in contact knows that you are not an attorney. Do not allow people to assume that you are an attorney, which is likely when they learn you work in a law office. 2. Accepting cases. Do not accept a case on behalf of the office. You can tell someone what kinds of cases the office handles, but you cannot say or imply that the office will take someone's case. Only an attorney can establish an attorney-client relationship. 3. Setting fees. Do not set a fee. You can tell someone the amount of an attorney's initial consultation fee, but when questioned further about fees, you must say that fees need to be discussed with the attorney. 4. Sharing fees. Do not accept a part of the fee of a particular client, even if the attorney offers it to you. Attorneys cannot share split fees of particular clients with non-attorneys. Your salary will come out of the fees generated by the office. But it is unethical for an attorney to agree in advance to give you a bonus or other compensation on the fee that will be generated by a particular client's case. This is so even if you referred the client to the office, even if you did great work on the case, and even if the client agrees to let you have part of the fee. 5. Compensation for referring clients. Do not accept anything of value for recommending an attorney or for referring a case to the attorney. Something of value can include increased salary, a bonus, time off, a promotion, etc. 6. Confidentiality. Do not discuss the facts of a case with anyone outside the office, including your spouse, partner, or parent, without permission from your supervisor. If you have information related to the case, you must keep the information confidential. This rule is not limited to secrets or personal information about the case. It includes all information related to the case, including the fact that a particular person is a client of the office, although some information about a client may already be public knowledge. Abide by the rule that you will not discuss any aspect of the case without permission from your supervisor. KIC, keep it confidential. 7. Confidentiality. Before sending documents prepared on a computer or before filing them in court, remove the metadata information hidden within the document itself. Metadata can consist of confidential information. Confidentiality. When sending messages or documents online, like for example as email attachments, be sure that the client understands that the communication may not be secure. Know how to encrypt the communication if your supervisor deems this precaution to be necessary. Encryption places the text in a code that can be read only by persons with special software. Extra caution is needed when placing client data on smartphones, tablets, and other small media devices, which are easy to lose and often relatively easy to hack into. 9. Conflict of interest. Let your supervisor know immediately if in your prior employment or volunteer activities you worked for other law offices with clients who have any connection or relationship with clients of the law office where you now work or volunteer. Your supervisor must determine if such connections create a conflict of interest. 10. Conflict of interest. Avoid romantic or financial relationships with current clients, opposing parties, relatives of opposing parties, or attorneys of opposing parties. 11. Conflict of interest. Understand how the office performs its conflicts check on every prospective client so that the office can avoid taking cases that would create a conflict of interest. 12. Conflict of interest. Let your supervisor know if a client has offered you a gift. If the gift requires the preparation of a document, the document may have to be prepared by an attorney who does not work in your office. 13. Competence. If you do not know how to perform an assigned task, let your supervisor know that you need additional training or a different assignment. 14. Competence. Never stop learning the substantive and procedural law that pertains to the tasks you are assigned. Once employed, competence is maintained primarily through self-study and through continuing legal education, CLE. 15. Communication with other side. Do not contact an opponent or anyone connected with an opponent unless you have the permission of your supervisor and your opponent's attorney. Do not try to become a Facebook friend or establish other kinds of online connections with an opponent or anyone connected with the opponent. 16. Communication with other side. If the other side is proceeding pro se without representation and your supervisor allows you to communicate with them, you must not give the impression that you are disinterested impartial, or unconnected with the case. They must know that you work for the other side. 17. Solicitation and advertising. Do not initiate contacts with anyone in person, by phone, or online, such as by email, on a social media site, in a chat room, etc., in order to encourage them to hire and pay fees to your law office unless the person already has a relationship with the law office. You can, however, recommend your office if someone asks you for a recommendation. Do not make misrepresentations or false claims in advertising. 18. Unauthorized practice of law. Do not give legal advice, which is any comment or conclusion that applies the law or legal principles to the facts of a specific person's legal problem. You can provide legal information, any statements about the law that are not directed at the facts of a specific person's legal problem, but not legal advice. When you are asked questions that call for legal advice, refuse to be coaxed into providing it, no matter how innocent the questions appear to be, no matter how clear it is that you know the correct answer. And no matter how confident your supervisor is that you can handle such questions on your own. With great caution, you can relay a message from an attorney that contains legal advice, but you cannot explain or elaborate on the message. If the client has any questions about the message, you must tell the client that you will let the attorney know what the questions are. You cannot answer legal questions even if you know the answers. 19. Unauthorized practice of law. Avoid performing any task in the office without attorney supervision, even if you have performed the task before and know how to perform it. Attorneys who are confident of the competence of veteran paralegals may not need to provide the kind of supervision that a new paralegal would need. At a minimum, however, the attorney must review the work of both experienced and inexperienced paralegals. 20. Unauthorized practice of law. Do not sign a pleading or any document that is filed in court, even if the attorney asks you to sign it. 21. Commingling. Do not deposit client funds, like for example proceeds of the sale of a home that is part of a property division in a divorce, into the same account that the law office uses for rent, salaries, or other office expenses. Avoid commingling. 22. Misconduct. Do not lie or otherwise misrepresent facts, like for example, do not pretend to be a stranger in order to obtain information from someone in an office or on an online social media site. Avoid pretexting, online deception to obtain information. Do not notarize a signature unless you were present and saw the signer place their signature on the document. 23. Misconduct. Do not pad your timesheets by stating that you performed a task you did not perform or spent time on a task that you did not spend. Avoid insider trading, improperly using or passing on to others any non-public information you learn about in the office in order to trade in the shares of a company. 24. Misconduct. Do not tell anyone how to hide assets so that the assets will not be available to an opponent in litigation, and do not tell anyone how to avoid a subpoena or other legal process. 25. Know the common rationalizations for misrepresentation and other unethical conduct. It's always done. The other side does it. The cause of your client is just. If I don't do it, I will jeopardize my job. Promise yourself that you will not allow these rationalizations to entice you to participate in unethical conduct, even if there are attorneys, paralegals, and others around you who use the rationalizations. In your career, the paramount question must always be, what is the right thing to do? Answering this question will not always be easy, particularly if you are forced to make a choice between your ethics and your job. This type of choice appears to be the focus of our introductory facts, and we will learn from this chapter some of the responses to those facts. 6-1A, Attorney at Law and Attorney in Fact. Before we begin examining the themes of ethics in greater detail, we should distinguish between an attorney at law and an attorney in fact. In the broadest sense, an attorney is an agent, a representative who is authorized to act for another. The two main categories of attorneys are attorneys at law and attorneys in fact. An attorney at law is someone who engages in the practice of law, which consists of using or attempting to use legal skills to help resolve a specific person's legal problem. An attorney in fact is someone authorized to act in place of another, often in a business transaction. Examples might include someone given the authority to sign a deed for another or to sell another's business. The document that authorizes another to act as an attorney, in fact, is called a power of attorney. Both attorneys at law and attorneys in fact are agents, but their authority as agents is quite different. An attorney at law practices law on behalf of another. An attorney in fact conducts a transaction on behalf of another. Persons who are attorneys in fact cannot practice law unless they are attorneys at law. Phrased another way, given a non-attorney a power of attorney does not grant them the right to practice law for the person giving the power. 6-2, Enforcing Ethics. 6-2A, Ethics and Sanctions. The ethical rules of some organizations are enforced by sanctions. A sanction is any penalty or punishment imposed for unacceptable conduct, like, for example, the sanction of a fine or expulsion from the organization because of fraud. A very different meaning of sanction is permissible or approval. Like, for example, the motion could not be filed without the sanction of the court. All of the major national paralegal associations have adopted ethical rules, as we will see later in Exhibit 6-4. None, however, is enforced by meaningful sanctions. A paralegal association might occasionally throw someone out of the association because of misconduct, but this is rare, and it is highly unlikely that an expulsion would interfere with their ability to work as a paralegal unless the reason for the expulsion would also cause an employer to be upset by what the paralegal did. Attorneys, on the other hand, are subject to enforceable ethical rules that can affect whether they are allowed to continue practicing law. Attorney ethics are backed by sanctions. The rules govern everything an attorney does in setting up, running, and shutting down a law office. Of course, one of the things an attorney can do in running an office is hire paralegals. Hence, the way in which the attorney uses paralegals are subject to ethical rules. Unethical use of paralegals can subject the attorney to sanctions. This can occur in a number of ways. As we will see, an attorney has an ethical obligation to avoid assisting a non-attorney in the unauthorized practice of law, UPL. This can occur by delegating tasks to a paralegal that only an attorney should perform, like, for example, signing a pleading. Delegating a task to a paralegal that the latter is allowed to perform, but failing to provide adequate supervision for the task, like, for example, not reviewing a pleading written by a paralegal before it was filed in court. Helping an independent paralegal set up a business in which the paralegal engages in tasks only attorneys can perform. Like, for example, helping pay the rent of an independent paralegal who runs a divorce service in which the independent paralegal gives legal advice to their clients. In these three examples, the paralegal is engaging in UPL, unauthorized practice of law, and the attorney is unethically assisting a non-attorney in UPL, unauthorized practice of law. 6-2B, who regulates attorneys? In most states, the regulation of attorneys is primarily under the control of the highest court in the state, often called the Supreme Court, which determines when an attorney can be granted a license to practice law and under what conditions the license will be taken away or suspended because of unethical conduct. The state legislature may also have some regulatory authority over attorneys, and disputes occasionally arise over which branch of government can control a particular aspect of the practice of law. The judiciary often wins this dispute and becomes the final authority. In practice, however, the judicial branch and the legislative branch usually share regulatory jurisdiction over the practice of law. For example, the state legislature may have the power to impose minimum standards on attorney conduct, but the state Supreme Court may be able to impose standards that are higher than the minimum. Neither the courts nor the legislature, however, performs the day-to-day functions of implementing the rules governing attorneys. That rule is delegated to an entity such as a state bar association, an office of registration, or a disciplinary board or grievance commission. Bar associations have a central role in the regulatory process even in states where other regulatory bodies also exist, such as a disciplinary board. There are 4 kinds of bar associations: national, like for example, American Bar Association and Hispanic National Bar Association; state, like for example, Illinois State Bar Association and State Bar of Montana; local, like for example, Boston Bar Association and San Diego County Bar Association; specialty, like for example, American Academy of Matrimonial Lawyers, American Association of Justice, National Association of Women Lawyers. Some bar associations fall into more than one category. The American Academy of Matrimonial Lawyers, for example, is both a national and a specialty association. All national, local, and specialty bar associations are voluntary. No attorney is required to be a member. At least one state bar association in each state, however, is integrated, which means that membership is required as a condition of practicing law in the state. An integrated bar association is also referred to as a mandatory bar association or a unified bar association. Under the supervision of the state's highest court, this state bar association can propose revisions in the ethics code, write opinions interpreting sections of the code, and collect dues that are used to help fund the state's system of enforcing ethical rules. Given this dominant role of bar associations, the method of regulating attorneys in America is, in large measure, self-regulation, attorneys regulating attorneys. This is true even in those states that allow non-attorney citizens to serve on some boards or commissions that help regulate the legal profession. Online exercise. In your state, who has the primary authority to regulate attorneys in the practice of law? The state Supreme Court, the legislature, a combination of both? Identify from where the authority exists, i.e., important example, a statute, court rule. 6-2C. Attorney codes of ethics. There is no national set of ethical rules that applies to every state. Each state can adopt its own ethics state code to regulate the attorneys in that state. The state code may have different names such as rules of professional conduct, codes of ethics, canons of ethics, code of professional responsibility, or model rules. Although there are some important variations among these state codes, they are substantially similar. The reason for this similarity is the influence of the American Bar Association, ABA. The ABA is a voluntary national bar association. No attorney must belong to it, yet approximately 55% of the attorneys in America do belong. Paralegals can join as ABA associates. The ABA publishes ethical rules but does not discipline attorneys for unethical conduct. The role of the ABA in this area is to write ethical rules and to propose to the individual states that they be accepted. A state is free to adopt, modify, or reject the ABA rules. The current recommendation of the ABA is found in a document called the Model Rules of Professional Conduct, MRPC. This document has been very influential throughout the country. Almost every state has adopted it with relatively minor changes. The Model Rules MR is a revision of the ABA's earlier Model Code of Professional Responsibility. Exhibit 6-2 presents an overview of the major ethical codes governing attorney conduct. Most of these codes include provisions that are directly relevant to paralegals and other non-attorneys who work for attorneys. See the last column of Exhibit 6-2. Later in the chapter, we will examine these provisions. Exhibit 6-2, Ethical Codes Governing Attorneys. Analyze this. Determine what rules of professional responsibility have been adopted by your state for the practice of law for attorneys. Are there any rules in your state's Code of Professional Responsibility that specifically apply to paralegals? If your state has rules governing paralegals, place them in your portfolio binder. 6-2D, Ethics Opinions. There are two kinds of ethics opinions that interpret and apply specific rules in the ethical codes. First, there are opinions written by courts. These are binding in the state. Second, there are formal and informal ethical opinions written by bodies that regulate attorneys, such as bar association, committees on ethics, or on the unauthorized practice of law, UPL. These opinions are advisory rather than binding. The state's highest court must decide whether to adopt bar association opinions. The court usually does adopt them with minor changes, even those that have not yet been adopted are valuable because of the guidance they provide to practicing attorneys. See Appendix C for summaries of ethical opinions involving paralegals in your state. Attorneys can submit questions to the bar's ethics committee. To preserve confidentiality, attorneys submit these questions without clients' names or other identifying information. Like, for example, if an attorney represents client A in a case against a local merchant, would it be ethical to The answers to questions are sometimes published as formal or informal opinions so that the entire legal community can benefit from the bar's interpretive advice. The American Bar Association also writes ethics opinions through its Standing Committee on Ethics and Professional Responsibility, like the opinions of state and local bar associations. The ethics opinion of the ABA are advisory rather than binding. ABA opinions never become binding because, as a voluntary association, there is no court that oversees what the ABA does. If what the ABA says in an opinion becomes binding, it is because a state has adopted parts or all of the ABA opinion. (6-2E) Accusation of unethical conduct. When an attorney is charged with unethical conduct, the case is investigated by a disciplinary body appointed by the state's highest court. The name for this body differs from state to state. Like, for example, the Grievance Commission, the Attorney Registration, and Disciplinary Commission, the Committee on Professional Conduct, or the Board of Professional Responsibility. If the investigation shows that probable cause exists that a violation has occurred, the next step is usually a disciplinary hearing before a commission, committee, or board. This body decides if a violation occurred and, if it did, what punishment should be imposed. The case then goes before the state's highest court, which is free to accept, reject, or modify the conclusion of the disciplinary body. A number of sanctions can be imposed by the court, as you can see from Exhibit 6-3. The sanctions fall into the categories of disbarment, suspension, reprimand, and probation. Some states require attorneys to attend a day of special ethics training, the equivalent of traffic school, as part of the discipline imposed or violating the state's ethical code. Exhibit 6-3. Types of sanctions for attorney unethical conduct discipline. Later in the chapter, we will cover one of the most contentious issues in this area. Can a disbarred or suspended attorney continue working in a law office as a paralegal? As we will see, some states say no. The risk is too great that the disciplined attorney will continue to practice law under the guise of being a paralegal. This was the situation in Chapter 1 in re Bruce D. Friedberg. Other states allow it, but may do so with restrictions such as forbidding the attorney and paralegal from having client contact. 6-2F. Application of attorney codes to paralegals. Thus far, we have been discussing attorney codes of ethics. Can a paralegal be sanctioned for violating these codes? Not directly. With one exception, as noted below, the codes apply to attorneys only, because paralegals cannot join a bar association as full members. They cannot be sanctioned by a bar association. Serious paralegal wrongdoing, however, can lead to severe consequences. The paralegals might be fired by their employer. They might be sued for negligence. They might face criminal prosecution. Their supervising attorney might face ethical charges because of the paralegal's wrongdoing, and etc. Paralegals themselves, however, cannot be punished for unethical conduct by the entity that regulates attorneys. Attorneys can be punished for using their paralegals unethically, but paralegals are not directly regulated by, and hence cannot be punished by, the disciplinary system that governs attorneys. As indicated, there is an exception to the rule that attorney codes apply to attorneys only. Recently, there has been considerable debate over whether the legal profession should allow attorneys and non-legal professionals to form a multidisciplinary practice, MDP. This is a partnership between attorneys and non-attorneys such as accountants, doctors, therapists, economists, scientists, and environmental consultants. The partnership delivers legal and non-legal services. In such a partnership, the non-attorney partner would be governed by the ethical code that governs attorneys. At present, only the District of Columbia allows such partnerships, although many states are studying the possibility of allowing them. These entities would be a major departure from the rule that attorneys must not form a partnership with or share fees with non-attorneys. Critics warn that MDPs will lead to a loss of attorney control over the practice of law. The big fear is that companies such as Walmart and H&R Block will be able to start offering legal services in direct competition with traditional law firms. Proponents argue that MDPs will open up new markets for law firms, particularly in a global economy where large American law firms often compete in countries and authorize MDPs for their own attorneys. If MDPs ever become widespread in the United States, they will probably not have a significant effect on paralegals. The goal of an MDP is to allow a law firm to expand its scope of business by partnering with individuals who have non-legal skills and expertise. There is nothing non-legal about paralegals. They are an intimate part of the attorney's legal team. While it is possible that a state might one day allow an attorney to form an MDP with a paralegal, the likelihood of this happening is remote. 6-3 Paralegal Codes. Now we turn to paralegal codes. These are sets of rules and guidelines devoted exclusively to issues of paralegal ethics. There are two kinds of paralegal codes: those written by attorneys, courts, or legislatures, and those written by paralegals. See Exhibit 6-4 for an overview of these codes. Exhibit 6-4 Overview of Paralegal Codes. Overview of Paralegal Ethics Codes. Paralegal codes by bar associations. Paralegal codes by courts or legislatures. Paralegal codes by national paralegal associations. Paralegal codes by state and local paralegal associations. Paralegal codes by bar associations. 1. ABA guidelines for the utilization of paralegal services. 2. State bar associations. Paralegal codes by national paralegal associations. A. NFPA. B. NALA. C. NALS. Six -3 A. Paralegal codes written by bar associations, courts, and legislatures. The ABA has issued model guidelines for the utilization of paralegal services, like the ABA's model rules and model code. See Exhibit 6-2. The model guidelines are recommendations to the states. The ABA itself does not discipline anyone for violating the model guidelines. Later in this chapter, you will find a discussion of every major guideline or rule contained in the model guidelines. To date, about half the states have their own state paralegal codes or guidelines that are similar to the model guidelines. For your state, see Appendix C. Most were adopted by the state bar associations or by the committee of the bar association that covers paralegals. Some have been formally approved and adopted by the state's highest court. A few have been written by the state legislature. The model guidelines and the state paralegal codes guidelines are primarily directed to attorneys who use paralegals in their practice. Hence, if there are violations by paralegals, it is the supervising attorney who could be subject to sanctions by the state body that enforces attorney ethics. 6-3B Paralegal codes written by paralegals. The three major national associations, NFPA, NALA, and NALS, have also written paralegal codes. See Exhibit 6-4 and Appendix D. As indicated earlier, these codes are not enforced by meaningful sanctions. The associations might terminate a paralegal's membership in the association for ethical improprieties, but this is rarely done. The associations simply do not have the resources or clout to implement a system of enforcement. This does not mean, however, that the paralegal codes are unimportant. Their main value is to reinforce the critical importance of ethics in the practice of law. In addition, some state and local paralegal associations have published their own paralegal codes. For associations in your state, see Appendix D. These codes closely mirror the themes of the codes written by the National Paralegal Associations and, most importantly, the themes that govern attorneys as they pertain to paralegals. 6-4 Ethics Rules Introduction. We turn now to an overview of specific ethical rules that apply to attorneys. The overview is based on the ABA's model, Rules of Professional Conduct. See Exhibit 6-2. The rule numbers used in the discussion, like for example Rule 1.5, refer to the rule numbers of the model rules. In addition, we will occasionally refer to the ABA's Model Code of Professional Responsibility, the earlier version of the model rules. Where appropriate, the discussion will include a paralegal perspective based on attorney codes and the other paralegal codes and guidelines mentioned in Exhibit 6-4. Paralegals are on the front line. One of their primary responsibilities is to help an attorney avoid being charged with unethical conduct. Hence, paralegals must be intimately familiar with ethical rules. Our goal in this chapter is to provide you with that familiarity. One final note before we begin. Most allegations are brought by disgruntled clients who claim to have been harmed by the attorney's alleged unethical behavior. An example would be a client's case that was dismissed because the attorney carelessly forgot to file a pleading in court. We need to emphasize, however, that a person who initiates a charge of unethical conduct does not have to prove they suffered actual harm. Suppose, for example, an attorney represents a client with whom the attorney has a clear conflict of interest. The attorney should never have taken the case. Representing the client in the case is unethical even if the attorney wins the case for the client. Proof of harm is not necessary to establish a violation of the ethical rules, although such harm is usually present. 6-5 Formation of the attorney-client relationship. An attorney-client relationship arises when the attorney and the client expressly agree to form the relationship, or the attorney's conduct would lead a reasonable person to believe that they have agreed to represent the client even in the absence of a formal agreement to do so. When an attorney first meets with a prospective client, one of their first concerns is whether to accept the case. The attorney may reject a case for a number of reasons, such as the attorney's belief that the prospective client does not have a meritorious case, the attorney's current busy caseload does not allow the office to take on the added case, the attorney's belief that the office does not have the kind of expertise required to represent this prospective client, the presence of a conflict of interest, see discussion below, the likelihood that the office would not be able to collect its fees and costs of representation. Once the office decides not to take the case, it should send out a letter of non-engagement to avoid or refute a later claim by a prospective client that the office was going to provide representation. Initial contacts with the office may have involved a meeting and some phone calls without a clear indication of whether the attorney was going to take the case. As time passes, the situation can become ugly if the statute of limitations has run out so that a claim can no longer be asserted. The attorney does not want to be blamed for the fact that the claim is now time barred. Sending a letter of non-engagement helps prove that the attorney never had an ethical or professional duty to act on the case before the claim was barred by the statute of limitations because the attorney never agreed to provide representation. Quick tip. Document. One way to protect yourself and your firm is to memorialize events, meetings, and transactions with clients so that there is a record of what occurred in the event a claim or issue arises later on. This documentation can be in the form of a memorandum to the file, an email to the attorney, or a non-engagement letter. Whatever form it takes, just be sure to document the meeting. The main way in which an attorney-client relationship is formed is by the attorney and client expressly agreeing to form such a relationship. The agreement might be called a retainer agreement, retainer contract, contract of representation, attorney-client fee agreement, or engagement letter that is signed by the attorney and the client. See Chapter 12 for an example of such an agreement. The document covers the scope of services to be provided as well as the payments the clients will be making for those services. The verb is retain. Retainer also refers to the amount of money or other property paid by a client as a deposit or advance against future fees, costs, and expenses of providing services. Yet, a formal agreement is not the only way that an attorney-client relationship can come into existence. It is possible for an attorney to take on a client without intending to do so. The test of whether an attorney-client relationship has been formed is whether a reasonable person would interpret the attorney's conduct as an agreement to provide legal services to a specific person. It does not depend on whether a formal agreement was signed. The test is not whether the attorney wanted or intended to become someone's attorney. The test is how a reasonable person would interpret what the attorney did. In the absence of clear evidence of non-engagement, attorneys can find themselves in an unwanted and unintended attorney-client relationship. Example: Peter Kim, Esquire, meets Zoe Patterson for the first time at a party. When Zoe finds out that Peter is an attorney, she tells him that she thinks that her boss is trying to fire her because she has rebuffed his romantic overtures to her. Peter tells her that she could write down everything that the boss has said and done since he began acting inappropriately. He also answers her questions about her employment rights. During the conversation, Peter is called away, but before he leaves the party, he gives Zoe his card. Nothing else is said. Is Peter Zoe's attorney? Has an attorney-client relationship been formed? The question is critical because if such a relationship exists, Peter has ethical duties pertaining to confidentiality and conflict of interest. He must treat what Zoe told him as confidential, and he would not be allowed to represent Zoe's boss, even if she later hires someone else to represent her in the sexual harassment case. Did Peter become Zoe's attorney at the party? He gave her legal advice along with his business card after she gave him details about her legal problem. On the other hand, they never signed an agreement or discussed fees. As indicated, however, a formal agreement and fees are not essential to forming an attorney-client relationship. As of the time of the party, if a reasonable person in Zoe's position would believe that Peter agreed to provide legal services, then the attorney-client relationship exists. It can always be ended. See the discussion of withdrawal below. But once it is formed, serious consequences can result if the attorney does not act properly before it is ended. The consequences can include the duty to keep confidential what the prospective client said and to refrain from representing the opponent of the prospective client. The danger of creating an unintended attorney-client relationship is particularly acute on attorney websites. When you go to the website of cautious attorneys, you will often see a statement to visitors that no attorney-client relationship is created simply by reason of the fact that the site is visited or that an email query is sent to the attorney through a link on the site. Before allowing a visitor to send an email question, the attorney may make visitors click yes to the question. Do you understand that the receipt of your email does not in and of itself create an attorney-client relationship between us? We will have more to say about the ethical use of websites later in the chapter. Here is what the American Bar Association says about websites and the attorney-client relationship. Websites have become a common means by which lawyers communicate with the public. Lawyers must not include misleading information on websites, must be mindful of the expectations created by the website, and must carefully manage inquiries invited through the website. Websites that invite inquiries may create a prospective client-lawyer relationship. Model Rule 1.18. Paralegal perspective. Some paralegals work in high-volume law offices that handle a large caseload. Examples might be offices with specialties in workers' compensation or fender-bender negligence cases. Paralegals who are asked to screen the many callers who contact an office about their legal problems must never tell a caller that they will be accepted as a client, even if the caller fits the criteria established by the office for the kind of cases it accepts. The most that the paralegal can do is to arrange for the caller to talk with an attorney in the office. Accepting cases is an attorney-only task. An attorney may not delegate to a paralegal responsibility for establishing attorney-client relationships. Analyze this. Joe and Micah are heading for a possible divorce. Joe hears Micah is interviewing divorce lawyers around the city. Joe wants to make sure that Micah does not hire certain attorneys, so she makes appointments to see 3 potential lawyers to determine if she will hire them. Was an attorney-client relationship created by meeting with each attorney? Check out the movie Something to Talk About for a similar issue. 6-6 Limited Scope Representation. An attorney can provide limited scope representation so long as the client clearly understands the limited nature of the services. Model Rule 1.2c. Most states allow attorneys to practice collaborative law so long as the clients clearly understand that the collaborative law attorneys do not provide litigation services. The attorney agreement with the client to withdraw from the case if litigation becomes necessary does not compromise the attorney's duty to give vigorous representation to their own client. Most attorney services consist of a mix or bundle of tasks. For example, in a divorce, the bundle might consist of legal advice on the grounds for divorce, investigation of marital assets, document preparation, document review, document filing, legal research, negotiation, and court representation. Collectively, these tasks are called bundled legal services. 6-6A Unbundled Legal Services. Suppose that a client does not want the full range of attorney services. The client might be representing themselves pro se, but would like the attorney to perform specific tasks such as reviewing a separation agreement the client has prepared from a sample form found online. The client is seeking what is called discrete task representation or limited scope representation. Attorneys who agree to such representation are providing unbundled legal services. Charging for such services is called task-based billing, unit billing, or project billing. The main ethical danger in providing unbundled legal services is that the client does not have a clear understanding of the limited nature of the representation. Model Rule 1.2. A nightmare example is an attorney who agrees to review a document prepared by a pro se client who believes wrongly that the attorney will also file a court claim based on that document. The client then loses the claim by default when it is not filed before the statute of limitations expires. Attorneys have an ethical obligation to take all reasonable steps to avoid such misunderstandings in unbundled cases. In some states, all documents filed in court that were prepared by an attorney must state the attorney's name on the document. In such states, a client who hires an attorney for the limited purpose of drafting a complaint, for example, cannot allow the court to believe that the client drafted it. Ghostwriting is not allowed in such states. 6-6B, Collaborative Law. Collaborative law is an example of limited scope representation in family law cases. Attorneys practicing collaborative law refuse to continue representing the parties if they cannot settle their dispute through mediation or other method of alternative dispute resolution, ADR. The representation is limited because the attorneys refuse to litigate. Each party hires their own attorney who practices collaborative law. A four-way agreement is then reached in which the two parties and their attorneys consent to the limited role of the attorneys. To encourage settlement, the agreement provides that the attorneys will refuse to continue representing the parties if litigation becomes necessary because ADR has failed to resolve the disputes. The parties must find other attorneys if the case goes to trial. The collaborative law attorneys, therefore, do not have a financial incentive to drag the dispute into litigation in order to increase their hourly fees. When collaborative law is successful, the role of the court is limited to reviewing the agreements reached by the parties. Courts often approve such agreements. Most states say that practicing collaborative law is ethical so long as clients give informed consent. To the restriction on litigation in a collaborative law practice, there is a danger that a client who hires a collaborative law attorney will not understand the litigation restriction and may not realize that they can hire other attorneys who are not subject to this restriction. The most troublesome ethical question is whether the four-way agreement not to be litigation attorneys places an attorney under a contractual commitment to an opposing party. This was the concern of one of the few bar associations. To take the position that practicing collaborative law is unethical. Most state bars and the American Bar Association disagree. It is true that it is unethical for an attorney to represent a party if the representation will be materially limited by the attorney's responsibilities to a third person. Rule 1.7b. In this instance, the third person is the opposing party to whom the attorney has made a contractual commitment to cease providing services to the attorney's own client if ADR collapses and litigation becomes necessary. If, however, a client gives informed consent to the arrangement, the ethical objection is eliminated. The contractual agreement to withdraw from the case places no limits on the attorney's duty to provide competent and vigorous representation before the time litigation becomes necessary. This is the view of most bar associations. They also do not believe that the agreement to withdraw interferes with the attorney's independent judgment regarding whether litigation is needed. 6-7 Competence. An attorney shall provide competent representation to a client. Competence consists of the knowledge, skill, thoroughness, and preparation reasonably necessary to assist a particular client. Model Rule 1.1. A competent attorney is one who uses the knowledge, skill, thoroughness, and preparation that are reasonably necessary to represent a particular client. What is reasonably necessary depends on the complexity of the case. A great deal of knowledge, skill, thoroughness, and preparation, for example, will be needed when representing a corporate client accused of complicated antitrust violations. Competence does not mean winning every case. The standard is reasonableness in acquiring and using the knowledge and skill needed to represent a particular client. How do attorneys obtain the knowledge and skill needed for particular cases? They take the time needed to prepare themselves. They use the general principles of legal analysis learned in law school. They do legal research as needed for the matter. When needed, they formally associate themselves with more experienced attorneys in the area. Attorneys who fail to take these steps are acting unethically if their failure means that they do not provide the knowledge, skill, thoroughness, and preparation reasonably necessary to represent a particular client. Some attorneys have so many clients that they could not possibly give proper attention to each. Always looking for more lucrative work, they run the risk of neglecting the clients they already have. As a consequence, they might miss court dates or other filing deadlines, lose documents, fail to determine what law governs a client's case, etc. Example: Enrique Henderson Esquire has a large criminal law practice. Enrique agrees to probate the estate of a client's deceased son. Enrique has never had a probate client before and does not investigate how probate cases should be handled. 5 years go by, no progress is made in determining who is entitled to receive the estate. If some minimal legal research had been done, Henderson would have been able to close the case within 6 months of taking it. Henderson has acted unethically. The failure to do basic research on a case is a sign of incompetence. The need for such research is clear in view of the fact they have never handled a probate case. Either they must take the time to find out how to probate the estate, or they must contact another attorney with probate experience and arrange to work with this attorney on the case. Doing neither is unethical. The vast majority of graduates of law schools need considerable on-the-job study and guidance before they are ready to handle cases of any complexity. Traditional law school courses give new attorneys a good theoretical understanding of the law. This is different from the practical knowledge and skill needed to work on real cases. Many law schools have clinical education programs in which students receive credit for working on actual cases under the supervision of attorneys. For example, the school might operate its own tax clinic for senior citizens or might assign students to work several hours a week on cases of indigent clients at a local legal aid office. Although these clinical programs provide practical experience, they are not a major part of the law school curriculum of every law school. Most new attorneys, including those with clinical experience, therefore, are quite nervous when they face their first client on their first paid job. The nervousness is based on the fact that they are acutely aware of how much they don't know. This doesn't necessarily mean they are incompetent to practice law. It simply means they must take the time to prepare themselves and to draw on the assistance of others when needed. Quick tip: preparation. Always prepare, read, research, and review. Competence is gaining confidence. Competence is gaining confidence by being prepared. Do the work. Continuing legal education, CLE, is another vehicle used by attorneys to achieve competence. Most states require attorneys to participate in a designated number of hours of CLE per year as a condition of maintaining their license to practice law. This requirement is called MCLE, Mandatory Continuing Legal Education. CLE sessions are designed to help practicing attorneys stay current in their areas of practice. The sessions are often conducted by a CLE institute affiliated with the Bar Association. Throughout the year, and particularly during bar conventions, attorneys have the opportunity to attend relatively short CLE sessions, like, for example, an afternoon. CLE online is another option. If an attorney is incompetent, they can be sanctioned for being unethical. In addition, the incompetence may have other consequences. The client might try to sue the attorney for the tort of negligence in a legal malpractice case. Such suits were discussed in Chapter 4. If the client is a criminal defendant who was convicted, they may try to appeal the conviction on the grounds that the attorney's incompetence amounted to a denial of the effective assistance of counsel guaranteed by the Sixth Amendment of the United States Constitution. Paralegal perspective. An attorney has an ethical obligation to recruit paralegals who are competent because of their prior education and whatever additional training and supervision the office will provide to perform the task they will be assigned. Of course, paralegals have an ethical obligation to take steps to maintain and increase their own competence. Some of these steps are listed below. If you are given assignments that are beyond your knowledge and skill, let your supervisor know. Either you must be given training with sufficient supervision, or you must be given other assignments. A lawyer should explain to the paralegal that the paralegal has a duty to inform the lawyer of any assignment which the assistant regards as beyond his capability. Be wary of the attorneys who have so much confidence in your competence that they use your work product with little or no checking for accuracy. This is extremely dangerous, particularly for paralegals who work for busy attorneys. The danger is that you will make a mistake that will not be caught until damage is done to the client, no matter how much experience you develop in an area of the law. Unique legal issues often arise unless someone is reviewing your work. How will you know whether you have missed one of these issues? Your ego will appreciate the confidence your supervisor expresses in you by delegating so much responsibility. But your competence is not a substitute for supervision. A paralegal is engaged in the unauthorized practice of law, UPL, when performing legal tasks without adequate supervision, even if the task is performed correctly, and even if the attorney asked the paralegal to perform the task. Try to turn assignments into ongoing learning experiences. After a new assignment has been completed, ask your supervisor how it can be improved. The next time. You may have to wait until a busy supervisor has time to respond, but don't wait until the year-end evaluation. Every day presents opportunities to increase your competence. If you make it a part of your agenda to look for and take those opportunities, your growth as a paralegal will depend on it, and you will be contributing to the ethical mandate of the office to be competent. Find out which attorneys, administrators, paralegals, and secretaries in the office have a reputation for explaining things well. Try to spend time with such individuals, even if you do not work with them on a daily basis. Take them to lunch. Find time to sit with them on a coffee break. Ask lots of questions. Let them know you respect high-quality work and appreciate anything they can tell you to help you increase your competence. Invest in CLE. Even if you must pay for it yourself, find the time to attend CLE sessions. Because the law often changes, you need to use resources like CLE to keep current. Take the initiative in continuing your training after your formal education is over. Do not wait for someone to suggest further training. Attend CLE sessions designed for paralegals. In addition, consider attending CLE sessions for attorneys in the areas of law that are relevant to your work assignments. CLE is often conducted on a weekday afternoon, on a Saturday, or online. Here are ways to find out what CLE opportunities are available in your area. Go to the websites of paralegal associations in your area. See Appendix A. If CLE is not listed on the homepage of an association, type CLE or Continuing Legal Education in its search box, or send an email to the association inquiring about CLE. Go to the website of the bar associations in your area. See Appendix A. If CLE is not listed on the homepage of an association, type CLE or Continuing Legal Education in its search box. In some states, paralegal CLE is not optional. As we saw in Chapter 4, for example, paralegals and legal document assistants, LDAs, must meet mandatory CLE requirements in California. Also, paralegals who have passed the certification exams of paralegal associations have CLE obligations that must be met in order to maintain their certification status. See Chapter 4. Review the section in Chapter 4 on malpractice insurance. No matter how competent you are, you could be a defendant in a negligence suit brought against a law firm by a disgruntled client. Find out if the firm has a malpractice policy and whether it covers paralegal employees. Quick tip: some organizations offer membership with free CLE. Check your paralegal associations, bar associations, nonprofits, and national government organizations, such as the National Association of Attorney General, NAAG. 6-7A, Digital Competence. At one time, a law office looked with amusement at the older attorneys who refused to join the computer bandwagon in the practice of law. No more, indeed, all attorneys, young or old, can be disciplined for failing to keep abreast of the benefits and risks associated with relevant technology. Model Rule 1.3, Comment 6. Attorneys must know how to back up files, perform computerized legal research, install and update virus and malware protection, avoid violating confidentiality when using computer devices in public, safeguard confidentiality in the cloud, create effective passwords, remove scrub metadata discussed later in the chapter, conduct e-discovery, avoid spoliation of digital evidence discussed later in the chapter, other technology innovations as required by their practice. Paralegal perspective. There are many steps you can take on your own to increase your own digital competence. See Chapter 11. In addition, there is a core computer assignment at the end of every chapter in this book, which you should do whether or not they are required for the course. In particular, start and regularly update the computer terminology in the law CTL notebook described in Chapter 1. 6-8, Diligence, or delay. Attorneys must act with reasonable diligence and promptness, avoiding unwarranted delay in representing a client. Model Rule 1.3. Reasonable efforts must be taken to expedite litigation. Model Rule 3.2. Perhaps no professional shortcoming is more widely resented than procrastination. Model Rule 1.3, Comment 3. Angry clients often complain that attorneys take forever to complete a case and keep clients in the dark about what is happening. The attorney never answers my calls. It took months to file the case in court. They keep telling me that everything is fine, but nothing ever gets done. Such complaints do not necessarily indicate unethical behavior by the attorney. Events may be beyond the control of the attorney. For example, the court calendar is crowded or the other side is not responding. Yet, this does not excuse a lack of regular communication with clients to keep them reasonably informed about the status of their case. Other explanations for a lack of diligence and promptness, however, are more serious. The attorney is disorganized. The office has not developed adequate systems to process cases. The delays are due to careless mistakes and a lack of skill. The attorney is taking many more cases than the office can handle. Additional personnel should be hired to do the needed work, or new cases should not be accepted. The office fails to designate backup attorneys to handle ongoing cases of attorneys who are away on vacation or are otherwise unavailable because of pressing work on other cases. Often, the failure to use reasonable diligence and promptness causes harm to the client. For example, the attorney neglects to file a suit before the statute of limitations has run, and the client loses the case by default. Unreasonable procrastination, however, can be unethical if such harm does not result. Another problem is the attorney who intentionally causes numerous delays in an effort to wear the other side down. It is unethical to engage in such dilatory practices. Attorneys must use reasonable efforts to expedite litigation consistent with protecting the interests of their clients. Paralegal perspective. An overloaded attorney probably works with an overloaded paralegal. Successful paralegals often take the initiative by asking for additional work, but reason must prevail. If you have more work than you can handle, you must let your supervisor know. Otherwise, you might find yourself contributing to the ethical problem of undue delay. Learn everything you can about the office systems, particularly for tasks that the office performs on a regular basis. Find out how systems are created. After you have gained experience in the office, start thinking about designing systems on your own initiative. For example, one component of a system that can be created with relative ease is a folder containing frequently used documents in a divorce or other kind of case the office often handles. The documents in the folder become a source of model documents that can be adapted for future cases. Effective office systems of this kind can reduce the risk of unethical delays in client representation. When a busy attorney is in court or cannot be disturbed because of urgent work on another case, someone in the office should be available to communicate with clients who want to know the status of their case. In many offices, the paralegal is in a position to provide this information. The role can be delicate because of two dangers: giving legal advice and creating unreasonable expectations. In addition to asking about the status of their case, clients often ask questions that call for legal advice. Giving such advice may constitute the unauthorized practice of law, UPL. Later, we will examine in greater depth the temptations and pressures on a paralegal to give legal advice. Also, clients may want to know if they are going to win their cases. Careless language, like for example, "You have an excellent case," might later give rise to a breach of contract suit in which a client argues that the office guaranteed a particular result in the representation. All that can be said to the client is that the office is doing the best it can to achieve the client's objectives. 6-9 Fees. Fees for legal services must be reasonable. Factors that determine the reasonableness of a fee include time and labor, complexity, novelty, amount involved, results, experience, and reputation, what is customary, and whether other business had to be given up. Model Rule 1.5a. 6-9a. What is a reasonable fee? A reasonable fee is a fee that is not excessive. There is no absolute standard to determine when a fee is excessive and therefore unreasonable. A number of factors must be considered: the time and labor involved, the complexity of the case, the novelty of the issues in the case, the amount of money or other properties involved, the result achieved by the attorney, the experience and reputation of the attorney, the customary fee in the locality for the same kind of case, whether the attorney had to give up other business in order to take the case, etc. In one case, a court ruled that $500 an hour was excessive in a simple battery case in which there was no trial. The accused pled guilty, and there were no unusual issues to be resolved. In another case, a court concluded that a fee of $22,500 was excessive in an uncomplicated real estate case involving very little attorney time. The case was settled through the efforts of someone other than the attorney. A fee is not necessarily excessive simply because it is large. Cases exist in which courts have approved fees of hundreds of millions of dollars. An example is the tobacco litigation of the 1990s, in which attorneys brought suits that resulted in multi-billion-dollar settlements and judgments. Prior to this time, the tobacco industry had remarkable success in winning personal injury suits brought by sick smokers and by the estates of deceased smokers. In assessing the reasonableness of a fee, a court will consider the initial odds against winning and the uniqueness of the issues raised in the litigation. By these standards, the attorneys who won the case against the tobacco industry were entitled to very high fees. When the litigation began, few thought the plaintiff attorneys had much chance of winning anything, let alone winning billions. Later in the chapter, we will discuss the infamous role of a paralegal, Merrill Williams, in the tobacco litigation. The 6-9B Fee Agreement. 6-9B Fee Agreement. Most states require contingent fee agreements to be in writing. Most states recommend but do not require other fee agreements, like, for example, hourly fee agreements, to be in writing. Model Rule 1.5a. The basis of the fee should be communicated to the client before or soon after the attorney starts to work on the case. This is often done in the agreement hiring the attorney. For an example of such an agreement, see Chapter 12. Kinds of fees are also discussed in greater detail in Chapter 5. In most states, contingent fee agreements must be in writing. This is a fee that is paid only if the case is successfully resolved by litigation or settlement, regardless of the number of hours spent on the case. States differ on whether non-contingency fee cases must be in writing. In most states, written agreements are recommended but not required. Oral agreements are acceptable as long as the basis of the fee is adequately explained to the client and nothing misleading is said about fees and related expenses. We will have more to say about contingent fees and misleading statements later in the chapter. 6-9C Expenses. In addition to paying fees for an attorney's time, clients can also be charged for out-of-pocket expenses incurred by the office in the representation. Examples of expenses include court costs, witness fees, and long-distance travel. Clients must not be misled about their payment. If an attorney tells clients that they pay nothing if they don't win, it must make clear whether such statements refer to attorney fees only. If clients must pay an attorney's out-of-pocket expenses, even if the case is lost, the clients must be made aware of this at the outset of the attorney-client relationship. 6-9D, Passing on savings to clients. An ethics opinion of the American Bar Association addresses the issue of excessive fees through the following 3 fact situations. Case 1. John Smith, Esquire, who bills by the hour, has 2 clients who happen to have separate cases in the same court on May 9th, each requiring relatively minor attention from the attorney. If the attorney had gone to court on 2 separate days, each client could have been billed for 3 hours. On May 9th, however, Smith was able to handle both cases. Smith spent a total of 3 hours in court. Can they bill each client 3 hours for the time spent on May 9th, since they would have been able to do so if they went on separate days? Answer: no. Smith did not earn 6 billable hours on May 9th. Billing more than one client for the same time is unreasonable. Savings resulting from scheduling must be passed on to clients. Case 2. Mary Jones, Esquire, who bills by the hour, charges a client 5 hours in transportation time to travel by airplane to a meeting with the client in another city. While on the plane, Mary skips the in-flight movie in order to spend 2 hours drafting a motion for a different client on another case. Can they bill the first client 5 hours and the second client 2 hours to cover the total of 5 hours on the plane? Answer: no. Jones has not earned 7 billable hours. Billing more than one client for the same time is unreasonable. Savings resulting from being able to do 2 things simultaneously, traveling and drafting a motion for different clients, must be passed on to clients. Case 3. George Harris, Esquire, who bills by the hour, bills a client for 10 hours to research a problem and draft a memorandum of law covering the issues in the case. Several days later, Harris uses the same memorandum on a different case for another client who happens to have the same legal problem as the earlier client. Can they bill the second client 10 hours for the memorandum? Answer: no. Harris has not earned 20 billable hours. Billing more than one client for the same work product, a research memorandum, is unreasonable. Savings resulting from being able to reuse a work product must be passed on to clients. If Harris needed time to adapt the memo to the needs of the second client, they could charge for this time. When billing this client, however, they cannot assume that the prior memo did not exist. Analyze this. Your firm handles divorce cases and has standard documents it prepares. You are told to always bill 5 hours for the preparation of the initial divorce filing, regardless of the time it took you to prepare the documents. What is your response? Is that proper? 6-9E, Minimum fees. At one time, bar associations published a list of minimum fees that attorneys should charge for specified legal services. A fee below the minimum was considered unethical. In Goldfarb v. Virginia State Bar, 421 U.S. 773, 1975, The U.S. Supreme Court ruled that such minimum fee schedules are prohibited. These schedules operated as a fixed, rigid price floor and therefore constituted illegal price fixing in violation of antitrust law. 6-9F Maximum fees, fee caps. Attorneys cannot be required to charge minimum fees, but they can be subject to maximum fees. Some states have passed statutes that impose fee caps on certain kinds of cases. A fee cap is the maximum amount or maximum percentage that can be charged as a fee in a case. For example, a state may say that in a medical malpractice case, fees cannot exceed 20% of what is recovered. Online exercises. Determine whether your state has fee caps on medical malpractice claims, and if so, what are those caps? 6-9G Contingent fees. Contingent fees are proper in most cases if the client clearly understands when they are responsible for paying attorney's fees and related expenses of litigation. Contingent fees are not allowed in criminal cases. Contingent fees are not allowed in family law cases if the fee is dependent on securing a divorce, on the amount of alimony or support, or the amount of property settlement that is awarded in place of, in lieu of alimony or support. Model Rules 1.5c and D. As indicated earlier, most states require contingent fee agreements, those dependent on the outcome of the case, to be in writing. The benefit of a contingent fee is that it provides an incentive for an attorney to take the case of a client who does not have funds to pay hourly fees while the case is pending. Example, an attorney agrees to represent a client in an automobile negligence case. If the jury awards the client damages, the attorney will receive 30% of the award. If the client loses the case, the attorney receives no fee. Similarly, if the case is settled in the client's favor, the attorney receives 30% of the settlement, but no fee if the client obtains nothing through litigation or settlement. This is a contingent fee because it is dependent on the successful outcome of the negligence case. In the automobile negligence example, assume that the attorney incurs $5,000 in expenses for filing fees, travel costs, and witness fees. The fee agreement must clearly state who is responsible for these expenses. Does the client pay these expenses whether or not the attorney wins the case in court or by settlement? If the client must pay these expenses, and if the attorney wins the case, are the expenses to be paid in addition to the attorney's fee, or must the attorney deduct the expenses from their fee? Contingent fees cannot be used in every kind of case. They are not allowed in criminal cases and in some family law cases. Example, Gabe Farrell is a client of Sam Grandon Esquire in a criminal case. Gabe is charged with murder. Gabe agrees to pay Grandon $100,000 if they are found innocent. Grandon will receive nothing if Gabe is convicted of any crime. This fee agreement is unethical. Contingent fees are not allowed in criminal cases. Note the pressures on Grandon. He arguably has no incentive to try to negotiate a guilty plea to a lesser charge, like for example, manslaughter, because such a plea would mean a conviction and hence no fee. In such a situation, the attorney's own personal interest obtaining the $100,000 could conflict with the interest of the client receiving a lesser penalty through a negotiated plea. The fee, therefore, is unethical if the amount of the contingent fee is otherwise reasonable and is agreed to by the client. Similar inappropriate fee pressures can arise in family law cases. Example, Tom Edgars hires an attorney to obtain a divorce. The fee is $25,000 if the divorce is granted. but no fee if it is not granted. As the case develops, suppose a glimmer of hope arises that the husband and wife might reconcile. Here again, the attorney's interest obtaining the $25,000 could conflict with the interest of the client reconciling. This might lead the attorney to discourage the reconciliation or to set up roadblocks to it. Reconciliation removes the possibility of the contingency, obtaining the divorce from occurring. In family law cases, therefore, the following fees would be unethical. The attorney will receive a designated fee if the divorce is granted. The attorney will receive a designated fee if the court issues an alimony or support order above a specified dollar amount per month. The attorney will receive a designated fee if the court issues a property division or settlement order that is in place of in lieu of an alimony or support order. These fees are unethical if the amount of the contingent fee is otherwise reasonable and is agreed to by the client. Some states have limited expectations to rule on contingent fees in family law cases. For example, a state might forbid a contingent fee when a client is seeking future support, but allow it if the client is seeking to collect a support judgment that has already been rendered. If a judgment already exists, the attorney's interest in collecting the contingent fee is less likely to interfere with the continuation or reconciliation of family relationships. Online exercise. Research whether your state has limitations on the types of cases that can qualify as a contingent fee case. List the types of cases that are excluded. 6-9H. Fee splitting among attorneys. Attorneys who are not in the same law office can share a fee. If the client agrees to the arrangement, the total fee is reasonable and either A, both attorneys do actual work on the case and the fee is split in proportion to the work each does on the case, or B, if attorney number 1 does all the work, attorney 2 agrees to be legally responsible along with attorney number 1 in the event of malpractice or ethical violations by attorney number 1. Model Rule 1.5e. Attorneys in the same firm share fees all the time. This rarely raises ethical problems. Suppose, however, that attorneys in different firms share a fee. This is an example of fee splitting, the division or splitting of a single client's fee between two or more attorneys who are not in the same firm. To explore the ethics of fee splitting, compare the following two situations. Example, Case A, attorney number 1 finds a client and refers the client to attorney 2 in a different law firm. Attorney number 1 does no work on the case. Attorney number 2 pays attorney number 1 a forwarding fee. Example, Case B, attorney number 1 finds a client and asks attorney number 2 in a different law firm to assist attorney number 1 in representing the client. Both attorneys work on the case and the fee that each receives is in proportion to the work they do on the case. The arrangement in Case A is unethical in most states. Attorneys in different law firms cannot share a fee if one of the attorneys does not work. Attorneys in different law firms cannot share a fee if one of the attorneys does no work on the case unless this attorney agrees to be legally responsible along with the other attorney in the event that the latter commits malpractice or an ethical violation. The splitting of fees in Case B is ethical because both attorneys do actual work on the case. Other requirements for fee splitting are that the total fee paid by the client is reasonable and the client agrees in writing to the fee splitting arrangement. Under the paralegal perspective below, we will cover the related ethical problem of an attorney splitting a fee with a paralegal or other non-attorney. 6-9I. Non-payment of fees and the client files. The failure of a client to pay attorney's fees is not a valid reason for the attorney to demand payment as a condition of releasing the file to the client. A client's file belongs to the client. Upon request, the attorney must return the file to the client even if fees are outstanding. Important example, i.e. unpaid. When a client has a serious dispute with an attorney over a fee, the client will sometimes dismiss the attorney and ask for a return of the client's file, which may contain many documents such as correspondence, complaints, other pleadings, exhibits, and reports of experts. This file is the property of the client, and in most states, the file must be surrendered by the attorney when the client requests it, even if there are unpaid bills for fees and expenses. If the attorney has a claim for payment, the remedy is to sue the client for breach of contract. It is unethical for the attorney to hold the file hostage to ensure payment. The attorney can copy the file before turning it over, but at the attorney's own expense. For more on an attorney's client file responsibilities at the close of the case, see Chapter 5. Paralegal perspective. Fee splitting with non-attorneys. Attorneys must not split fees with non-attorneys. Example, Frank Martin is a freelance investigator. Frank refers accident victims to a law firm. For every client they refer to the firm, they receive 25% of the fee collected by the firm. Example, Helen Gregson is a chiropractor. Helen refers medical malpractice cases to a law firm, which gives them $500 for each referral, who becomes a client. These are improper divisions of fees with non-attorneys. Even if the amount of the division is reasonable, and even if a client brought in by Martin or Gregson gives written consent to their receiving a part of the fee, an attorney cannot share with a non-attorney a portion of a fee paid by a particular client. The rationale behind this prohibition is that the non-attorney might exercise some pressure or control over the attorney in order to protect their share of the fee and thereby jeopardize the attorney's independent judgment. Paralegal salaries. The salaries of most paralegals are paid out of the fees earned by the office. This does not constitute the unethical sharing of fees with non-attorneys, so long as there is no advance agreement to pay a paralegal all or part of particular legal fees. Retirement plan bonus. Suppose that a paralegal is eligible to become part of the firm's retirement plan, which has a profit-sharing component, or suppose that the firm has a bonus plan for its paralegals. In most states, the same rule applies. Retirement plans and bonuses are ethical so long as there is no sharing or splitting of the particular client's fees. There is a major difference between a law firm agreeing to pay a paralegal 10% of whatever fees are collected in the Davis v. Kelly automobile negligence case, on which the paralegal has done good work, unethical in all states, and a law firm giving this paralegal a bonus because the firm appreciates the paralegal's good work on all of the negligence cases, including Davis v. Kelly, that resulted in high fees during the year, ethical in most states. Partnerships and corporations. An attorney cannot form a partnership with a non-attorney if any of the activities of the partnership consist of the practice of law. If the office practices law as a corporation, the attorney cannot own a shareholder interest or be a director or officer. Professional corporations, PCs, are discussed in Chapter 5. As we saw earlier, however, if a state allowed the formation of a multidisciplinary practice, MDP, Non-attorneys would be allowed to become partners of the firm and thereby share fees. Setting fees, accepting or rejecting a case. Paralegals occasionally speak with the prospective clients before an attorney does. When this occurs, paralegals must not set fees or say anything that could be interpreted as accepting or rejecting a case. These are attorney-only functions. Is a paralegal allowed to tell a prospective client what the standard fee of the office is? Probably, because this would be considered communicating information about fees rather than setting them. Cautious offices, however, instruct their paralegals to avoid any mention of fees except perhaps to state whether there is or is not a fee or an initial consultation. Paralegal fees. Attorneys may charge for paralegal work on client cases, referred to a paralegal fee. This is the fee that an attorney can collect for substantive, non-clerical legal work of the attorney. Of the attorney's paralegal on a client case. Paralegals record their time on timesheets that eventually become the basis of the bills sent to clients. The amount that an attorney bills for paralegal time must be reasonable, as determined by factors such as the experience of the paralegal, the nature of the tasks the paralegal undertakes, and the market rate for paralegals in the area. The attorney-client fee agreements should state the amount a client will be charged for a paralegal's time. See Chapter 12. Non-clerical tasks. When a client agrees to pay paralegal fees, the fees must be for the performance of paralegal tasks. It is unethical to seek paralegal fees for time the paralegal spent performing clerical duties, such as photocopying. A paralegal is allowed to perform such duties, but the office cannot seek paralegal fees from clients for doing so. The costs of secretarial or clerical tasks, rent, utilities, and the like are part of overhead for which clients are not separately charged. In some states, however, a client can agree to make separate payments for secretarial or clerical services, but this is not the norm, and such services should not be called paralegal services. Analyze this. A paralegal copies hundreds of files for a trademark case. Would that be considered part of a client's fee? If not, how could the law firm recoup its costs for copying the documents? Statutory fee cases, as discussed previously in Chapter 1, in the vast majority of cases, each side pays its own attorney fees and costs. This is the American rule. In special statutory fee cases, however, the losing side can be forced to pay attorney fees, including paralegal fees, of the winning party in litigation. Such fee-shifting cases follow the English rule. When attorney and paralegal fees are awarded in statutory fee cases, the fees must be reasonable and cannot cover clerical tasks. As we saw in Chapter 1, some states ask attorneys to submit an affidavit to support the amount claimed for the paralegal's time. The affidavit must give a detailed statement of the time and services rendered by the paralegal, a summary of the paralegal's qualifications, etc. Contemporaneous time records. The preference, although not a requirement, is that time records should be contemporaneous. That is, made at approximately the same time as the events being recorded. Try to avoid entering or recording time long after performing tasks that require time records. Block billing. Law firms should avoid block billing for attorney and paralegal time. Block billing consists of grouping multiple tasks under a single time charge. rather than describing each task separately and assigning the actual time associated with each task. Billing records should provide the actual time spent on individually described tasks. Example, block billing, 19.6 hours, discovery. Itemized billing, 7.2 hours, responding to interrogatories, 3.0 hours, preparing a privilege log, 8.4 hours, indexing deposition of defendant, total 19.6 hours. Double billing. Attorneys and paralegals must avoid double billing. It is fraudulent to charge a client twice for the same service. Example, Charles is a litigation paralegal in a law firm. One of their tasks is to digest, i.e., important example, summarize a deposition. The firm bills the client 20 hours for this task at the paralegal's rate, $100 per hour. The firm also bills the client 10 hours of attorney Bedford's time for digesting the same deposition at the attorney's rate, $250 per hour. The client is being double billed, a grossly unethical practice. It would be proper for an attorney to charge a client for time spent supervising a paralegal's work, but not for performing the work the paralegal performed if the paralegal's time is charged separately under the attorney-client fee agreement. Padding. Do not pad your timesheets. Padding is also fraudulent. It occurs when you add hours to your timesheet that were not in fact spent on the client's case. Time padding, or when you bill for added tasks that were not performed, task padding. Example, it takes Charles, a litigation paralegal, 12 hours to digest a deposition. The timesheets, however, say Charles spent 20 hours on the task. Padding is a serious problem in the practice of law. Doing unnecessary work to drive up a client's bill is called churning. In 2013, the front page of the New York Times told the story of an attorney's email exhorting another attorney in the firm to churn that bill baby. Unfortunately, paralegals can find themselves under a similar pressure, which of course must be resisted. In many offices, a paralegal's job security depends on the number of billable hours they accumulate. Even if the office does not impose a billable hours quota, the number of hours billed is closely watched in order to determine how profitable paralegals are to the office. They should not encourage anyone to engage in double billing and padding. One of the most common temptations that can corrupt a paralegal's ethics is to inflate billable hours, since there is often immense pressure in law firms to bill high hours for job security and upward mobility. Such creative billing is not humorous. It's both morally wrong and illegal. It's also fraudulent and a plain and simple case of theft. Paralegals claim that questionable billing is among the most common unethical practice attorneys ask them to perform. In some offices, paralegals have been ordered to double bill and bill for time they did not spend working. When you are employed as a paralegal, you may face such pressure if you work in an office where income is generated through hourly fees. The office wants high billing to increase its income. The paralegal wants high billings to demonstrate to the office that they are financially valuable to the office. Fortunately, most paralegals do not submit fraudulent timesheets and billings, but the pressure to do so is real. Summary on fees. Attorneys must not split fees with non-attorneys. Paralegal salaries, pension benefits, and bonuses can be paid out of the fees generated by the firm so long as these payments are not tied to the fees of particular clients. An attorney cannot form a partnership with a non-attorney or allow a non-attorney to be a shareholder, director, or officer of a corporation engaged in the practice of law. A paralegal cannot set fees, accept cases, or reject cases for an attorney. Attorneys can charge paralegal fees for the substantive non-clerical work that paralegals perform on their cases. Preferably, time records should be contemporaneous. Avoid double billing, time padding, and task padding. As a summary of the fee, competence, and unauthorized practice of law issues, Disciplinary Counsel v. Willard, 123, Ohio State, 3D 15913 Northeast 3D 960 Ohio 2009, checks many of the boxes. Order of the court, a case study. Disciplinary Counsel v. Willard, Supreme Court of Ohio, 123 Ohio Street, 3D 15913 Northeast 3D 960 Ohio 2009. Disciplinary Counsel v. Willard presents a number of ethical issues that were addressed in this chapter. John Willard was an Ohio attorney who partnered with a non-lawyer organization to represent clients in foreclosure actions where he did little or no preparation or communication. He was approached by foreclosure alternatives to represent people whose homes were in foreclosure. They would pay him $150 to prepare limited court filings and foreclosure alternatives would negotiate directly with the lenders to attempt to reach some resolution in the foreclosure. The clients would blindly sign documents giving Willard authority to act on their behalf. Willard handled at least 28 cases. Unfortunately for the prospective clients, Willard had little to no contact with the clients and filed court documents with little to no knowledge of the facts surrounding the foreclosure action. When a complaint was filed, Willard would file some form of an answer response and send it to the client and say, if you have any defenses you can think of, feel free to call me. This was his first form of communication, if any. Of the 28 clients he represented, he only met with 3 or 4 of them. When a motion for summary judgment was filed by a lender, Willard would notify foreclosure alternatives and either file a response or tell the client to file bankruptcy. Generally, Willard did not personally communicate with the client. One of the client's cases went terribly wrong, resulting in them losing their home by foreclosure and ultimately filing a grievance against Willard. The clients, the Chandlers, paid $450 of a $900 fee to Willard. The Chandlers were told that Willard was handling their case when he was not made aware of the case until the foreclosure proceeding was too far along. Their house was sold in foreclosure. The Chandlers did not even know Willard's name and learned it by reviewing the court filings. They eventually hired an attorney who filed a grievance against Willard. In the case, the disciplinary board found that Willard had violated several disciplinary rules. First, the board determined that he violated the rule that states a lawyer shall not request a person or organization to recommend or promote the use of the lawyer's services. Second, Willard also aided a non-lawyer in the unauthorized practice of law. Here, foreclosure alternative worked with the lenders to attempt to negotiate a settlement for the debtors. Because of their agreement that Willard would do the legal work and foreclosure, alternatives would do the negotiations without a lawyer. This constituted aiding the unauthorized practice of law. Third, Willard was found to have shared legal fees with a non-lawyer. Foreclosure alternatives. This arrangement was improper, and finally, Willard formed a partnership with a non-lawyer where legal activities were involved. But the court found that 2 areas that the disciplinary board found no support were wrong. The court found that Willard was not adequately prepared to represent the Chandlers and all the other foreclosure clients, and the court found that Willard failed to seek the lawful objectives of his clients. Thus, 6 violations of codes of ethics and professional responsibilities. The court suspended Willard's license for 1 year with 6 months stayed. Discussion questions. Read Disciplinary Counsel vs. Willard. What could Willard have done to avoid disciplinary action? What case in the opinion did the court find similar to Willard's case in determining the sanctions or disciplinary action? Did all the justices agree on the disciplinary action for Willard? If not, what were the different disciplinary actions suggested by the justices? 6-10 Misconduct by attorneys. An attorney must not commit a crime or engage in dishonesty or misrepresentation or otherwise violate the rules of ethics. An attorney must not knowingly engage in misconduct through the acts of others, such as paralegal or investigator. Model Rule 8.4. Tens of thousands of allegations of ethical misconduct by attorneys are investigated every year. Some of these allegations involve criminal conduct. Examples include theft of client funds, securities fraud, falsification of official documents, and tax fraud. For such conduct, an attorney can be subject to criminal prosecution and to discipline by the court or agency that enforces ethics in the state. If an attorney misappropriates a client's funds, the client may be able to receive compensation from a client security fund run by a bar association or foundation set up for this purpose. See Exhibit 6-3. Paralegal perspective, resisting the pressure. In the highly charged, competitive environment of a law office, some attorneys may be willing to violate ethics and the law in the interest of winning. Be sensitive to any overt and subtle pressure on you to participate in such violations. If you feel this pressure, resist it. Let your supervisors know that you are uncomfortable with the situation, and talk with other paralegals who have encountered comparable pressure. Don't give in and don't sit in silence. In all aspects of your career as a paralegal, adopt the motto, if what you are asked to do doesn't feel right, don't proceed until it does. Value your integrity above all else. A paralegal in Oklahoma offers the following advice. Insist on the highest standards for yourself and for your employer. One small ethical breach can lead to a series of compromises with enormous disciplinary and legal malpractice consequences. Fraudulent friending. Social media sites such as Facebook, X, and MySpace are sources of evidence that attorneys might be able to use in litigation. In a child custody case, for example, attorneys for the parents routinely check these sites for pictures of partying, drinking, or other behavior that could suggest negative parenting skills. Recently, a judge ordered the parties to exchange each other's passwords for their Facebook and dating websites to allow mutual opportunity to discovery of evidence relevant to their disputes. A paralegal might be asked to comb social media sites for possible evidence. Care must be used in doing so. It would be unethical to misrepresent your identity in order to gain access to someone's web page through friending or other method of connecting. Lying using a pretext to obtain information is called pretexting. Also, it is unethical to contact an opponent without permission of the opponent's attorney. If the opponent is unrepresented, you must not allow them to believe that you are uninvolved, disinterested in the legal dispute. See the discussion of the no contact rule below. False notarization. Paralegals who are also notaries are sometimes asked by their supervisors to notarize documents that should not be notarized. In fact, paralegals are most often named as defendants for false notarization of a signature. Assume that a law office is sued and the paralegal is named as one of the defendants. If the plaintiff wins, who pays the judgment. As we saw in Chapter 4, the office may have a malpractice insurance liability policy that will pay judgments against it and its employees. The policies, however, often exclude intentional acts of misconduct. False notarization is usually an intentional act. Hence, the losing defendants, including the paralegal, must pay the judgments out of their personal pockets. In short, be extremely cautious of what you are asked to sign. The same is true of documents you are asked to witness. Even if no formal notarization is involved, don't sign a clause saying you witnessed something being performed or executed, called an attestation clause, unless you actually witness it. Online exercise. What are the requirements in your jurisdiction for notarizing a document? Detail the process and procedure and place it in your portfolio binder. Criminal prosecution. If your supervisor is charged with criminal conduct, the chances are good that you will be questioned by prosecutors, and you might become a suspect yourself. In 2014, after the prominent law firm of Dewey and LaBeouf went bankrupt, a paralegal with billing duties was indicted along with senior partners for participating in falsification of records. Insider trading. Be extremely careful about using any information you learn involving a corporation whose stock is likely to change in value as a result of an event that is not yet known to the public. Assume that Company X is planning to merge with Company Y. The news is not yet public. When it does become public, the value of the stock in Company X is expected to rise dramatically. You work at a law firm that represents Company X, and you find out about the planned merger while at work. If you buy stock in Company X before the announcement of the merger, you would benefit from the increased value of the stock that would result after the announcement. This might be an illegal use of inside information called insider trading. In a dramatic case, a paralegal who worked at a securities law firm in Boston was charged with insider trading by the Securities and Exchange Commission, SEC, while working on a case involving a proposed merger. She learned certain information which she gave to outside investors who used it to make illegal profits in the stock market. The story made national news. One headline read, "SEC says Boston paralegal gave tip worth $823,471. Soon after the incident, she was fired. Criminal prosecution for the crime of insider trading became a very real possibility. All employees of law firms must be extremely careful. Innocently, buying stock as a personal investment could turn into a nightmare. One attorney recommends that any paralegal who would like to buy or sell securities should check first with a corporate attorney in the firm to see if the firm represents the issuer or a company negotiating with the issuer. If it does, an accusation of insider trading might later be made. The same caution applies when a member of the paralegal's immediate family buys or sells such securities. Piracy. Another problem area is the use of so-called pirated software. Some businesses buy or lease one copy of computer software and then copy it so that other employees in the office can use it on other terminals. If the software manufacturer has not authorized such copying as part of the original purchase or lease agreement, the copying is illegal and can subject violators to criminal penalties and civil damages. (6-11) Obstructing access to evidence. An attorney must not obstruct a party's access to evidence by destroying, altering, or concealing the evidence. Model Rule 3.4. As a matter of basic fairness to an opposing party, an attorney must not obstruct access to evidence by destroying it, like, for example, shredding relevant documents, altering it, like, for example, backdating financial records, or concealing it, like, for example, pretending not to know whether a requested document exists. Nor can the attorney counsel a client to obstruct evidence in these ways. For example, it is unethical for an attorney to tell a client to clean up a social networking site by removing photos that were requested in discovery. A charge of spoliation can be brought against attorneys or their clients who intentionally destroy, alter, or conceal evidence. Spoliation is a tort for which an aggrieved party can collect damages from the spoiler. In Chapter 14, we will discuss the litigation hold, which is a notice used by parties to alert opponents not to destroy or alter evidence that might be relevant to contemplated litigation. 6-12 Crime or fraud by clients. It is proper for an attorney to discuss the legal consequences of any proposed conduct of the client. If, however, the attorney knows that future conduct of a client would be criminal or fraudulent, the attorney must not give the client any advice or other assistance on such conduct. Model Rule 1.2d. The client hires the attorney and controls the purpose of the attorney-client relationship. Furthermore, the client is entitled to know the legal consequences of any action they are contemplating. This does not mean, however, that the attorney must do whatever the client wants. Example: the president of a corporation hires Leo Richards, Esquire, to advise the company on how to dump toxic waste into a local river. Note that the president has not asked Richards if the dumping is legal. It would be perfectly ethical for Richards to answer such a question. In the example, the president asks how to dump. If Richards feels that the dumping can legally take place, they can so advise the president. Suppose, however, that it is clear to Richards that the dumping would violate the federal or state criminal code. Under such circumstances, it would be unethical for Richards to advise the president on how to proceed with the dumping. The same would be true if the president wanted help in filing an environmental statement that misrepresented the intentions of the company. Such an application would be fraudulent, and an attorney must not help someone commit what the attorney knows is fraudulent conduct. When attorneys are later charged with unethical conduct in such cases, their defense is often that they did not know the conduct proposed by the client was criminal or fraudulent. If the law applicable to the client's case is unclear, the attorney can make a good faith effort to find a legal way for the client to achieve their objective. The point at which the attorney crosses the ethical line is when they know the client is trying to accomplish something criminal or fraudulent. In addition to charges of unethical conduct, an attorney could be subjected to civil suits for participating in illegal conduct of a client. For example, participating in the destruction or alteration of evidence. Spoliation can also have serious consequences. One final point on the theme of legal services and illegal conduct. Suppose that a senior citizen goes to an attorney for advice on Medicaid. This is a needs-based program. You have to be poor enough to qualify for its healthcare benefits, unlike Medicare. Assume that the client has too many assets to qualify. The attorney then describes how the bulk of the assets could be disposed of, like for example by gifts to children, so that the client would qualify. The strategy was so widespread that Congress, angry that attorneys were teaching people how to abuse the system, made it a crime to give such advice. This became known as the Send Granny's Lawyer to Jail law. The law certainly made it difficult for attorneys to argue that they did not know that they were participating in something illegal with their clients. The advice itself was illegal. The law created an uproar in the legal community and was immediately challenged in court as a violation of free speech under the First Amendment. The issue eventually became moot when the U.S. Attorney General announced that the Department of Justice would not bring prosecutions under the law because of its dubious legality. Quick tip: an attorney will rarely tell paralegals or other staff members that they know the office is helping a client do something criminal or fraudulent, but you might learn that this is so, particularly if there is a close, trusting relationship between you and your supervising attorney. You must let this attorney or some other authority in the office know you do not want to work on such a case. 6-13 Frivolous Positions and Harassment. An attorney must not bring a claim or assert a defense that is frivolous, is intended to harass an opponent, or cause unwarranted delay. Model Rules Preamble 5.3.1. We have an adversary system of justice. This means that our method of resolving a legal dispute is to have opposing sides fight it out before an impartial decision maker. See Chapter 7 for a description of the inquisitorial system used in many other countries. We believe that the truth and fairness are more likely to emerge when each side has an equal chance to present its case forcefully. Within this system, clients have the right to hire an attorney to be a vigorous advocate, but there are limits on how vigorous an advocate can be. It is unethical for an attorney to assert frivolous positions as claims or defenses. A position is frivolous if the attorney is unable to make a good faith argument that existing law supports the position, or that existing law should be changed or reversed to support the position. A position is not necessarily frivolous simply because the attorney thinks the client will probably lose. The key is whether there is a good faith argument to support the position. If the attorney can think of no rational support for the position, it is frivolous. Because the law is often unclear, however, it is difficult to establish that an attorney is acting unethically under the test of good faith. Closely related to asserting frivolous positions is the unethical practice of asserting positions for the sole purpose of harassing or maliciously injuring someone. A lawyer should use the law's procedures only for legitimate purposes and not to harass or intimidate others. Model Rules Preamble 5. A charge of unethical conduct is not the only consequence for asserting a frivolous position. Under Rule 11 of the Federal Rules of Civil Procedure, FRCP, for example, whenever an attorney in a federal case submits a motion or pleading to the court, they must certify that it is not being presented for any improper purpose, such as to harass or to cause unnecessary delay or needless increase in the cost of litigation, and that the claims Defenses and other legal contentions therein are warranted by existing law or by a non-frivolous argument for the extension, modification, or reversal of existing law or the establishment of new law. Violating Rule 11 can lead to sanctions by the court, like, for example, a fine. In addition to a charge of unethical conduct, many states have their own version of Rule 11 for state court cases. Online exercise. Determine the equivalent rule in your jurisdiction to Rule 11 regarding filing of frivolous pleadings in court. Paralegal perspective. In the heat of controversy, tempers can run high. Attorneys do not always exhibit the detachment expected of professionals. They may so thoroughly identify with the interests of their clients that values can become confused. Paralegals working for such attorneys may get caught up in the same fever, particularly if there is a close attorney-paralegal working relationship on a high-stakes case that has lasted a considerable time. The momentum is to do whatever it takes to win. Although this atmosphere can be exhilarating, it can also create an environment where less and less attention is paid to the necessities of ethics. 6-14 Safekeeping property. An attorney must hold client property separate from the attorney's own property. No commingling. Avoid using client funds improperly. Safeguard client records. Model Rule 1.15 Attorneys are fiduciaries, individuals who must exercise a high standard of good faith and fair treatment on behalf of their clients. This fiduciary responsibility is particularly important when handling client funds. 6-14A Commingling. A law office often receives client funds or funds of others connected with the client's case, like, for example, attorneys receive money in settlement of a case or as trustees. Such funds should be held in a client trust account. General operating funds of the office should be kept in a separate account. There must be no commingling of client funds and office funds. It is unethical to place everything in one account. This is so even if the firm maintains accurate bookkeeping records on what amounts in the single account belong to which clients and what amounts belong to the firm. In a commingled account, the danger is too great that client funds will be used for non-client purposes. Law firms are notoriously lax about this requirement. 6-14B Retainers. It is also improper for an office to misuse funds on retainer. Clients sometimes deposit funds with an office to cover future fees, court costs, and related expenses. The office should not draw on these fees before they are earned, nor withdraw the funds for expenses not yet incurred. This is so even if the funds were never commingled when deposited by the client. For more on the use and abuse of such funds, see Chapter 5. 6-14C Client Records. Client records must also be safeguarded. The client's file is the property of the client. When the attorney's representation of the client is over, the firm cannot discard or destroy the file. The client must be given the opportunity to retrieve it. The firm can keep copies. In fact, many states require that copies of files be kept in a storage a minimum period of time, like for example 5 years, after the firm has completed its representation of the client on a matter. When a firm is allowed to destroy files, it must do so without breaching confidentiality. It would probably be unethical, for example, to throw unshredded files containing client names and other case information into regular trash bins. As mentioned earlier, a law office cannot refuse to return a client's file under the client until the client settles their final bill. Paralegal perspective. Use great care when your responsibility involves client funds, such as receiving funds from clients, opening bank accounts, depositing funds in the proper account at a bank, and making entries in law firm records on such funds. It should be fairly obvious to you whether an attorney is violating the rule on commingling funds. It may be less clear whether the attorney is improperly using client funds for unauthorized purposes. Attorneys have been known to borrow money from clients' accounts and then return the money before anyone discovers what was done. They might even pay the account interest while using the money. Elaborate bookkeeping and accounting gimmicks might be used to disguise what occurred. Such conduct is unethical, even if the attorney pays interest and eventually returns all the funds. In addition, the attorney might be charged with theft or criminal fraud. Of course, anyone who knowingly assists the attorney could be subject to the same consequences. Be very careful about signatures. An attorney may want to delegate the task of signing for bank deposits, transfers, or withdrawals. In some states, it is unethical for an attorney to allow a non-attorney to sign for transactions involving client property, particularly funds in client trust accounts. Let's take another look at our fact pattern from the beginning of the chapter. It does seem that the paralegal in our facts is fully aware of the supervising attorney's conduct through Leanne's confession. The paralegal will have to report their actions to someone, such as a managing attorney, human resources, a bar association, or outside authorities. Our paralegal does not want to be accused of assisting the attorney in tampering with firm and client accounts. It is a difficult situation, but as a paralegal, you must do the right thing. Whomever is contacted, be sure you document the meeting and the advice or instructions you were given. If internally reporting the situation, the managing attorney or human resources person might say, "I'll handle it from here. No need to report this matter any further. The firm will address the issues." If that is the case, be sure documentation is created that shows you made the report and the results of the conversation. Sometimes memories are fleeting or fuzzy. 6-15 False evidence and statements. Failure to disclose. An attorney must not offer evidence the attorney knows to be false, must not make a false statement of fact or law to a tribunal, must correct any earlier false statements of material fact or law that the attorney made to a tribunal, must tell the tribunal about a case, statute, or other authority that the attorney knows will hurt the cause of the attorney's own client if the opposing party has failed to tell the tribunal about this authority. Model Rules 3.3 and 8.4. 6-15A, false evidence and statements. Attorneys must not offer false evidence or make false statements. They have an ethical obligation to be truthful to a court. If they later discover that they made a material statement in court that they now realize was false, they must correct the statement in court. Suppose that a client asks their attorney to offer into evidence a document that falsely states the earnings of the client's company. If the attorney knows that the document contains false statements, it would be unethical for the attorney to offer it into evidence unless the attorney informs the court of the falsity. In some states, the obligation of truthfulness applies to statements made to opponents as well as to courts. For example, it would be unethical in such states for an attorney to tell an opposing attorney that the maximum coverage on a client's liability policy is $100,000 when the attorney knows that the maximum is $300,000. Of course, making such a false statement to a judge would also be unethical. Social media and attorney representations. Attorneys must not make false or misleading statements on Facebook, LinkedIn, or other social media. Attorneys have been disciplined for exaggerating their experience in their online profiles, such as by falsely stating that they have handled cases in federal court. In a South Carolina case, an attorney was disciplined for listing practice areas in which he had little or no experience. Similarly, an attorney in California in 2014 was sanctioned by misrepresenting herself on Facebook. She claimed she had connections in the entertainment industry and photoshopped her picture with numerous celebrities. Those connections were fabricated, and ultimately she was suspended for 6 months from the practice of law by the California bar. The bar deemed her actions as misleading and deceptive to the public, so too must an attorney and, in turn, a paralegal make truthful representations on Facebook, X, and other social media sites in order to gain information about witnesses or clients on a case. For example, if a law firm is determining whether to take a personal injury case, they may want to check the prospective client's social media posting to see whether there are any admissions that no injuries occurred or pictures of the person playing a sport. Asking for access to the social media accounts is proper, but accessing an individual's social media accounts to gain information on that person without disclosing your identity is unethical. Some attorneys or paralegals have used a friend request to gain access to Facebook, for example. Normally, that would not be problematic, but using a different identify to gain that access, using a different identity to gain that access is an ethical problem. There are ways to investigate clients or potential witnesses through ethical means. Don't cross the line and court trouble by representing. Don't cross the line and court trouble by misrepresenting information or yourself when using social media, even if directed to do so by an attorney. As the last section of this chapter states, your ethics or your job, know the right thing to do. 6-15B, duty to disclose contrary authority. An attorney who knows of a law that goes against the claims of their own client must tell the tribunal about that law if attorney knows that the opposing attorney has not done so. This requirement is particularly startling. Example, Karen Singer and Bill Carew are attorneys who are opposing each other in a bitter trial involving a large sum of money. Singer knows about a very damaging but obscure case that goes against their client, but because of sloppy research, Carew does not know about it. Singer never mentions the case, and it never comes up during the trial. It is certainly understandable why Singer does not want to say anything about the case, although Singer does not want to help their opponent. They will pay a price for their silence. Singer is subject to sanctions for a violation of ethical obligations to disclose known contrary authority when they know that their opponent has not cited it. The attorney has a duty to bring the case to the court's attention, even if it may ultimately be dispositive law against the client. In a case from the Federal Third Circuit Court of Appeals, a defendant was arrested for the unlawful possession of ammunition. At the time of the arrest, the statute was being challenged on constitutional grounds. The Third Circuit had found the wording in the statute vague and declared it unconstitutional, thereby rendering the defendant's conviction on the issue void. The applicable statute correcting the unconstitutional language was passed 2 years after a defendant's initial arrest, and thus dispositive for his client's case. Opposing counsel failed to bring this crucial change in the law to the court's attention. The opposing counsel for the government brought it to the court's attention instead, based on the ethical duty to do so. Here's a quote in a footnote from the Federal Third Circuit Court of Appeals, noting that the disclosure by the attorney was virtually an admission against their position in the case, but was the ethically appropriate position. The court noted, "We commend the candor of the government's counsel in acknowledging at argument the timing of the enactment of the statute. See Government of the Virgin Islands v. Turby, 304 F. A. PPX 76 footnote 4 3D CIR 2008. Although the government attorney lost the case, the fact that a major legal error was corrected was an important ethical victory, such so that the court noted it in a case footnote." Paralegal perspective. Chances are high that attorneys who offer false evidence or who lie to a court will pressure their employees to participate in the deception. A paralegal or other employee might be asked to give a false statement to a court clerk, help a client lie, commit perjury, backdate a document, or improperly notarize a deed. Do not compromise your integrity, no matter how much you believe in the cause of the client. No matter how much you detest the tactics of the opposing side, no matter how much you like the attorney for whom you work, and no matter how important this job is to you. Our last look at the facts from the beginning of this chapter and the ethical codes studied tell us what the paralegal should do about her supervisor, Leanne's misuse of firm funds. As suggested earlier, there is no doubt that the paralegal has to disclose this information to someone else in the firm, such as the managing partner or the human resources director for the firm. The paralegal should also consider reporting the actions of her supervising attorney to the disciplinary council for the local and state bar and possibility law enforcement. These are serious actions by the attorney, and no one should ignore the gravity of the possible offenses, regardless of the relationship that the paralegal has with the supervising attorney. 6-16 Confidentiality. General rule: an attorney must not disclose information relating to the misrepresentation of a client. Exceptions to the general rule: informed consent. A client can always agree to allow the disclosure of confidential information, preventing death or substantial bodily harm. Confidential information can be disclosed if the attorney reasonably believes disclosure is necessary to prevent reasonably certain death or substantial bodily harm, preventing substantial injury to financial interests or property. Confidential information can be disclosed if the attorney reasonably believes disclosure is necessary to prevent the client from committing a crime or fraud that is reasonably certain to cause substantial injury to the financial interests or property of another, if the client is using the services of the attorney in committing the crime or fraud that the attorney seeks to prevent by the disclosure. Implied consent. An attorney has implied consent from the client to disclose confidential information when disclosure is needed to carry out the representation for which the attorney was hired. Suits between attorney and client. If the client sues the attorney or vice versa, the attorney can reveal whatever confidential information is necessary for the attorney to defend against the client's suit or to assert the attorney's claim against the client. Model Rule 1.6. Information is confidential if others do not have a right to receive it. When access to information is restricted in this way, the information is privileged. After we cover ethics and confidentiality, we need to examine the related topics of the attorney-client privilege, ACP, and the attorney work product rule. 6-16A. What information is confidential? The ethical obligation to maintain confidentiality applies to all or almost all information that relates to the representation of a client, whatever its source. One court has said, virtually any information relating to a case should be considered confidential, even unprivileged client information. Note also that the obligation is broader than so-called secrets or matters explicitly communicated in confidence. Information can be confidential even if the client does not refer to it as a secret, and even if the client does not ask that it not be revealed. Confidentiality has been breached in each of the following examples. At a party, an attorney tells an acquaintance from another town that the law firm is representing Jacob Anderson, who wants to prevent his employer from forcing him to retire. The identity of a client is confidential, so is the reason the client is seeking legal help. At a bar association conference, an attorney tells an old law school classmate that a client named Brenda Steck is considering a suit against her brother over the ownership of property left by their deceased mother. The identity of a client and what lawsuits she is considering are confidential. A legal secretary carelessly leaves a client's file open on her desk where a stranger, like for example another client, briefly reads parts of the top sheet. The contents of a client file are confidential. The duty of confidentiality does not apply to information that is already public knowledge. If, in the first example, the media has already reported that Jacob Anderson is represented by the attorney's law firm, the attorney can tell someone that Anderson is a client there. Providing details of the case, however, that have not been reported in the media would be a breach of confidentiality. It should be noted, however, that some law offices recommend non-disclosure of even publicly known information. The guideline of such offices is no discussion of any information about a case. The ethical rule on confidentiality is designed to encourage clients to discuss their case fully and frankly with their attorney, including embarrassing and legally damaging information. Arguably, clients would be reluctant to be open with an attorney if they had to worry about whether the attorney might reveal the information to others. The rule on confidentiality makes it unethical for attorneys to do so. 6-16b Exceptions to the rule on confidentiality. Informed consent. Attorneys can disclose confidential information if they receive informed consent to do so from their clients. Well-known trial attorneys who write books about cases of their clients, for example, can include confidential information in the books if they have clear client consent to do so. Preventing death or substantial bodily harm. Disclosure can be ethically permissible if the attorney reasonably believes that disclosure is necessary to prevent reasonably certain death or substantial bodily harm. Example: an attorney represents a client in a bitter divorce action. Assume that during a meeting at the law firm, the client makes one of the following statements to the attorney. I am going to use this gun tonight to kill my wife's lover. I killed my wife's lover yesterday with this gun. The attorney does not have a duty to disclose either of these confidential statements to the police or to anyone else. If, however, the attorney does disclose them, has the attorney breached confidentiality? The answer is no for the first statement, but yes for the second. The first statement is about a future act, the crime of murder that the client says he intends to commit. An attorney can disclose this statement if the attorney reasonably believes that disclosure is necessary to prevent reasonably certain death or substantial bodily harm. The second statement, however, is about a past act. Disclosing it would not prevent death or substantial bodily harm. Hence, disclosure would be unethical. Preventing substantial injury to financial interests or property. Assume that an attorney learns that the client is about to harm someone financially. The attorney does not have a duty to disclose this confidential information to the person or company that will be harmed. If, however, the attorney does disclose it, the ethical duty of confidentiality is not breached if the attorney reasonably believes that disclosure is necessary to prevent substantial financial harm, and if two additional conditions are met. First, the client is going to cause the harm through a criminal or fraudulent act, and second, the client is using the attorney's services to commit the crime or fraud. Example: an attorney represents the owner of a company. The attorney advises the owner on a large loan that the owner is seeking from a small bank. The owner tells the attorney that they are going to use false financial data. On the loan application and intends to file for bankruptcy a few months after the loan is approved, once the funds are received. In most situations, the attorney does not have a duty to disclose this confidential information to the bank or to anyone else. If, however, the attorney wants to disclose it, the ethical duty of confidentiality is not breached if the attorney reasonably believes disclosure is necessary to prevent the client from committing a crime or fraud that is reasonably certain to cause substantial injury to the financial interests or property of another, the bank, and if the client is using the services of the attorney in committing the crime or fraud that the attorney seeks to prevent. These conditions appear to have been met in the statements the client made to the attorney in the bank example, Implied consent. The client impliedly consents to those disclosures of confidential information by an attorney that are needed to provide the representation for which the client hired the attorney. In a dispute over alimony, for example, the attorney would obviously have to disclose certain relevant financial information about the client to a court or to opposing counsel during settlement negotiations. Attorney and client suing each other. Finally, some disclosures can be proper in suits between attorney and client. Suppose, for example, the client sues the attorney for malpractice, or the attorney sues the client for non-payment of a fee. In such proceedings, an attorney can reveal confidential information about the client if disclosure is necessary to defend against the client's claim or to assert the attorney's own claim against the client. See Exhibit 6-5, Summary of Exceptions to Confidentiality. Exhibit 6-5, Summary of Exceptions to Confidentiality. Informed consent. Attorney and client suing each other. Implied consent. Preventing substantial injury to financial interests or property. Preventing death or substantial bodily harm. Analyze this. An attorney has a meeting with a close friend who happens to be a client as well. The friend says that they are tired of all their girlfriends complaining and spending money on unnecessary things. The friend told their girlfriend they wanted to stop seeing them and wanted them out of their house tomorrow. This friend tells their attorney friend that if they are not out by tomorrow, they will make sure the girlfriend is out of the house, one way or another. The girlfriend turns up dead 2 days later. Is the exchange between the two friends confidential and protected by the attorney-client privilege? Defend your response. 6-16C, Attorney-Client Privilege, ACP. The attorney-client privilege, ACP, serves a function similar to that of the ethical rule on confidentiality, in that both doctrines are designed to encourage open communication between attorney and client. The two doctrines overlap, although the ethical duty of confidentiality is much broader than the ACP. Ethical duty of confidentiality protects all or almost all information, not just client or attorney communications, from any source if the information pertains to a client case and was obtained by a law office while representing the client. ACP protects all communications made in confidence between an attorney and client if the purpose of the communication was to obtain legal services from the attorney. A communication is made in confidence if it was intended to be confidential. If it is made in the presence of strangers, like for example in front of strangers on an elevator, the ACP is lost. Everything protected by the ACP is also protected by the ethical duty of confidentiality. The reverse, however, is not always true. All information protected by the ethical duty of confidentiality is not also protected by the ACP. Example, while investigating the finances of a client's company, an attorney learns from the minutes of a shareholder meeting that the company considered discontinuing a particular product 5 years ago. This information is protected from disclosure by the ethical duty of confidentiality because, however, the information was not part of a communication between attorney and client, the information is not protected by the ACP. The ACP most often arises in court or administrative proceedings in which the attorney or client is asked a question that pertains to a communication that occurred between them when the client was seeking legal help. The client can refuse to answer on the ground of privilege. If the attorney is the one being asked the question, they must refuse to answer on the same ground unless the client gives the attorney consent to answer. Only the client can waive the ACP. The rule on confidentiality covers sanctions imposed on attorneys when they improperly disclose information. When they improperly disclose confidential client information to anyone outside the law office. The ACP tells us when clients and attorneys or their employees can refuse to answer questions pertaining to communications involving legal services for a client. A good example of a case involving the issue of attorney-client privilege and confidentiality is Volry v. State, 2007, TEX, APP, Lexus 6574. Have a great day, man.
Okay, you do the same.
Yes, ma'am. Corpus Christi, TEX, 2007, where a legal assistant was involved in helping a friend and defendant in a murder case. Order the court, a case study, Volry v. State, Texas Court of Civil Appeals, Corpus Christi, 2007, TEX APP Lexus 6574, Corpus Christi TEX 2007. Volry presents a summary of several ethical issues that are presented in this chapter. The case is a murder case where a legal assistant was friends with the victim and defendant, husband of the victim. Here, Joyce Volry was going to a high school reunion with her sister on June 24th, 2004. The defendant, Lester Volry, met his wife at the reunion, where they both left in a blue Explorer. Joyce had contact with her sister initially after she left with Lester, but later that night, Joyce was not responding to calls and didn't return home. During that night, a couple observed two people in a roadway where the woman was trying to get away. The man pinned the woman down and he was shot. There may have been another person in the vehicle as Lester kept entering and exiting the vehicle and exiting the vehicle. Randy Graffagnino, a legal assistant with the law firm of Provost Umphrey, tested that he worked for Walter Umphrey. He knew that Umphrey owned a ranch and lodge where the Volrys worked. Randy frequented the ranch on weekends and was good friends with Lester. When he heard about the incident, Randy called Lester to persuade him to turn himself in. Several calls were exchanged by the two men. At trial, Randy testified that Lester stated that he did not kill his wife, but that some other person had done it. Lester further told Randy that he had messed up and was in real trouble. Randy told Lester that he was talking with the police so that he could facilitate Lester's peaceful surrender. Ultimately, Lester turned himself in to the police. Randy testified that he told Lester on numerous occasions that the law firm could not represent him in the criminal matter. The issue that the appellate court had to evaluate was whether an attorney-client relationship was established between Randy and Lester. The court determined that there was not. Lester stated he believed that Randy was an attorney and thus established an attorney-client relationship creating a level of confidentiality between their communications. The court stated that the attorney-client relationship is established by agreement, either by contract or implied from the actions of the parties. During his testimony, Randy continually stated that he told Lester that he was not a lawyer and that he could not legally help him. He also told Lester that the firm could not represent him because of a conflict of interest. He and his wife had worked for Humphrey. Lester thought that Randy was a lawyer and that he could help him legally. He denied that Randy ever told him that he could not help him. What Lester testified to was that he thought his communications with Randy would be confidential because they were friends and because Randy was an attorney. The appellate court agreed with the trial court that there was no attorney-client relationship established between Lester and Randy. Randy had explicitly told Lester that he and the firm could not help him. Thus, based on the facts, no attorney-client relationship was established and that the information exchanged between the men was not protected by any privilege and not confidential. Discussion questions. Review Valerie v. State. What case did the court rely upon in deciding the attorney-client relationship issue? What other issues were raised in the case? What could Randy have done differently to ensure that no question existed as to his status as a legal assistant? Was the court's result well-founded? Explain your answer. 6-16D. Attorney Work Product Rule. Another rule that is related to but different from confidentiality and the ACP is the Attorney Work Product Rule. Suppose that while working on a client's case, an attorney prepares a memorandum that contains research notes but no confidential communications. The memorandum, therefore, is not protected by the ACP. Can the other side force the attorney to provide a copy of the memorandum? Is it discoverable, meaning that an opposing party can obtain a copy during discovery at the pretrial stage of a lawsuit? The answer depends on why the memorandum was prepared. If it was prepared in anticipation of litigation, it is protected by the work product rule and is not discoverable. To the extent that work product is not discoverable, it is privileged. Work product consists of notes, working papers, memoranda, or similar documents and tangible things prepared by the attorney in anticipation of litigation. An example is an attorney's inter-office memorandum that lays out their strategy in litigating a case. Attorneys do not have to disclose their work product to the other side unless the latter convinces a judge that it has a substantial need for the work product. Judges, however, are rarely convinced. Quick tip: when preparing a memorandum for a case for your attorney, always insert above the introductory block attorney-client privilege or work product privilege. It will give a heightened level of confidentiality and non-disclosure protection to the document. Adding that language to other client documents may be appropriate as well. 6-16E. Inadvertent disclosure. A great fear of a law office is that the wrong person will obtain material that should be protected by ethics, by the ACP, by the work product rule, or by all three. This can have devastating consequences. For example, if a stranger overhears a confidential communication by a client to the attorney or to the attorney's paralegal, a court might rule that the attorney-client privilege has been waived on the theory that it is inconsistent to let a stranger or any third party hear what you claim was confidential. Media celebrity Martha Stewart was confronted with this reality when a court ruled in her criminal trial that she had waived the attorney-client privilege covering the contents of an email with her attorney when Stewart mailed a copy of the email to her daughter. Accidentally faxing or emailing a sensitive document such as a strategy memorandum on a current case to the opposing attorney can happen. When under a time deadline and working quickly, you may punch in or type the wrong information, such as the phone number on the fax machine, or send an email message or attachment to the wrong address. Yes, it happens, and there are ways to correct the error. Assume that an office receives an email from opposing counsel with an attachment containing a confidential document. The intended recipient was another attorney in a branch office of the sender, but someone typed the wrong email address and the opponent received the document. Many states say that unintended recipients must properly notify the sender that the document was inadvertently received. If the recipient knows before opening the document that it was received in error, it must not be opened. The recipient must notify the sender and abide by the sender's instructions on what to do with it, like, for example, send it back or destroy it. States use different approaches to decide whether confidentiality and the ACP are always waived, lost, by inadvertent disclosure of confidential information. Some states follow the strict rule, also called the traditional rule, that confidentiality and privilege are lost if a disclosure occurs, whether intentionally or inadvertently. Other states, however, use a case-by-case approach in which the court looks at all of the particular circumstances of each disclosure to decide whether, on balance, justice would be better served by preserving confidentiality and privilege despite the disclosure. The factors the court will look at include whether the office took reasonable precautions to prevent disclosure, the number of disclosures that occurred, and how long it took for the sender to discover what happened and to try to rectify the sending error. Many law offices routinely include notices at the bottom of every email message they send out, such as the following: this message is for the intended individual or entity and may contain information that is privileged. If the reader of this message is not the intended recipient, you are hereby notified that any copying, forwarding, or other dissemination of this message is prohibited. If you have received this communication in error, please notify the sender immediately by email or telephone and delegate the original message immediately. Online exercise. What is your jurisdiction's law on inadvertent disclosures to opposing counsel? What does your jurisdiction require be done to correct the inadvertent disclosure? Place this information in your portfolio binder. Paralegal perspective. Rules governing confidentiality and the attorney-client privilege ACP apply to paralegals. Confidentiality. In every state, the duty of confidentiality applies to paralegals. Attorneys have an obligation to instruct their paralegals about ethics, particularly the duty not to disclose information relating to a client. Model Rule 5.3, Comment 2. ACP. In every state, the ACP applies to paralegals. Hence, a paralegal cannot be questioned about what the paralegal and client said to each other on a matter pertaining to the representation of the client by the law office where the paralegal works. Some states have made this result explicit in their statutory code. For example, a Colorado statute, Colorado Revised Statutes, Statute 13-90-107, 1B provides that an attorney shall not be examined without the consent of his client as to any communication made by the client to him or his advice given therein in the course of professional employment, nor shall an attorney secretary, paralegal, legal assistant, stenographer, or client be examined without the consent of his employer concerning any fact, the knowledge of which he has acquired in such capacity. As indicated earlier, the major national paralegal associations have their own ethical codes. See Exhibit 6-4 and Appendix D. All of these codes stress the importance of maintaining confidentiality. A legal assistant must protect the confidences of a client and must not violate any rule or statute now in effect or hereafter enacted controlling the doctrine of privileged communications between a client and an attorney. Canon 7, National Association of Legal Assistants, NALA Code of Ethics and Professional Responsibility. A paralegal shall preserve all confidential information provided by the client or acquired from other sources before, during, and after the course of the professional relationship. Confidential information is that legal authority governing confidential information in the jurisdiction in which the paralegal practices. Section 1.5 and 1.5a, National Federation of Paralegal Associations, Model Code of Ethics and Professional Responsibility. Members of NALS, the Association for Legal Professionals, must observe rules governing privileged communications and confidential information. They must preserve and protect the confidences and privileged communications of a client. Canon 4 NALS, Code of Ethics and Professional Responsibility. When you are hired, the firm may ask you to sign a formal confidentiality agreement in which you promise not to divulge client information to anyone who is not working on the client's case. You, of course, are bound to maintain confidentiality even if your employer does not ask you to sign such an agreement. Paralegals face many temptations to violate confidentiality. For example, a paralegal inadvertently reveals confidential information. While networking with other paralegals at a paralegal association meeting, during animated conversation with another paralegal in a common area such as a restaurant or an elevator, or during casual after-work discussion with a relative, spouse, or roommate about interesting cases at the office. As indicated, the rule on confidentiality is not limited to damaging or embarrassing information. The rule is much broader. All information relating to the representation of a client must not be revealed to anyone outside the office. Quick tip: to avoid any breach of a client's confidentiality, make it a practice to never discuss your cases with anyone outside of the work environment. Some law firms discourage the discussion of even public information with anyone outside the firm. In Philadelphia, paralegals are told that a client of your office might be offended to learn that a firm employee has discussed the client's business in public, even if the information mentioned is public knowledge. Do not discuss the business of your office or your firm's clients with any outsider. no matter how close a friend, at any time, unless you are specifically authorized by a lawyer to do so. During the World War II, sailors were told that loose lips sink ships. The same applies to law firms. Note that the last clause of the following law firm statement to all paralegals places limits on what can be said to other employees within the same law firm. Throughout your employment, you will have access to information that must at all times be held in strictest confidence. Even the seemingly insignificant fact that the firm is involved in a particular matter falls within the orbit of confidential information. Unless you have attorney permission, do not disclose documents or contents of documents to anyone, including firm employees who do not need this information to do their work. If you attend a meeting on a case outside the law office, ask your supervisor whether you should take notes or prepare a follow-up memorandum on the meeting. Let the supervisor decide whether your notes or the memo might be discoverable. Be very careful when you talk with clients in the presence of third persons. As indicated earlier, overheard conversations might constitute an unintentional waiver of the ACP. Cellular phones can sometimes cause problems. The signal in mobile communications is transmitted by frequency over airwaves. Therefore, outsiders can listen to both ends of the conversation with relative ease. If you are on a cellular phone with a client, warn them that confidential information should not be discussed. Do not listen to your messages on a phone when others are in the room and can hear the messages as well. Clients often leave messages that contain confidential information. When using speakerphones or paging systems, don't broadcast confidential information. Assume that many people will be hearing you on these public systems and that most of them are not entitled to hear what you are saying. Make sure your door is closed when discussing a client's case. If there is no door to the office, find out if there is a private room in the firm you can use for the call. If this is not practical, lower your voice when talking on the phone and be alert at all times to the presence of anyone around you who can hear what you are saying. This is particularly important for paralegals who work in open cubicle areas. When working on your computer, try to position the monitor so that others cannot read the screen, especially when you need to leave your desk. As part of information protective measures in most legal environments, computers are set to automatically make the screen go dark or that add a design graphic after a designated period of time when there is no typing, usually after re-entering your password. The screen then reappears and you continue typing. Be sure that this screensaver program is installed on your computer. Additionally, you can add a privacy screen filter to your work computer for added security protection. The privacy screen filter is a thin layer of polarized plastic that reduces the viewing angle of your screen. You can see what is on your screen, but others off to the side, for example, only see a dark screen. All your visual information on the computer is essentially hidden unless you are looking at your screen directly. This is another form of protection for the confidential information that you will be privy to while in a professional legal environment. Using a shredding machine when throwing away papers containing confidential information. Extra caution is needed when deleting files from a computer. Using the delete key is not enough. A file can be deleted from computer directories, but still be readable in the computer's trash bin and elsewhere on your hard drive. In addition to deleting the files in the recycling bin, find out what steps the office takes or should take to delete files permanently. Also, most law offices have backup systems that copy data to external drives and/or to the cloud. Deleting a file on an office computer does not simultaneously delete it on external drives or in the cloud. We will cover these computer terms in Chapter 11. Avoid sending inappropriate metadata when you send someone a document online, like, for example, a memo created in Microsoft Word that you send as an attachment to an email message. You are sending more than the data that will be read on the screen when the document is opened or when it is printed. Digital documents also contain metadata, which are data about data. They could consist of hidden information about the document, such as earlier drafts of the same document or comments of colleagues on the document. The metadata might contain confidential information. If you do not want a recipient of a document to be able to read the metadata on it, you must delete the metadata before you send the document. Online exercise. Perform a search to find out how to remove metadata from a document. Clients often communicate with attorneys and paralegals by email. Most of these communications contain confidential communications that can be read by strangers, such as hackers and administrators of network servers. The cautious law office, therefore, will obtain explicit consent from the client to communicate by email. After reminding the client that the security online cannot be guaranteed, as an added precaution, email can be encrypted, which converts the message into a code that renders the data in the message incomprehensible until they are reconverted to a readable format by a recipient with the right software, unless requested by a client. However, a law office is not ethically obligated to encrypt all emails it sends. Confidential information should never be sent through open formats such as social media and listservs. Strangers can often read what is sent over to them. We will examine these online programs in Chapter 11. Find out if anyone other than the client has access to the client's email. If others have access and read messages to and from the law office, a court might rule that this waives the ACP for those messages. Computers and fax machines often store thousands of phone numbers and email addresses to make it easy for you to find an address when you want to send something. The downside of this convenience is that it is very easy to send something to the wrong person. Hence, before you hit the send button, there are precautions you can use. 1. Stay away from hitting the reply all button and input each recipient's email address. 2. Turn on any automatic pre-sending prompts within your email, such as spell check or sending confirmation. 3. Always type in the complete email address of the recipient in case your email program populates the wrong address. 4. Type your email first and then input the addresses. When using vendors such as outside printers, like for example, a company that prints appellate briefs and copying services, make sure that they sign confidentiality agreements stating that they will not disclose the contents of any of the documents on which they will be working. Use an electric watermark or stamp marked privileged on documents that contain confidential information. When transporting file folders or boxes containing case files, like for example, to and from the courthouse, client names should not be visible on the outside of the folder or box. When looking for employment, it is often helpful to submit writing samples to prospective employers. If the sample is a document on a real case, like for example, a complaint or research memorandum, seek permission to use it as a writing sample from the employer in the office where you prepared it. Also, be sure to omit or strike out, redact any client names or other confidential information in the samples. During a job interview, never discuss confidential information about prior cases. It would be unprofessional to do so. Later, when we cover conflict of interest, we will examine the need to provide a prospective employer with a list of names of parties in cases you have worked on in prior jobs. This must be done with great caution, as we will see. One of the most dramatic legal stories of the 20th century was the tobacco litigation of the 1990s. The cases led to billions of dollars in settlements, judgments, and attorney fees. The litigation is still going on today. A critical event in this drama was a breach of confidentiality by Merrill Williams, a paralegal who once worked at Wyatt, Tarrant, and Combs, the largest law firm in Kentucky. The firm represented Brown and Williamson B&W, maker of Kool and Viceroy, as a $9 an hour paralegal. Williams was assigned to work on the numerous documents involved in the litigation. The task overwhelmed him. He was sickened by what he read as document after document showed the lengths to which the tobacco company executives had gone to cover up the risks of smoking. He secretly photocopied and distributed confidential internal memos. Letters, and other documents exchanged by the law firm and its clients. The documents demonstrated that the tobacco manufacturer knew about the dangers of smoking but tried to cover it up. The news media made extensive use of this material. No one doubted that Williams had produced the smoking gun against the tobacco industry. Here is how a Los Angeles Times article described the impact of the role of Williams in the litigation. The ground shifted in 1994 when an obscure paralegal who had secretly stolen thousands of pages of documents from a law firm representing B&W leaked the purloined papers to Congress and the media. Now the blood was in the water. Wyatt, Tarrant, and Combs obtained an injunction against Merrill Williams, no longer an obscure paralegal, to prevent him from continuing to reveal what he knew. The firm said that Williams broke his employment contract that required confidentiality. An ex-smoker himself, Williams had undergone quadruple bypass surgery and threatened to seek damages for injuries allegedly caused by smoking and by his exposure during the course of his employment to information that had induced psychological suffering. This remarkable saga raises critical issues. Clearly, Williams violated client confidentiality. Indeed, it is difficult to think of a violation that has had a greater impact, yet was his violation justified on moral grounds. Tobacco causes the death of thousands every year in this country and hundreds of thousands around the world. Until Williams committed his act, the tobacco industry was all but invulnerable in the legislatures and in the courts of this country. The disclosure of the documents turned the tide. Was Williams a hero or a common thief? Of course, few paralegals during a job interview will tell an interviewer that Williams is one of their heroes. Such an acknowledgement would probably frighten off any potential employer. Furthermore, the Williams case is complicated by allegations that the attorney to whom Williams gave the documents provided Williams with a home, cars, and cash, either outright or as loans. This raised the further ethical and legal issue of whether stolen evidence was being paid for and received. Nevertheless, the question remains, was Merrill Williams engaged in an act of civil disobedience for which anyone who cares about public health should be grateful? Technology update. Client portals. A means to securely communicate with clients is through a client portal. A client portal permits legal professionals to confidentiality and securely share information online with their clients. The type of information that can be exchanged includes, for example, documents, messages, billings, pleadings, and correspondences. To access the portal, the client logs in with a username and password, similar to using email, credit accounts, and the like. Information regarding the client's case or general communications is inserted into the portal for the client to view or, in turn, the attorney to view when receiving a response from the client. To be alerted to a message through a portal, an email notification is received from one of the parties, notifying the recipient that a message is waiting for them. The receiving party then logs in to the portal and accesses the message. Clients' portals provide enhanced communication capabilities for legal professionals and their clients, and easier accessibility to documents and correspondences in a case or transaction. It makes it easier to share files and folders in a more timely manner as well. Rather than send documents for signature through the U.S. mail, the client portal can be used to send a client the documents for review and signature in an expedient manner. The client portal is generally more secure than email. More and more law firms are utilizing this technology as a better means to keep clients informed about their legal business. Thus, to make client portals an effective tool in a legal practice, providing guidance to the client in its use is essential, especially for those clients who are not technology savvy. Additionally, training other legal staff and attorneys in portal use is essential. This technology is here now and will replace many forms of communication as people become more comfortable and familiar with its use. 6-17 Conflict of Interest. 6-17A Introduction. Three words strike dread in the heart of a practicing attorney. Conflict of interest. Why? Because if it exists, it can lead to the disqualification of the attorney and their entire law firm from representing the particular client with whom the conflict exists, even if the attorney is in the middle of the representation of this client. In addition, a conflict of interest can subject the attorney to a suit for legal malpractice. A conflict of interest exists because of divided loyalties that actually or potentially harm or disadvantage someone who is owed undivided loyalty. A client is entitled to an attorney's zealous representation based on independent professional judgment. It is independent when it is free of compromising influences and loyalties. Furthermore, rules against conflict of interest are needed to safeguard confidentiality. Independent professional judgment. There are two main ways in which an attorney's independent professional judgment might be compromised: when the attorney represents parties who have adverse interests, and when the attorney's personal interests interfere with the client's interest. Adverse interests. An attorney's loyalty can be compromised if the attorney represents two persons who have interests that are opposed, adverse to each other. An adverse interest is an opposing interest or position. Example: Smith sues Jones for breach of contract involving the sale of goods. They both want the same attorney to represent them in this case. The parties have adverse interests. They have opposing positions on whether a breach occurred. Personal interests. An attorney's loyalty can also be compromised by the attorney's own personal interests. An attorney's professional interest is to provide and be paid for legal services to the client. An attorney's personal interest is any other goal or desire that the attorney may have in connection with the client beyond providing and being paid for the agreed to legal services. Example: Roberts sues Fireside Incorporated for a breach of warranty. Diane Conley, Esquire, represents Roberts. Unknown to Roberts, Conley owns substantial stock in Fireside. Conley has a personal interest in something connected to their client. That personal interest is their financial investment in the company they are suing on behalf of their client. These are just two examples of possible conflicts of interest based on adverse interests and personal interests. As we study these and other examples, we will see that not every conflict of interest will disqualify an attorney. Confidentiality. Confidentiality. The preservation of confidentiality is another major reason that conflict of interest rules exist. Attorneys learn many different kinds of facts about their clients. The facts can be financial, emotional, marital, damaging, embarrassing, and etc. If these facts are connected or related to the representation, they are confidential. The role of the attorney is to marshal all the facts into the best legal arguments that favor the client's legitimate objectives. Imagine the distress that a former client would feel upon learning that the attorney used some of these facts against the client when the attorney represented someone else. Exhibit 6-6 summarizes the major kinds of conflicts we will be examining. The conflicts can interfere with an attorney's independent professional judgment or can compromise confidentiality. We need to examine when conflicts prevent an attorney from taking a case and when. If the attorney does take the case, they must cease the representation because of a court order or disqualification. Exhibit 6-6, Kinds of Conflicts. (6-17B) Concurrent representation. A concurrent representation is the simultaneous representation of clients who have adverse interests. The adverse interests can be in the same litigated matter and different litigated matters in a negotiation or in a transactional matter. An adverse interest is a goal or claim of one person that is different from or opposed to the goal or claim of another person. Not every concurrent representation conflict will lead to disqualifications, as we will see. There are four major categories of concurrent representation conflicts. When two concurrent clients are at odds in the same litigated matter. When two concurrent clients are at odds in unrelated litigated matters. When two current clients are co-plaintiffs or co-defendants in the same litigated matter. When two current clients are on the same side in a negotiation or in a transactional matter not involving litigation. Here are examples of these four concurrent representation conflicts. Example number 1. Two current clients at odds in the same litigated matter. Tamara wants to sue Nicola in an automobile negligence case. Both Tamara and Nicola ask Franklin Harvey Esquire to represent them in this negligence case. 2. Two concurrent clients at odds in unrelated litigated matters. Isaac is suing Marta in an automobile negligence case. Marta is suing Isaac for sole custody of their daughter. Isaac and Marta are not married. Alice Sander Esquire represents Isaac in the negligence case, and Marta now asks Sander to represent Marta in the custody case against Isaac. 3. Two current clients who are co-plaintiffs or co-defendants in the same litigated matter. Adina is a passenger in a car driven by Kelvin. They are both injured when a truck driven by Harry collides with their car. Adina and Kelvin, as co-plaintiffs, sue Harry for negligence. Walt Francis Esquire wants to represent both Adina and Kelvin. 4. Two current clients on the same side in a negotiation or in a transactional matter not involving litigation. Dan and Charles have lived together for several months. They ask Leon Thomas Esquire to draft a cohabitation agreement for them so that their property rights and support duties to each other are clarified. Now, let's look at which of these concurrent representation conflicts will lead to disqualification. 1. Two current clients at odds in the same litigated matter. In most states, an attorney cannot represent two clients who are litigating each other in the same case and who will be making claims against each other. The attorney would be disqualified from such representation. Hence, in the first example, Harvey would not be allowed to represent both Nicola and Tamara in the negligence case. Harvey cannot give undivided loyalty to both sides. Tamara needs to prove that Nicola was negligent. Nicola needs to prove that they were not negligent, and perhaps that Tamara was negligent, called contributory negligence. How can Harvey vigorously argue that Nicola was negligent and at the same time vigorously argue that Nicola was not negligent? How can Harvey give independent professional judgment? Have a great day, ma'am. Ma'am, have a great day.
You too, thank you.
How can Harvey give independent professional judgment to two people who have such a conflict? The difficulty is not solved by Harvey's commitment to be fair and objective in giving advice to both parties. The role as an attorney is to be a partisan advocate for the client. Furthermore, client consent would not change this result. Even if Tamara and Nicola agree to allow Harvey to represent both of them, it would be unethical for them to do so. In most states, the presence of adverse interests between the parties in the same litigation makes it unethical for an attorney to represent both sides with or without their consent. Some states, however, make an exception in certain kinds of cases, particularly divorce cases. An example, Chris and Alex James Smith have been married for 2 months. They are now separated and both want a divorce. There are no children and no marital assets to divide. Neither wants nor is entitled to alimony from the other. Georgia Davidson Esquire is an attorney that Chris and Alex know and trust. They decide to ask Davidson to represent both of them in the divorce. In this case of concurrent representation, can Davidson ethically represent both sides? A few states will allow them to do so on the theory that there is not much of a conflict between the parties. The conflict does exist. Chris and Alex will be listed as opposing parties in divorce court, but the conflict appears to be in name only. Chris and Alex want the divorce. There is no custody battle. Alimony is not an issue, and there is no property to fight over. All they need is a court to decree that their marriage is legally over. Hence, the potential for harm caused by concurrent representation in such a case is almost non-existent. In these states, if both parties give their informed consent and are made aware of the risks of concurrent representation, the same attorney would not be disqualified from representing them both. Other states, however, disagree. They frown on concurrent representation in so-called friendly divorces of this kind. The case may have been friendly at the outset, but years later, when everything turns sour, one of the parties inevitably attacks the attorney for having had conflict of interest. Cautious attorneys always avoid concurrent representation of opposing parties in the same litigation. 2. Two concurrent clients at odds in unrelated litigated matters. Next, we look at the second example of concurrent representation, where the two concurrent clients would be at odds in unrelated litigated matters. In most states, an attorney would be disqualified from representing two current clients who are litigating each other in unrelated cases. Hence, in the second example, Alice Sander Esquire cannot represent Isaac in their negligence case against Marta and simultaneously represent Marta against Isaac in the unrelated custody case. Furthermore, in most states, even the consent of both Isaac and Marta will not be sufficient to allow Sander to represent them both at the same time, simultaneously in the two cases. In the negligence case, Sander must be a loyal advocate for Isaac against Marta. Simultaneously, Sander would have to be a loyal advocate for Marta against Isaac in the custody case. If Sander says yes to Marta's request that Sander represent Marta against Isaac in the custody case, Isaac would have legitimate reason to question Sander's undivided loyalty, even though the custody case may have nothing to do with the negligence case. 3. Two current clients are co-plaintiffs or co-defendants in the same litigated matter. Next, we look at the third example of concurrent representation where the two current clients would be co-plaintiffs or co-defendants in the same litigated matter. In most states, an attorney can represent co-plaintiffs or co-defendants in the same litigated matter if the following four conditions are met. The attorney reasonably believes they can provide competent and diligent representation to both co-plaintiffs. If the two current clients are suing in the same case or to both co-defendants. If the two current clients are being sued in the same case. The clients will not be asserting claims against each other. There is no special law that prohibits the concurrent representation. The clients give written informed consent to have the attorney represent both of them. Model Rule 1.7b. Written informed consent requires an explanation by the attorney of the risks and as well the benefits of allowing the attorney to both clients. In the third example, can Walt Francis Esquire meet all four conditions in order to be able to represent Adina and Kelvin as co-plaintiffs in their negligence suit against Harry the truck driver? The answer is not clear-cut. Suppose, for example, that the evidence shows that Kelvin was negligent in driving their car at the time the truck hit the car. This may give rise to a claim for damages by Adina against Kelvin. Also, if Adina is called as a witness, some of their testimony might be unfavorable to Kelvin. Hence, Walt may not be reasonable in concluding that they can give competent and diligent representation to both co-plaintiffs. If they cannot, the conflict of interest disqualifies them from providing the concurrent representation to the co-plaintiffs. The same analysis would apply to two persons being sued as co-defendants in the same litigated matter. 4. Two current clients on the same side in a negotiation or in a transactional matter not involving litigation. Finally, we look at the fourth example of concurrent representation where the two current clients would be on the same side in a negotiation or transaction not involving litigation. Leon Thomas Esquire has been asked by Dan and Charles to draft a cohabitation agreement for them. Both would be his clients in providing the transactional service of writing their contract. Can he do so ethically? The answer depends of the same four conditions mentioned earlier. Leon must reasonably believe he can give competent and diligent representation to Dan and Charles. These clients must not be asserting claims against each other. There must be no special law against the concurrent representation, and the two clients must give written informed consent to the concurrent representation. The likelihood is that these conditions can be met so that Thomas can draft the agreement. The same conclusion would apply if the attorney were hired to negotiate the agreement between Dan and Charles, and someone else drafted it or they drafted it themselves. 6-17C. Successive representation. In successive representation, an attorney represents a current client who opposes a former client of this attorney. Example: Diane Smithson is a former client of Ron Sullivan, Esquire, a sole practitioner. Sullivan once represented Smithson in an antitrust matter against General Motors. Several years after this case was concluded, Smithson has a legal dispute with Walmart. Smithson hires a different attorney, Paul Foley, Esquire, at a different law firm to represent her in the Walmart case. Walmart wants to hire Ron Sullivan to represent them against Smithson in the case of Smithson versus Walmart. Smithson is a former client of Ron Sullivan. Smithson now has a legal case against Walmart, which wants to hire Sullivan, in this case against Smithson. A former client would become an adversary. Can Sullivan represent Walmart against a former client? The answer depends on the kind of dispute that Smithson has with Walmart. 3 possibilities exist. 1. The matter or case between Smithson and Walmart is the same matter or case that Smithson had in the earlier case with General Motors. The 2 cases are the same even though the parties are not the same. 2. The matter or case between Smithson and Walmart is substantially related to the matter or case that Smithson had in the earlier case with General Motors. The 2 cases are not the same, but they are substantially related even though the parties are not the same. 3. The matter or case between Smithson and Walmart is totally different from the matter or case that Smithson had in the earlier case with General Motors. In the third situation, Ron Sullivan is allowed to represent Walmart against his former client, Diane Smithson. In the first 2 examples, however, Sullivan cannot represent Walmart against Smithson unless Smithson agrees in writing to allow him to do so. The rule is as follows. Rule on successive representation conflicts. An attorney who once represented a client on a matter cannot later represent another against the former client in the same matter or in a substantially related matter unless the former client agrees in writing. Model Rule 1.9. Note the danger that exists in 2 cases involved in successive representation. In case number 1, when the attorney represented the former client, the attorney learned confidential information about the case. Now this attorney wants to represent a new client against the former client in case number 2. If case number 2 is the same or substantially the same as case number 1, the danger is that the attorney will use the confidential information learned in case number 1 against the former client in case number 2. This danger does not exist or is significantly less if case number 1 and case number 2 are totally different. (6-17D) Personal interest conflicts. The client's interest is to receive independent professional assistance from an attorney in order to resolve a client matter. Attorneys may have their own personal interests that interfere with this interest of the client. A personal interest is any goal or desire that the attorney may have in connection with a client, beyond providing and being paid for the agreed to legal services. A personal interest is any goal or desire that the attorney may have in connection with a client beyond providing and being paid for the agreed to legal services. Here are 4 examples of such personal interests. The first three are financial interests, and the fourth is an emotional interest. Entering a business transaction with the client, giving financial assistance to the client such as a loan, receiving a substantial gift from the client, entering a sexual relationship with the client. The conflict rules in these areas are designed to prevent overreaching, taking unfair advantage of another's nevate or other vulnerability, and undue influence.
Naivete.
The conflict rules in these areas are designed to prevent overreaching, taking unfair advantage of another's naivete or other vulnerability, and undue influence. Improper persuasion by the attorney. Let's look at how these objectives apply to the 4 conflicts involving an attorney's personal interest. Business transaction with a client. Clients and attorneys sometimes enter business transactions with each other. Example, Jeanette Bruno Esquire is Len Oliver's attorney. Oliver owns an auto repair business for which Bruno has done legal work. Oliver sells Bruno a 30% interest in the repair business. Bruno continues as Oliver's attorney. Conflict of interest problems may exist in this example. Assume that the business runs into difficulties and Oliver considers bankruptcy. Oliver goes to Bruno for legal advice on bankruptcy law. Bruno has dual concerns: to give Oliver competent legal advice and to protect their 30% interest in the business. Bankruptcy may be good for Oliver, but disastrous for Bruno's investment. How can an attorney give a client independent professional advice when the advice may go against the attorney's own interest? Bruno's concern for their investment creates the potential that Oliver will be placed at a disadvantage. Divided loyalties exist. This is not to say, however, that it is always unethical for an attorney to enter a business transaction with a client. If strict conditions are met, the transaction is ethical. The conditions are as follows. The terms of the transaction are fair and reasonable to the client. The client is given a written description of the terms of the transaction. The attorney tells the client in writing that the client should seek the advice of another attorney on whether it is wise for the client to enter the transaction. The client is given sufficient time to seek this additional advice. The client gives informed consent in writing to enter the transaction. In our example, Oliver must be advised to and be given sufficient time to consult with an attorney other than Bruno on letting Bruno buy a 30% interest in the business. Bruno would have to give Oliver a clear written explanation of their business relationship, which must be fair and reasonable to Oliver. Model Rule 1.8a. Financial assistance to a client. Attorneys, like all service providers, want to be paid. Often, however, a client does not have the resources to pay until after the case is over. Example, Harry Maxwell Esquire is Bob Smith's attorney in a negligence action in which Smith is seeking damages for serious injuries. While the case is pending, Maxwell agrees to lend Smith living expenses and court filing fees. The loan will be repaid if Maxwell wins the case. A debtor-creditor relationship now exists between Smith and Maxwell in addition to their attorney-client relationship. The loan covered 2 times living expenses and court filing fees. The ethical rule is different for each item. The financial assistance for living expenses is unethical. Suppose that the defendant in the negligence case makes an offer to settle the case with Smith. Should Maxwell accept the offer? There is a danger that Maxwell's advice on the offer will be colored by the fact that they have a financial interest in Smith, wants to have the loan repaid. The amount of the offer to settle may not be enough to cover the loan. Should Maxwell advise Smith to accept the offer? Accepting the offer may be in Smith's interest, but not in Maxwell's interest. Such divided loyalty is an unethical conflict of interest. Furthermore, the rule against providing this kind of financial assistance is designed to discourage attorneys from stirring up litigation by financing it. The loan covering litigation expenses such as filing fees and other court costs is treated differently. Such loans are ethical. In our example, Maxwell's loan covering the cost of the filing fees to be repaid if they win the case is proper. Furthermore, if Harry is a person with little income, indigent, it is ethical for the attorney to pay litigation expenses without asking for repayment. Model Rule 1.8e. Analyze this. An attorney's client has been charged with using government funds improperly in a construction project. The indictment states that the client inflated the contract price in the amount of $400,000. The government wants repayment of the funds. The attorney loans the client the $400,000 to pay back the government funds. Does a conflict of interest exist? Explain your response. Gifts from a client. An attorney must not solicit substantial gifts from clients who are not related to the attorney. Substantial gifts can be accepted if offered by the client, but they cannot be asked for solicited. Suppose, however, that the idea of the gift to the attorney or to a member of the attorney's family comes from the client. It is not solicited. Such gifts can be accepted, although this attorney cannot prepare any document that may be needed to complete the gift. Example: William Stanton Esquire has been the family attorney of the Tarkenton family for years. At Christmas, Miss Tarkenton gives Stanton an expensive computer and says to change the will so that Stanton's 10-year-old daughter would receive funds for a college education. If a document is needed to carry out the gift, it is unethical for the attorney to prepare that document. Its preparation would create a conflict of interest in our example. The gift of money for college involves a document, Miss Tarkenton's will. Note the conflict. It would be in Miss Tarkenton's interest to have the will written so that a set or maximum sum is identified for this gift, as well as a cutoff date for its use. Stanton, on the other hand, would probably want the will drafted so that there is no maximum amount stated and no cutoff date. Stanton's daughter may one day want to go to graduate school. If the language of the will is vague and if no time limits are inserted, an argument could be made that the gift covers both undergraduate and graduate work. Other questions could arise as well. Does the gift cover room and board at college? What if the daughter does not go to college until after marrying and raising children? It is in Stanton's interest to draft the will to benefit the daughter under all these contingencies. This may not be in Miss Tarkenton's interest. Because of this conflict, an attorney cannot prepare a document such as a will, trust, or contract that results in any substantial gift from a client to the attorney or to the attorney's children, spouse, parents, or siblings. If a client wants to make such a gift, another attorney who is not part of the same law firm must prepare the document. There is, however, one exception. If the client donor is related to the person receiving the gift, the attorney can prepare the document. In our example, there is no indication that the donor, Miss Tarkenton, is related to the attorney or to the attorney's daughter. Therefore, there does not appear to be any ethical problem in taking the gift of the computer from Miss Tarkenton. No documents are involved. Model Rule 1.8c. Paralegal perspective. Can a paralegal accept a substantial gift from a client, like for example a Christmas present, a trip, or other business, or Can a paralegal accept a substantial gift from a client, like, for example, a Christmas present, a trip, or other bonus from a client who just won a big judgment? First of all, never consider accepting gifts from clients unless your supervising attorney approves. Considerations of which you are unaware may make the gift inappropriate. Considerations of which you are unaware may make the gift inappropriate. Suppose, however, it is approved, but the gift involves the preparation of a document which the attorney prepares, though technically not the same as attorneys preparing the document for a gift to their spouses or children. The similarities certainly create an appearance of impropriety, and a court might rule that your supervising attorney should not prepare it. Analyze this. To say thank you for a job well done, a client gives you 2 tickets to the Broadway show Hamilton. The tickets are located in the center orchestra section. Can you accept the tickets from the client? Explain your answer. Sexual relations with a client. One of the more dramatic examples of a conflict of interest is the attorney who develops a romantic relationship with a current client. Particularly, a sexual relationship. Clients often come to an attorney when they are emotionally vulnerable. Under such circumstances, it is unconscionable. It is unconsignable.
Unconscionable.
Under such circumstances, it is unconscionable for the attorney to take advantage of this vulnerability. An attorney with an emotional interest in a client will be looking for ways to increase that interest and to inspire a reciprocal interest from the client. Needless to say, this may not be what the client needs. The attorney's own need could well cloud their ability to put the client's welfare first. The ABA model rules prohibit sexual relations between attorney and client, even if consensual, unless the sexual relationship began before the attorney-client relationship began. Model Rule 1.8J. Some states have variations of this rule. In Florida, for example, sexual conduct is prohibited only if it can be shown that the conduct exploits or adversely affects the client. Florida Rules 4-8.4I. If the relationship began after the Florida attorney was hired, there is a presumption that the relationship was exploitative. The attorney must overcome the presumption by proving otherwise. Quick tip, don't do it. Don't even consider it. Do not ever have a sexual relationship with a client. Other personal interests. Do you think the attorneys in the following cases have a conflict of interest? An attorney who is gay represents a parent seeking to deny custody to the other parent because the latter is gay. An attorney who believes abortion is immoral works on a case where the client is Planned Parenthood. An attorney whose father was murdered 10 years ago represents a client charged with murdering their partner. An attorney who is opposed to the death penalty is the prosecutor on a case where the state has asked for the death penalty. The likelihood is that the personal feelings of these attorneys will affect how vigorously, zealously they will work on behalf of their client. Because of those feelings, it can be argued that they have a bias, which is an inclination, a tendency, or a predisposition to think and to act in a certain way. Clients are entitled to zealous representation, even if the character or cause of the client is unpopular. Attorneys are encouraged to provide representation to such individuals, yet attorneys are not obligated to take every case. Indeed, attorneys should avoid representing someone whose character or cause the attorney regards. Indeed, attorneys should avoid representing someone whose character or cause the attorney regards as so repugnant that the attorney's ability to represent the client zealously is in serious doubt. Model Rule 6.2. At one time, attorneys in New York State were explicitly cautioned to decline employment if the intensity of personal feelings may impair effective representation of a prospective client. We will return to the topic of bias in Chapter 12. 6-17E. Positional conflicts. A positional conflict exists, 1. If an attorney asserts inconsistent legal positions while representing two current clients in separate, unrelated cases, and 2. If success on behalf of a client in one case will harm or disadvantage a client in the other case. 2. If success on behalf of a client in one case will harm or disadvantage a client in the other case, an attorney must avoid positional conflicts unless both clients in writing allow the attorney to assert the inconsistent positions. Model Rule 1.7, Comment 24. Example, Case number 1. Diane Bryant, Esquire, represents Mary Thompson, who wants Statute 23C declared unconstitutional. In court, Bryant argues that it is unconstitutional. Case number 2. In a separate, unrelated case, Bryant is asked to represent a supplier, Ed Anderson, who would lose substantial business if Statute 23C is declared unconstitutional. In this case, Bryant would have to argue to the court that Statute 23 is constitutional. In this example, Bryant should not agree to represent Ed Anderson. Winning the case is likely to harm or disadvantage Mary Thompson. If both clients agree in writing to allow Bryant to argue these inconsistent positions in the two cases, Mary can do so. If, however, neither client would be harmed or disadvantaged by the inconsistent legal positions, the attorney would not need their consent to argue the positions in the two cases. 6-17F. Third-person conflicts. Sometimes an attorney's fee is paid by a non-client. Example, John Adamson is sued by a landlord for violating the lease on their apartment. Alice Toomey, Esquire, represents John. The company where John works, Towers Incorporated, agrees to pay Alice's fees for John. It can be ethical for Alice Toomey to accept payments from Towers, so long as it is clear that their loyalty is to John, not to Towers. Furthermore, 1. John must give written informed consent to allow Towers to pay the fees. 2. Towers must not interfere with Alice's representation of John. And 3. Alice must not tell Towers anything about the case that would violate John's right of confidentiality. Model Rule 1.8F. 6-17G, vicarious conflicts. When one person causes a conflict of interest in a law office, that person is said to be tainted. When one person causes a conflict of interest in a law office, that person is said to be tainted. This most often arises in successive representation conflicts where the attorney seeks to represent a current client against a former client. This conflict taints the attorney and may taint the entire law office, so that no attorney in the office can represent the current client against the former client unless the former client agrees to allow the representation. Example: 2 years ago, John Farrell, Esquire, of the law firm of Smith & Smith, represented the stepfather in a custody dispute with the child's aunt, who represented themselves in the case. The stepfather won the case, but the aunt was awarded limited visitation rights. The aunt now wants to sue the stepfather for failure to abide by the visitation order. John Farrell no longer represents the stepfather. The aunt asks John Farrell to represent her. He declines because of a conflict of interest, successive representation, but sends the aunt to a law partner, Diane Williams, Esquire, down the corridor at Smith & Smith. Down the corridor at Smith & Smith. In this example, John Farrell is tainted. John would have a conflict of interest if they tried to represent the aunt against a former client, the stepfather. The two cases involve the same matter, the custody and visitation of the child. When an attorney has a successive representation conflict such as this one, every other attorney in the firm is also tainted unless the former client consents to allow the representation. Hence, Diane Williams, Esquire, is disqualified from representing the aunt against the stepfather unless the stepfather consents to allow Williams to represent the aunt against them. Diane Williams has a vicarious conflict, which is a conflict that exists solely because of someone else's conflict. If a vicarious conflict causes a disqualification, the disqualification is called a vicarious disqualification. If the stepfather does not consent to Diane Williams' representation of the aunt, then Williams is vicariously disqualified from representing the aunt because of John Farrell's actual conflict that would prevent them from representing the aunt. A vicarious disqualification is also called an imputed disqualification. Imputed simply means attributed to. John Farrell's conflict is attributed to Diane Williams. His disqualification is an actual disqualification. If the stepfather does not agree to allow Diane Williams to represent the aunt against the stepfather, then Williams' disqualification is an imputed or vicarious disqualification. 6-17H, migratory conflicts. Finally, we examine migratory conflicts, which exist when an attorney who has a conflict switches jobs and brings the conflict with them to the new job, potentially disqualifying every attorney at the new job. Example, Law Office 1. At Law Office 1, Jim Peters, Esquire, represents Sue Fisher in the case of Fisher v. Dooley. During the representation, Peters learns confidential information about Fisher. Law Office 2. Peters quits Law Office 1 and joins Law Office 2. One of the clients of Law Office 2 is Adamson, who is suing Fisher in Adamson v. Fisher, a case that is substantially related to the case of Fisher v. Dooley. This job switch raises two conflicts questions. First, can Jim Peters at Law Office 2 represent Adamson against Fisher in the case of Adamson v. Fisher? No. See the earlier discussion of when successive representation is not allowed. Second, can another attorney at Law Office 2 represent Adamson against Fisher in the case of Adamson v. Fisher? The second question asks whether every attorney in Law Office 2 is vicariously disqualified from representing Adamson because of the actual conflict that the tainted attorney, Jim Peters, brought to the office. In many states, there are two possible ways to avoid disqualification: consent and screening. Avoiding disqualification through consent. Consent can avoid vicarious disqualification due to a job switch. In our example, Sue Fisher can be asked if they agree to allow an attorney in Law Office 2 to represent Adamson against them in the case of Adamson versus Fisher. Sue's new attorneys will probably advise them not to give such consent because of the perceived likelihood that Peters will reveal or has already revealed confidential information about Fisher to other attorneys at Law Office 2. Avoiding disqualification through screening. Another possible method of avoiding vicarious disqualification because of a job switch is by screening the attorney from the case in order to eliminate the possibility that the tainted attorney will reveal confidential information to other attorneys in the law office. Screening consists of steps taken by a law office to isolate a tainted worker from involvement in a case. Not all states, however, allow screening of attorneys as a way to avoid disqualification. If a state does not allow attorney screening and if the client at Law Office 1 does not consent, then every attorney at Law Office 2 is disqualified from representing that client. As we will see in the paralegal perspective, a job switch by a paralegal can also cause imputed disqualification. To avoid disqualification when a paralegal switches jobs, consent and screening can be used in most states. More states are willing to allow screening to avoid disqualification when a paralegal switches jobs than when an attorney switches jobs. Paralegal perspective. Introduction. Paralegals and other non-attorney employees can create conflicts that disqualify a law office from representing a particular client. This occurs most often because of the non-attorney's prior employment. Example, Ted Warren is a paralegal who works for Mary Winter Esquire. Winter represents Apple in the case of Apple versus IBM. Ted has substantial paralegal responsibilities on this case. While this case is still going on, Ted switches jobs and goes to work for Quinton and Orrin, which represents IBM in the litigation with Apple. Ted is tainted because they bring a conflict of interest to the firm of Quinton and Orrin. While Ted worked for Mary Winter, they obviously acquired confidential information about Apple. There are pressures on Ted to tell the attorneys at Quinton and Orrin what he knows about Apple so that they can use the information to the advantage of their client, IBM, in the litigation against Apple. A paralegal's personal interests can also create conflicts. One law firm makes the following statement to all its paralegals. If you or a temporary paralegal working under your supervision were formerly employed by opposing counsel, this could be the basis for a motion to disqualify this law firm. So also could personal relationships such as kinship with the opposing party or attorney, or dating an attorney from another firm. Make your attorney aware of such connections. Similarly, a New Mexico court rule provides the following caution to attorneys. A lawyer is responsible to ensure that no personal, social, or business interest or relationship of the paralegal impinges upon or appears to impinge upon the services rendered to the client. If a lawyer accepts a matter in which the paralegal may have a conflict of interest, the lawyer will exclude that paralegal from participation in any services performed in connection with that matter. Furthermore, the lawyer must specifically inform the client that a non-lawyer employee has a conflict of interest, which was the lawyer's conflict. Furthermore, the lawyer must specifically inform the client that a non-lawyer employee has a conflict of interest, which was the lawyer's conflict would prevent further representation of the client in connection with the matter. The nature of the conflict should be disclosed. The lawyer will caution the paralegal to inform the lawyer of any interest or association which might constitute or cause such a conflict. or which might give the appearance of constituting or causing such a conflict. In addition, no interest or loyalty of the paralegal may be permitted to interfere with the lawyer's independent exercise of professional judgment. Avoiding imputed disqualification. As we have seen, there are two ways that conflicted law offices try to avoid imputed disqualification due to tainted attorneys or tainted paralegals whose job switch creates a conflict of interest. Client consent and screening. Consent will work to prevent imputed disqualification when the tainted person is an attorney or a paralegal. Screening, however, will work in most states when the tainted person is a paralegal, but in some states will not work if the tainted person is an attorney. Avoiding imputed disqualification by client consent. The cleanest way a law office can avoid imputed disqualification is to try to obtain the consent of the party who has the most to lose, the party whose confidentiality is in jeopardy. In most cases, the consent of this person will avoid disqualification. Example, in the Ted Warren example, Apple would have to be asked to consent to the continued representation of IBM by Quinton and Orrin, where Warren now works. Avoiding imputed disqualification by screening. Screening consists of steps taken by a law office to isolate a tainted worker, attorney, paralegal, or other non-attorney employee from involvement in a case in order to avoid vicarious or imputed disqualifications of the office from representation of a client in that case. The screen is known as an ethical wall, sometimes called a cone of silence. It is built around the tainted worker who brought the conflict of interest into the office. They become the quarantined worker to a rigid isolation from anything to do with the case that prompted the conflict. To wall a person means to screen them in an effort to avoid disqualification. The components of screening are outlined in Exhibit 6-7. Exhibit 6-7. Components of comprehensive screening. The following are the most effective guidelines a law office can follow to screen a tainted worker, like, for example, attorney, paralegal, investigator, secretary, or other non-attorney who brings a conflict of interest to the office. The goal is to avoid vicarious imputed disqualification by isolating the worker from the case in which they have caused the conflict of interest. 1. The screening begins as soon as the tainted worker arrives at the office. 2. At this time, or soon after, the office notifies the opposing party's attorney that the tainted worker has been hired and that comprehensive screening has begun. 3. The office notifies its own client of the screening and the reason for it. 4. The tainted worker signs a statement promising not to discuss what they know about the case with anyone in the office. 5. Those working on the case in the office promise not to discuss it with or in the presence of the tainted worker. 6. A written notice is sent to everyone else in the office that identifies the tainted worker and the client's case file in question. Everyone in the office is told not to discuss any aspect of the case with the tainted worker. 7. The tainted worker will not be assigned to work with any untainted attorney, paralegal, secretary, or other staff member who is handling the case in question. 8. Others not working on the case in the office are told that if they learn anything about the case, they must not discuss it with the tainted worker. 9. The receptionist and mail handlers are instructed not to forward anything about the case to the tainted worker. 10. The desk of the tainted worker is in an area that is physically segregated from work on the case in the office. This area is designed to avoid inadvertent access to the case file. 11. The file is removed from the central computer system to which everyone has access or is placed in a separate database. to which the tainted worker does not have access. The tainted worker is not given the password that grants access to the restricted file. 12. The paper file of the case is locked in cabinets or other storage facilities to which the tainted worker does not have access. 13. Colored labels or flags are placed on each document in the file to indicate it is off limits to the tainted worker. For example, a sticker might say, "Access restricted. Do not discuss this case with name of conflicted tainted worker." 14. The tainted worker will not directly earn any profits from, participate in, the fees of, or obtain any other financial gain from the case. 15. The firm documents all of the above steps that are taken. This documentation will become evidence if ever needed to help rebut an allegation that the tainted worker had any contact with the file. In Phoenix Founders Incorporated v. Marshall, 887 Southwest 2D 831834 TEX 1994, a Texas paralegal worked on a case at one firm and then switched jobs to work for opposing counsel on the same case. The court said that if a paralegal does any work on a case, there is a conclusive presumption that they obtained confidences and secrets about that case. There is also a presumption that the paralegal shared this information with the new firm, but this is a rebuttable presumption. It is not conclusive. See Exhibit 6-A. The presumption can be rebuted by showing that the new firm took sufficient precautions to guard against any disclosure of confidences. Through an ethical wall at the new firm, the newly hired paralegal should be cautioned not to disclose any information relating to the representation of a client of the former employer. The paralegal should also be instructed not to work on any matter on which the paralegal worked during the prior employment, or regarding which the paralegal has information relating to the former employer's representation. Additionally, the new firm should take other reasonable steps to ensure that the paralegal does not work in connection with matters on which the paralegal worked during the prior employment. The Phoenix Founders case said that disqualification will always be required in 3 circumstances, unless the former client consents to allow the paralegal to continue working at the new firm. 1. When information relating to the representation of an adverse client is disclosed by the tainted paralegal at the new firm. 2. When screening at the new firm would be ineffective. Or 3. When the tainted paralegal necessarily would be required to work on the other side of a matter that is the same as or substantially related to a matter on which the paralegal worked at the prior firm. Exhibit 6-8, Presumptions when a paralegal switches jobs. If any of these 3 circumstances apply, disqualification is mandatory. Paralegal does same work on the case at the first office. This creates an irrebuttable, conclusive presumption that the paralegal obtained confidential information about the case of the first office. It also creates a rebuttable presumption that the paralegal revealed the confidential information at the second office. In another major case, a paralegal caused a San Francisco law firm to be disqualified from representing 9 clients in asbestos litigation involving millions of dollars. The sole reason for the disqualification was that the firm hired a paralegal who had once worked for a law firm that represented the opponents in the asbestos litigation. Soon after the controversy arose, the disqualified firm laid off the tainted paralegal who brought this conflict to the firm. He was devastated when he found out that he was being let go. I was flabbergasted, totally flabbergasted. He has not been able to find work since. The case was widely reported throughout the legal community. A front page story in the Los Angeles Daily Journal said it could force firms to conduct lengthy investigations of paralegals and other staffers before hiring them. Many paralegals change jobs during their careers. The market for experienced paralegals is outstanding. Bar associations realize that an overly strict disqualification rule could severely hamper the job prospects for such paralegals. According to the American Bar Association, it is important that non-lawyer employees have as much mobility and employment opportunity as possible, consistent with the protection of clients, particularly the protection of client confidentiality. Although such statements from the American Bar Association are comforting, the reality is that tainted paralegals are in a very vulnerable position. Many offices terminate the tainted paralegal who caused the conflict, rather than take the risk that an ethical wall built around this paralegal will be judged too little and too late. The office will probably take the safer course and let the paralegal go. Career client lists. When you apply for a job, the prospective employer will want to know whether you might bring a conflict of interest to the office if hired. In short, they want to know if you would contaminate the office. To find out, they must ask you questions about cases you may have worked on in prior jobs or volunteer experiences. You need to compile your own career client list. As soon as you start working in a law office in any role, like for example paralegal, secretary, or investigator, as a volunteer employee or independent contractor, the list should have 5 columns consisting of the names of all the parties involved in each case or matter, the name of the office, the names of the attorneys on both sides, the dates of your involvement, and a brief description of your role. See Exhibit 6-9. When you apply for a new job, your list will be relevant to whether the law firm will be subject to disqualification if you are hired. If you are unable to produce the list, a contentious office might refuse to hire you on that basis alone, rather than take the risk of finding out later that your prior work created a conflict of interest that could have been identified when you were initially considered for employment. Once you have the list, be very careful. Its contents contain confidential information. Do not attach it to your resume and randomly send it around town. Until employment discussions have become serious, do not show it to the prospective employer. Exhibit 6-9, Career Client List. To help determine whether you might create a conflict of interest, keep a confidential list covering the following information for every law office in which you worked or volunteered from the beginning of your career to your current position. Tainted by association. Assume that an attorney in the office is tainted and that the state allows screening to prevent disqualification. Paralegals who work closely with the attorney would probably have to be screened as well. It wouldn't make sense to prevent an attorney from having contact with a particular case, but allow their paralegal to have such contact. The paralegal, in effect, would become tainted by association. Freelance or independent paralegals who work for more than one law office on a part-time basis are particularly vulnerable to conflict of interest charges. For example, in a large case in litigation involving many parties, 2 opposing attorneys might unknowingly use the same independent paralegal to work on different aspects of the same case, or might use 2 different employees of this independent paralegal. Another example is the independent paralegal who worked on an earlier case for a client and now works on a different but substantially related case in which that client is the opponent. Attorneys who use freelance or independent paralegals therefore must be careful. The attorney cannot simply turn over work and be available to answer questions. At a minimum, the attorney must make inquiries about this paralegal's prior client At a minimum, the attorney must make inquiries about this paralegal's prior client's casework for other attorneys in order to determine whether there are any conflicts. (6-17I) Conflicts checks. How does a law office determine whether any of its attorneys, paralegals, or other employees have a conflict of interest with a prospective client? The law office does a conflicts check. To perform this check, the office needs a comprehensive database containing information such as the following about every former and present client of the office: names of clients, plus any aliases or earlier names before marriage. All names should be checked under varying spellings of the same person or entity. Names of spouses of clients, names of children of clients, names of key employees of clients, including the chief executive officers and directors of corporate clients, names of major shareholders in companies in which the client has an interest, name of parent and subsidiary corporations affiliated with the client, plus their chief executive officers and directors, names of members of relatively small associations in which the client has a role. Some categories of information can be difficult for the office to obtain. For example, whether an employee in the office holds stock in the company of the adversary of a prospective client, whether a spouse, relative, or intimate friend of an employee in the office is employed by or holds stock in the company of the adversary of a prospective client, whether an employee in the office is related to or has had a romantic relationship with the adversary of a prospective client or with anyone in the law office that represents the adversary. To discover this kind of information, the office usually must rely on its employees to come forward and reveal such connections. Some of the data a law firm needs for a conflict check may be found in the conflicts section of the new file worksheet that the office fills out when it begins working with a new client or with a new matter of a current client. See the conflicts section on the new file worksheet in Chapter 5. Large law firms sometimes hires paralegals to go through the office's electronic files to try to identify conflict problems that must be addressed by senior attorneys in the office. These paralegals are called conflicts specialists, also conflicts analysts, and conflicts researchers. Detailed conflicts information is also needed when the office is thinking about hiring a new attorney or paralegal from another office, called a lateral hire. To determine whether they might have a conflict, the office should check the names of the prior. To determine whether they might have a conflict, the office should check the names of the parties in their prior casework against the office's current and prospective clients. See Exhibit 6-9, detailing the career client list that a paralegal should have available when a prospective employer is considering the paralegal for employment. When a law office applies for malpractice insurance, the insurance carrier will often inquire about the system the office uses for conflicts checks. The insurance carrier also may want to know how conflicts are checked if the law office has merged or proposes to merge with another law office. If, for example, the ABC law firm merges with the XYZ law firm, a new group of tainted people may now exist because of the prior and current caseloads of the two firms. Finding out can be a huge undertaking because of the potentially thousands of cases on which the attorneys and paralegals of the two firms have worked or are working. Most litigation support and database management software, see Chapter 11, have conflicts checking functions that enable a law firm to comb through the law firm's databases to find possible conflicts. See Exhibit 6-10 for an example. Remember, one of the first things a law firm will do in deciding to take on a new case or client is to perform a conflicts check, which shows the importance of a conflicts check. Exhibit 6-10. Example of conflicts checking by computer. Six 18 Communication with the other side. If you know that an opponent is represented by an attorney, you must not contact the opponent about the dispute unless the opponent's attorney consents to the contact. Model Rule 4.2. If you have contact with an opponent who does not have an attorney, you must not give the impression that you are uninvolved, disinterested in the dispute, and you must not give legal advice to the unrepresented opponent other than to obtain their own attorney. Model Rule 4.3. If an opposing party is represented by an attorney, the permission of the party's attorney is needed to communicate with that party concerning the subject of the case. An unrepresented opposing party must not be misled into thinking that you are disinterested, meaning that you are neutral or uninvolved in the case. You are not disinterested if you work for one of the parties in the dispute. The only advice you can give unrepresented opposing parties is to obtain their own attorney. The anti-contact rule requires an attorney to avoid communicating with an opposing party unless the latter's attorney consents. The ethical concern here is overreaching, taking unfair advantage of another's naivete or other vulnerability, especially by deceptive means. Example, Dan and Teresa Klein have just separated and are thinking about a divorce. Each claims the marital home. Teresa hires Thomas Farlington, Esquire, to represent them. Farlington calls Dan to ask they would like to settle the case. It is unethical for Farlington to contact Dan about the case if Farlington knows that Dan has their own attorney. Farlington must talk with Dan's attorney. Only the latter can give Farlington permission to communicate with Dan. If Dan does not have an attorney, Farlington can talk with Dan, but must not allow Dan to be misled about Farlington's role. Farlington works for the other side and is not disinterested. Dan must be made to understand this fact. The only advice Farlington can give Dan in such a situation is to obtain their own attorney. A related communication rule is that an attorney should not communicate with the court in the absence of the attorney for the other side. Such ex parte communications are forbidden unless specifically authorized by law. Analyze this. You work with a human resources director from another firm on numerous cases. Years ago, they sued their former employer, and your firm represented the employer. The director was represented by counsel. The case has been dormant for years, and you just received from the court a notice of status conference on the matter. You pick up the telephone to see if they will be attending the status conference and continue pursuing the case. Is that contact proper? Defend your response. Paralegal perspective. The ethical restrictions on communicating with the other side apply to the employees of an attorney as well as to the attorney. The ethical restrictions on communicating with the other side apply to the employees of an attorney as well as to the attorney. The lawyer's obligation is to ensure that paralegals do not communicate directly with parties known to be represented by an attorney without that attorney's consent on the subject of such representation. If the other side is a business or some other large organization, do not talk with anyone there unless your supervisor tells you that it is ethical to do so. Never call the other side and pretend you are someone else in order to obtain information. See the earlier discussion on fraudulent friending, pretexting, and other misuse of social media. If your office allows you to talk with an opponent who is not represented by an attorney, you cannot give this person any advice other than the advice to secure his or her own attorney. 6-19 Solicitation. In-person, live telephone, or real-time electronic solicitation of clients is unethical if a significant reason for the solicitation is to seek fees or other financial benefit, unless the contact is with A, another attorney, or B, someone with whom you have a family, close personal, or prior professional relationship. Written, recorded, or standard, not real-time, electronic solicitation of clients is ethical unless A, the attorney knows that the prospective client does not want to be solicited, or B, the solicitation involves coercion, duress, or harassment. Solicitation, when permitted, must not contain untruthful or misleading statements. Model Rule 7.3. People in distress are sometimes so distraught that they are not in a position to evaluate their need for legal services. They should not be subjected to pressures from an attorney who wants to be hired, particularly if the attorney is not a relative, close friend, or has never represented them in the past. Such in person, i.e. important example face-to-face. Such in-person solicitation of clients is unethical if the attorney has a monetary, pecuniary, or other financial goal, such as generating fees. Example, Rebecca Winters, Esquire, stands outside the police station and gives a business card to any individual being arrested. The card says that Winters is an attorney specializing in criminal cases. Winters is obviously looking for prospective clients. Doing so in this manner is referred to as ambulance chasing, which is a pejorative term for aggressively tracking down anyone who probably has a legal problem in order to drum up business. There is no indication that Winters is related to or is good friends with any of the people going into the police station, or that they have any prior professional relationship with them. Like, for example, they are not former clients. Winters appears to have one goal: finding a source of fees, hence their conduct is unethical. In-person or live telephone solicitation of clients in this way is not allowed. The same would be true if Winters contacted these individuals through real-time electronic communications, such as in an online chat room. See Chapter 11 for more on real-time communication. The concern is that an attorney who contacts potentially vulnerable strangers in these ways may use undue pressure to sign them up as clients. Undue pressure is likely to occur if the solicitation is in writing, like, for example, through the mail, a recorded telephone message, or a standard non-real-time electronic contact, like, for example, an email message. This is true even if the recipients are known to need legal services. Example, an attorney obtains the names of homeowners facing foreclosure and sends them the following letter: "It has come to my attention that your home is being foreclosed. Federal law may allow you to stop your creditors and give you more time to pay. Call my office for legal help." Although critics say that such solicitation constitutes ambulance chasing by mail, the technique is ethical in most states as long as the recipients have not made known to the attorney that they do not want to be solicited. The solicitation does not involve coercion, duress, or harassment, and the solicitation is truthful and not misleading. In person, live telephone, or real-time electronic solicitation, however, is treated differently because of the added pressure that it imposes. It is easier to throw out unwanted mail than an uninvited guest. Some states impose additional regulations on the solicitations that they allow. For example, the state may require the attorney to print the phrase advertising material on the outside of the envelope or at the top of an electronic message, and may prohibit all solicitations to victims and their relatives for a designated number of days after an accident or disaster for which the attorney is offering legal services. Some federal laws impose additional restrictions. For example, the Aviation Disaster Family Assistance Act provides that in the event of an air carrier accident, no unsolicited communication concerning a potential action for personal injury or wrongful death may be made by an attorney or by an employee of the attorney to an individual injured in the accident or to a relative of an individual injured in the accident before the 45th day following the date of the accident. See 49 U.S.C. Statute 1136G. 2. In extreme cases, client solicitation can constitute the crime of barratry. Barratry, the crime of stirring up quarrels or litigation, persistently instigating lawsuits, often groundless ones, the illegal solicitation of clients. In 1990, for example, 3 attorneys and an employee of a law firm were indicted in Texas. They were charged with illegally seeking clients at hospitals and funeral homes. Soon after, 21 students were killed and 69 others were injured in a tragic school bus accident. Online exercise. Determine your state's law on attorney solicitation of cases through 1. Telephone, 2. Mail, and 3. In-person communication. What practices are ethical and unethical? Are there sanctions for partaking in unethical practices? Are paralegals included in the prohibitions for solicitation of a client's case? Paralegal perspective. An unscrupulous attorney may try to use a paralegal to solicit clients inappropriately. Paralegals are subject to the same prohibitions on solicitation that govern attorneys, like, for example, no in-person drumming up of clients in order to earn fees for the office. Example, Bill Hill is a senior citizen who lives at home for senior citizens. Andrew Vickers, Esquire, hires Bill as their paralegal. Their sole job is to speak with other seniors to find out if they have any legal problems, and if they do, to refer them to Vickers. Andrew Vickers is engaging in unethical solicitation through Bill Hill. Attorneys cannot hire a paralegal to try to accomplish what they cannot do themselves. Bill Hill is making in-person contact in order to find paying clients for Vickers. This is unethical if none of these other seniors are attorneys, none are family members, and none have a prior professional relationship with the Vickers office. Attorneys must also avoid using a runner, an employee, or independent contractor who contacts personal injury victims or other potential clients in order to solicit business for an attorney. If this person uses deception or fraud in the solicitation, they are sometimes called a capper or steerer. An example would be someone who arranges for an unsuspecting motorist to be involved in a crash with another vehicle, whose driver, by prearrangement with the capper, flees after the collision. The capper then solicits the motorist to hire an attorney for purposes of filing an insurance claim. See also the earlier discussion of fees in which we covered. See also the earlier discussion of fees in which we covered the related topic of unethically splitting fees with a non-attorney, and the topic we will discuss shortly on paying someone to recommend the services of an attorney. 6-20 Advertising. Attorneys may advertise in the newspaper, on television, online, or through other media as long as the advertisements are truthful and do not mislead the public, such as by creating unjustified expectations of the results the attorney will be able to obtain. Model Rule 7.2. The advertisement must include the name and office address of at least one attorney or law firm responsible for its content. The main goal of advertising and solicitation is to obtain clients. The difference is that solicitation involves direct contact with prospective clients, whereas advertising is a broader attempt to draw attention to the legal services being offered. At one time, almost all forms of advertising by attorneys were prohibited. Traditional attorneys considered advertising to be highly offensive to the dignity of profession. In 1977, however, the U.S. Supreme Court in Bates v. State Bar of Arizona, 433 U.S. 350, 1977, stunned the legal profession by holding that truthful advertising cannot be completely banned. The First Amendment protects such advertising. Furthermore, advertising does not pose the same danger as in-person, live telephone, or real-time electronic solicitation by an attorney. A recipient of advertising is generally under very little pressure to buy the advertised product, the attorney's services. Hence, attorneys can ethically use truthful, non-misleading advertising to the general public. Hence, attorneys can ethically use truthful, non-misleading advertising to the general public in order to generate business. Attorneys spend millions of dollars every year on television advertising alone, most of it by personal injury (PI) attorneys trying to bring in accident cases that often involve high contingency fees and relatively quick settlements. Former U.S. Chief Justice Warren Burger commented that some attorney ads would make a used car dealership blush with shame. Proponents of attorney advertising, however, say that it has made legal services more accessible and has provided the public with a better basis for choosing among available attorneys. One of the major problems with advertising is that it can be misleading. Examples of misleading ads. Ad flyer states, "You pay nothing if we do not win your case." Problem. The ad may be misleading if the office requires its client to pay court costs and expenses even if it loses the case. Ad. Man in a wheelchair says Fenton and Adams can win $1 million. I can vouch for it. Problem. The ad may raise false expectations. A viewer of the ad may think the law office is saying that it can obtain the same result for the viewer. Ad. Newspaper box ad says, trust your case to a specialist. Problem. Some states have specialization certification programs for attorneys. If a particular state doesn't, calling oneself a specialist may be misleading. If it does, references to the specialty in ads usually must comply with specific regulations, like, for example, mentioning the full name of the specialty board that granted the specialty credential. Many law firms today have websites. Some firms pay search engines to have their sites appear high on the list of results of certain searches. For example, a law firm paid Google $56.24 for each click on a search for mesothelioma. That led to the firm's website. Google was paid this amount whether or not the searcher hired the firm. A mere click on the link triggered the payment. The firm was willing to pay Google such a high price because someone using this search term is likely to be looking for an attorney who handles cases of workers exposed to asbestos, a field of practice that can lead to unusually high attorney fees. Most law firm websites are designed to provide the public with general information about the firm, particularly the kind of legal services it offers. In addition, some of the firm's websites go into detail about an aspect of the law that is relevant to their practice. For example, a family law attorney might have several pages that list the grounds for divorce in the state or the steps to take to establish paternity. Large law firms may have elaborate websites that include pictures of attorneys in the firm and the names and email addresses of its attorneys. To avoid the charge that a law firm is practicing law online, a disclaimer will often be printed on the homepage informing readers that the site is not intended to establish an attorney-client relationship or to provide legal advice. The goal is to make clear that the site is simply advertising the firm. As such, it must meet the ethical requirements for advertising, like, for example, be truthful and not misleading. The disclaimer should also warn viewers that the laws of different states may differ, that the firm makes no representation, warranty, or claim that the information on the site is current or accurate, and that viewers should not rely on the information provided on the site without consulting local attorneys. There will often be an email address on the site that a viewer or prospective client can use to contact the firm. An attorney's response to such email messages should not contain legal advice, particularly to individuals who live in states where the attorneys in the firm are not licensed to practice law. Furthermore, the sender should be told in a disclaimer that the firm cannot maintain the confidentiality of any communications sent through the website, and until a conflicts check is made, the firm cannot agree to represent anyone. See also the earlier discussion in the chapter on forming an attorney-client relationship. Additionally, with the advent of social media, law firms and other legal entities use sites such as Facebook, X, Instagram, and others to advertise their services. Included as part of the advertising scheme are noted accomplishments of the firm, lists of prominent clients, and other information that would entice prospective clients to consider that law firm or legal entity's services. Using social media is not prohibited and is just another way the legal community utilizes existing sites to assisting. Using social media is not prohibited and is just another way the legal community utilizes existing sites to assist in advertising services and specialties to current and future clients. Paralegal perspective. In Chapter 1 and 4, we saw that many independent contractors sell law-related services directly to the public without attorney supervision. They are collectively known as document service providers, DSPs. A few states place restrictions on what such individuals can call themselves. In California, for example, they cannot call themselves paralegals or legal assistants in their advertising if they do not work under attorney supervision. Similar restrictions exist in a few other states, such as Maine and Florida. Another example of a DSP is the Bankruptcy Petition Preparer, BPP. A BPP is not allowed to use the word legal or any similar term in their advertising. Some courts have concluded that they cannot use the word paralegal. See Chapter 4. Online exercise. Research whether advertising is permitted by paralegals in your jurisdiction. If so, what is permitted and what is not permitted by your jurisdiction. Place that information in your portfolio binder. 6-21 Payment for referrals or recommendations. A lawyer shall not give anything of value to a person for recommending the lawyer's services. Model Rule 7.2b. An attorney cannot give compensation payments or anything of value for referring business to the attorney or for recommending the attorney. An attorney can pay a company for advertising the attorney's services, but not for referring clients to the attorney or for recommending that the attorney be hired. Recommending consists of endorsing or vouching for an attorney's credentials, abilities, competence, character, or other professional qualities. There is nothing wrong with people making recommendations or referrals, but they must not be paid cash or anything else of value for doing so. There is nothing wrong with people making recommendations or referrals, but they must not be paid cash or anything else of value for doing so. Paralegal perspective. Paralegals can recommend their law office to others, but the office cannot give paralegals a raise, a bonus, time off, or anything else of value for making such recommendations. 6-22 Reporting professional misconduct. Attorneys who know that another attorney has violated the ethical rules must report this attorney to the appropriate disciplinary body if the violation is serious enough to cast substantial doubt on the attorney's honesty, trustworthiness, or fitness to practice law. Model Rule 8.3 Attorneys may pay a price for remaining silent when they become aware of unethical conduct by other attorneys. The failure of an attorney to report another attorney may mean that both attorneys can be disciplined for unethical behavior. This is known pejoratively as the rat rule, the snitch rule, or more euphemistically,
euphemistically,
or more you. This is known pejoratively as the rat rule, the snitch rule, or more euphemistically, the whistleblower rule. Not every ethical violation must be reported. The ethical violation must raise a substantial question of the attorney's honesty, trustworthiness, or fitness to practice law, like, for example, finding out that another attorney has stolen client funds. Paralegal perspective. Suppose that a paralegal observes their supervising attorney committing fraud, stealing client funds, or using perjured testimony. Is the paralegal under an ethical obligation to report the offending attorney to the Bar Association or other disciplinary body? The National Federation of Paralegal Associations, NFPA, thinks so. In its Model Code of Ethics and Professional Responsibility, see Exhibit 6-4 and Appendix D. The obligation is stated as follows in EC-1.2F. A paralegal shall advise the proper authority of non-confidential knowledge of any dishonesty or fraudulent acts by any person pertaining to the handling of the funds, securities, or other assets of a client. The authority to whom the report is made shall depend on the nature and circumstances of the possible misconduct, like, for example, ethics committees of law firms, corporations, and/or paralegal associations, local or state bar associations, local prosecutors, administrative agencies, and etc. Failure to report such knowledge is in itself misconduct and shall be treated as such under these rules. As pointed out earlier, ethical rules written by paralegals are not binding in the sense that they affect the paralegal's right to work as a paralegal. A paralegal who violates EC A paralegal who violates EC-1.2F by failing to report their attorney to the Bar Association might be expelled from the Paralegal Association that has adopted NFPA's model code, but it is highly unlikely that this will affect their employment prospects so long as the paralegal has not participated in the unethical conduct. What should a conscientious paralegal do? Here are some guidelines. First and foremost, do not participate directly or indirectly in the unethical conduct. Second, consult with fellow paralegals in the office and in your local paralegal association. Without naming names and without breaching client confidentiality, find out how others have handled similar predicaments on the job. Third, go to a senior officer at the firm, like for example a partner, and let them know that the conduct you have observed is troubling you. In our facts at the beginning of the chapter, the paralegal knows that the supervising attorney has taken money from the client trust fund account. Based on the information, our paralegal must report the information to management, human resources, or outside sources. By not reporting the information, the paralegal becomes part of the unethical behavior. Even if the money is returned to the account the next week as the supervising attorney promised, there are no good or easy solutions to this problem, but it is one that must be confronted and addressed. Additionally, you may need to confront the offending attorney, whomever you approach. Be sure to have your facts straight. What appears to you to be an ethical violation may simply be aggressive or zealous advocacy that is on the edge but still within the bounds of propriety or not. Should you go to the Bar Association or to a law enforcement agency? This is obviously a very tough question. The answer may depend on whether you have thoroughly exhausted available routes within the office to resolve the matter to your satisfaction, and more important, whether you think this is the only way to prevent serious harm to a client. See also your ethics or your job later in the chapter. The case of Brown v. Hammond involves a paralegal and a whistleblower, Cynthia Brown, who was fired after she complained about the improper billing practices of her law firm. She then sued the law firm. Her cause of action in the suit was wrongful discharge. As you read the opinion, keep the following points in mind. The case arises on a motion to dismiss. The defendant is arguing that even if Brown proves her factual allegations, her facts do not state a cause of action for wrongful discharge, and that therefore there is no legal basis for her to recover. If the motion is denied, the case then goes to trial, and Brown will be allowed to introduce evidence to support her factual claims. For purposes of ruling on a motion to dismiss, the court will assume that she will be able to establish her facts. The issue then becomes whether the state recognizes a cause of action of wrongful discharge on the basis of those facts. Like most non-union employees in the private sector, Brown was an at-will employee. The rule governing such employees is that they can be terminated at any time for any given reason that does not violate public policy. Brown's complaint had 2 counts. Count 1 is based on the claim that firing her for reporting billing fraud is against public policy. The court's discussion of this count makes a critical distinction between a disclosure that is gratuitous, one that is not based on a job duty, and a disclosure of someone is obligated to make as part of one's job. Count 2 is based on the claim that firing her for refusing to participate and fraudulent billing is against public policy. The case is in federal court because of diversity of citizenship. Plaintiff is a citizen of Texas and defendants are citizens of Pennsylvania. The amount in controversy exceeds $75,000. Order of the court, a case study. Brown v. Hammond, United States District Court, Eastern District, Pennsylvania, 810 F SUPP 644 ED PA 1993. The facts of the case are that Cynthia Brown, the plaintiff, sued her employer, Robert Hammond, and his law firm, the defendants, for the wrongful discharge. Brown claimed that the law firm was improperly billing its clients and thus blowing the whistle on her former boss and the firm. Brown had been directed to bill her time spent on cases as attorney time despite her protests to her employer. Eventually, Brown notified clients and the authorities of the law firm's billing practices. Brown was terminated from her employment with Robert Hammond Associates after only working at the firm from November 1990 to April 1991. Under Pennsylvania law, she was considered an at-will employee. The case was filed in district court based on diversity of citizenship, as Brown is from Texas and the law firm is based in Pennsylvania. Pennsylvania law was applied to the case. Brown filed 3 counts in her complaint against Hammond. The court found that since Brown was an at-will employee in Pennsylvania, an employee could be terminated for any or no reason, and thus the allegations of misconduct by Hammond in those counts were not against public policy. However, the court did not find that Brown had a plausible cause of action against Hammond for wrongful discharge when she refused to violate the law and commit fraudulent billing practices at the firm's direction. This was an exception for any or no reason policy of at-will employment. Thus, Brown's second count was allowed to proceed against Hammond, her former employer. In addition to count 1, count 3 was dismissed as well. Discussion questions. Examine Brown v. Hammond. What facts did the court rely on to support her case continuing against her former law firm? When does an employee have a viable case against an employer for wrongful discharge under Pennsylvania law? Were there actions that Brown could have done to strengthen her case against the law firm? 6-23 Pro bono services. All attorneys have a professional responsibility to provide legal services to persons who are unable to pay and should try to meet the goals of providing a minimum of 50 hours of pro bono services a year at no fee or at a substantially reduced fee. Model Rule 6.1. Attorneys have an ethical obligation to provide pro bono services. Pro bono services are provided free or at substantially reduced rate. Pro bono is an abbreviated form of the phrase pro bono publico, for the public good. The ethics codes of all bar associations suggest and a few require attorneys perform a designated number of pro bono hours per year. The American Bar Association recommends 50 hours. Paralegal perspective. Many paralegals provide pro bono paralegal services in office throughout the country, such as legal aid offices and domestic violence clinics. The work is usually done in the evening or on weekends. In most states, traditional and independent paralegals are not required to do pro bono work as a condition of employment, yet all paralegal associations strongly urge such work. Here, for example, is what the Kentucky Paralegal Association says to paralegals. A paralegal should voluntarily donate paralegal service as a matter of public service. Paralegals are encouraged to donate 25 hours of service a year. Donated service must be performed under the supervision of a lawyer. 6-24 Withdrawal. Attorneys are not required to take every case. Furthermore, once they begin a case, they are not obligated to stay with the client until the case is over. If, however, the case has already begun in court after the attorney has filed a notice of appearance, withdrawal is usually improper without the permission of the court. We need to distinguish between mandatory withdrawal when the attorney must end the attorney-client relationship and permissive withdrawal when the attorney is allowed to end the relationship without violating ethical rules. 6-24A Mandatory withdrawal. An attorney must end the attorney-client relationship, must withdraw from a case if the client fires the attorney, if continuing on the case violates ethical rules or laws, or if competent representation is jeopardized because of the attorney's physical or mental health. Withdrawal for these reasons is required unless a court or other tribunal orders the attorney not to withdraw. Model Rule 1.16. In some circumstances, an attorney must withdraw from a case that has begun. The client fires the attorney. An attorney is an agent of the client. Clients are always free to dismiss their agents. Representation of the client would violate ethical rules, like, for example, the attorney discovers that they have a conflict of interest with the client that cannot be cured or remedied, even with the consent of the client. Representation of the client would violate the law, like, for example, the client insists that the attorney provide advice on how to defraud the IRS. The attorney's physical or mental health has deteriorated to the point where the attorney's ability to represent the client has been materially impaired. This may be due to alcohol or drug abuse, marital problems, and etc. 6-24B Permissive withdrawal. An attorney is allowed to withdraw from a case for any reason if the withdrawal will not harm the client, meaning that withdrawal will not have a material adverse effect on the client. If the client would be harmed by the attorney's withdrawal, the attorney can still end the attorney-client relationship and withdraw from the case. If the attorney has good cause for doing so, good cause can include the following: the attorney is in fundamental disagreement with the client. The attorney believes the client is acting in a repugnant way. The client has used the attorney's services to commit a crime or fraud. The client has not paid the attorney after being warned that continued non-payment will result in the attorney's withdrawal. Model Rule 1.16. Attorneys are allowed to change their mind about representing a client even if the representation has begun. They can withdraw as long as a withdrawal would not harm the client. Examples of withdrawal that would harm a client is an attorney who abruptly withdraws on the eve of an important hearing or on the day before the client's cause of action dies. Because of the expiration of the statute of limitations, it would undoubtedly be burdensome and probably expensive for the client to be able to find another attorney on such short notice. If there is a danger that withdrawal would harm a client, the attorney cannot withdraw unless good cause is shown. Examples of good cause include fundamental disagreements with the client, repugnant conduct by the client, using the attorney's services for criminal or fraudulent purposes, or financial problems caused by the non-payment of fees by the client. Analyze this. The court appoints your law firm to represent a criminal defendant in a case. The client has already been convicted and the firm's responsibility would only be at the sentencing stage. 3 previous attorneys have withdrawn from the case. The firm has spent 50 hours reviewing the case file and transcripts. After numerous requests to meet with the client in the detention facility, the client refuses. Is withdrawal permissible? Explain your response. 6-24C Letter of Disengagement. When withdrawal is allowed, the attorney should send the client a letter of disengagement, also called pejoratively a kiss-off letter. It formally notifies the client that the attorney will no longer be representing the client. The letter The letter confirms the termination of the attorney-client relationship. It should state that the attorney-client relationship has ended, the reason for the attorney's withdrawing, a summary of the scope of the representation that was attempted, a statement of the disposition of funds, if any, remaining in the client's account, a statement of the right of the client to their file and how to obtain it, a recommendation that alternative counsel be obtained as soon as possible. Paralegal perspective. When you have a close working relationship with an attorney, particularly in a small law office, you become aware of their professional strengths and personal weaknesses. Bar associations around the country are becoming increasingly concerned about the impaired attorney, someone who is not functioning properly due to substance abuse or similar problems. A paralegal with such an attorney for a supervisor is obviously in a predicament. Seemingly small problems have the potential of turning into a crisis. If it is not practical to discuss the situation directly with the attorney involved, you need to seek the advice of others in the office and of the other paralegals, particularly members of the local paralegal association. 6-25 Appearance of impropriety. How would you feel if you were told that you have not done anything improper, but you are still going to be punished because what you did appeared to be improper? That would be the effect of an obligation to avoid even the appearance of a professional impropriety. In most states, it was once unethical for attorneys to engage in such appearances. The ABA model rules, however, do not list appearance of impropriety as an independent basis for determining unethical conduct. The ABA model code did have an appearance rule. To be disciplined in states that have adopted the model rules, an attorney must violate one of these specific ethical rules. Yet, even in these states, conservative attorneys are as worried about apparent impropriety as they are about specific actual impropriety. Paralegal perspective. In Florida, all Florida registered paralegals are told to avoid the appearance of impropriety. Appearance of impropriety or unethical conduct. A Florida registered paralegal should understand the attorney's rules of professional conduct and this code in order to avoid any action that would involve the attorney in a violation of the rules or give the appearance of professional impropriety. It is the obligation of the Florida registered paralegal to avoid conduct that would cause the lawyer to be unethical or even appear to be unethical, and loyalty to the lawyer is incumbent upon the Florida registered paralegal. 6-26 Unauthorized Practice of Law, UPL. An attorney shall not assist a non-attorney in the unauthorized practice of law, UPL, Model Rule 5.5. In Chapter 4, we saw that it is a crime in most states for a non-attorney to engage in the unauthorized practice of law, UPL. Our main focus in Chapter 4 was the non-attorney who works for an office other than a traditional law office. An example would be a document service provider DSP who owns a do-it-yourself divorce office that sells kits and typing services. Here in Chapter 6, our focus is the paralegal or other non-attorney who works under the supervision of an attorney in a law office. We want to explore the ways in which an attorney might be charged with assisting their own paralegal in engaging in UPL because of the attorney fails to supervise the tasks delegated to a paralegal, fails to prevent a paralegal from giving advice, allows a paralegal to conduct a deposition, allows a paralegal to sign a court document. These and related areas will be discussed below along with an overview of other major ethical issues involving paralegals. 6-27 Paralegals. Throughout the chapter thus far, we have covered ethical duties involving paralegals in the paralegal perspectives. on the main ethical rules governing attorneys: maintaining competence, proper fees, misconduct, breaches of confidentiality, conflicts of interest, communication with the other side, solicitation, payments for referrals, reporting misconduct, unauthorized practice of law, and etc. Here we present a more direct treatment of when attorneys can be disciplined for the unethical use of paralegals. We will cover the following topics: paralegals, the ABA Model Code, and the ABA Model Rules, paralegals and ethics codes in your state, identification of a paralegal status, doing what only attorneys can do, kinds of supervision and the independent paralegal. 6-27A ABA Model Code. ABA Model Code, the first major statement by the American Bar Association on the ethical use of paralegals by attorneys, came in its Model Code of Professional Responsibility. As we saw earlier in Exhibit 6-4, the Model Code is an earlier edition of the ABA's Model Rules of Professional Conduct. Here is what the Model Code said about non-attorneys in DR. Disciplinary Rule 3-101 in EC Ethical Consideration 3-6 and in ABA Formal Opinion 316. DR 3-101A, a lawyer shall not aid a non-lawyer in the unauthorized practice of law. EC 3-6, a lawyer often delegates tasks to clerks, secretaries, and other lay persons. Such delegation is proper if three conditions are met. The lawyer must maintain a direct relationship with the client, supervise the delegated work, and have complete professional responsibility for the work product. The delegation enables a lawyer to render legal services more economically and efficiently. Formal Opinion 3-16. Lawyers can hire paralegals and non-attorneys to perform any task in a law office except the following three tasks: counsel clients on legal matters, engage directly in the practice of law, make court appearances. The attorney must vouch for the paralegal's work to the client and become responsible for it to the client. The non-attorney must not do things that lawyers may not do or do things that lawyers only may do. 6-27B ABA Model Rules. Rule 5.3. The model rules are more explicit than the model code on the ethical duties of attorneys when they use paralegals. Example: the law firm of Adams & Adams represents Harold Thompson in their breach of contract suit against Parker Co. At the firm, Elaine Stanton, Esquire, works on the case with Peter Vons, a paralegal. Peter neglects to file an important pleading in court and carelessly gives confidential information about Thompson to the lawyer representing Parker. All of this causes Thompson great damage. Under what circumstances can Elaine Stanton be reprimanded, suspended, or disbarred because of what the paralegal did? To answer this question, we turn to Model Rule 5.3, see Exhibit 6-11. Exhibit 6-11, Model Rule 5.3. Rule 5.3 in Model Rules of Professional Conduct. Responsibilities regarding non-lawyer assistance. With respect to a non-lawyer employed or retained by or associated with a lawyer. With respect to a non-lawyer employed or retained by or associated with a lawyer. A partner and a lawyer who individually or together with other lawyers possess comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect measures giving responsibility assurance. A partner and a lawyer who individually or together with other lawyers possess comparable managerial authority in a law firm shall make reasonable efforts to ensure that the firm has in effect, measures given reasonable assurance that the person's conduct is compatible with the professional obligations of the lawyer. B. A lawyer having direct supervisory authority over the non-lawyer shall make reasonable efforts to ensure that the person's conduct is compatible with the professional obligations of the lawyer. And C. A lawyer shall be responsible for the conduct of such a person that would be in violation of the rules of professional conduct if engaged in by a lawyer, if 1. The lawyer orders or with the knowledge of the specific conduct ratifies the conduct involved, or 2. The lawyer is a partner or has comparable managerial authority in the law firm in which the person is employed, or has direct supervisory authority over the person and knows of the conduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial action. The first line of Rule 5.3 tells us which non-lawyers are covered by the ethical rule: non-lawyers employed by a lawyer, non-lawyers retained by a lawyer, non-lawyers associated with a lawyer. Employed non-lawyers are traditional paralegals who are salaried employees of the firm. A retained non-lawyer can be an independent contractor, such as an independent paralegal who works on a contract basis for the firm. An associated non-lawyer could be an intern who volunteers at the office. Note, however, that non-lawyers cannot be called associates, as we will see. Next, 5.3 lays out the different responsibilities of 3 different categories of lawyers in the firm. All lawyers are not judged by the same ethical standard. Here are the 3 categories of lawyers in the rule. A lawyer who runs the firm. This can be a partner or a lawyer with managerial authority that is comparable to that of a partner. See 5.3a and 5.3c2. A lawyer with direct supervisory authority over the paralegal. See 5.3b and 5.3c2. Any lawyer in the firm. See 5.3c1, because 5.3c1 does not qualify a category of lawyer. 5.3c1 refers to all lawyers in the office: partners, managing lawyers, supervising lawyers, and every other law firm in the firm. Let's analyze 5.3 in detail by applying it to Elaine Stanton Esquire and Peter Vons in our example of Harold Thompson's suit against Parker Co. Our analysis will cover the 3 categories of lawyers in the rule in the order in which they are treated in the rule. Lawyers who run the firm, partners, and other managers, Rule 5.3a. Section A of Rule 5.3 gives us the ethical obligation of a partner or other manager. We need to know whether Elaine Stanton is a partner in the firm or is an attorney with managerial responsibilities that are compared to those of a partner. If so, she has an ethical obligation under Rule 5.3a to make reasonable efforts to ensure that the firm has in effect measures giving responsible assurance that the paralegal's conduct is compatible with the professional obligations of the lawyer. Hence, a partner or comparable manager who is not supervising a paralegal cannot completely ignore office paralegals in the hope that someone else in the firm is monitoring them. Reasonable steps must be taken by every partner or comparable manager to establish a system of safeguards. This system is what is meant in 5.3a by measures that must be taken. The rule does not specify that measures must be taken. Here are some possible examples. Make sure that all paralegals in the firm are aware of the ethical rules governing attorneys in the state. Issue a firm-wide requirement that all paralegals must sign a statement that they have read the rules. Make sure that all paralegals in the firm are aware of the importance of deadlines in the practice of law and of the necessity of using paper or computer date reminder tickler techniques. Ask another lawyer or a legal administrator in the office to let you know when every paralegal in the office has completed a brief in-house course on the tickler systems used by the office. Because we don't have enough facts in our Elaine Stanton Peter Vaughn's example to determine who are the partners and managers at Adams and Adams and what reasonable measures they took or failed to take, we cannot at this time determine whether 5.3a was violated. We need more facts. Lawyers with direct supervisory authority over the paralegal, Rule 5.3b. Next, Rule 5.3b gives us the ethical obligation of a lawyer who has direct supervisory responsibility over the paralegal. Such a lawyer must make reasonable efforts to ensure that the paralegal's conduct is compatible with the professional obligations of the lawyer. Peter Vaughns is supervised by Elaine Stanton Esquire, who therefore has direct supervisory authority over Peter. Assume that Stanton is charged with a violation of 5.3b because the paralegal, Peter, failed to file an important pleading in court relevant to the ethical issue of competence and disclosed information about a client relevant to the ethical duty of confidentiality. At Stanton's disciplinary hearing, they would be asked a large number of questions about how they supervised Peter. For example, how do you assign tasks to Peter? How do you know if Peter is capable of handling an assignment? How often do you meet with Peter after you give them an assignment? How do you know if Peter is having difficulty completing an assignment? Has Peter made mistakes in the past? If so, how have you handled them? Why didn't you prevent the late filing by Peter? Why weren't you able to prevent Peter from disclosing confidential information about the Thompson case? In addition, Peter might be questioned by an investigator from the disciplinary board or called as a witness in Stanton's disciplinary hearing. Peter could be asked questions such as these. How long have you worked for Elaine Stanton? Why didn't you file the court document on time? Explain what happened. Describe the circumstances under which you revealed confidential information to the opponent in the Thompson case. How were you trained as a paralegal? What legal courses did you take in school? How was ethics covered? What kinds of assignments have you handled in your paralegal career? How does Elaine Stanton evaluate your work? What do you do if you have a question on an assignment but Elaine is not available in the office? The purpose of asking these questions of Stanton and of Peter is to find out if 5.3b applies. The disciplinary body must determine if Stanton complied. The disciplinary body must determine if Stanton complied with their duty to make reasonable efforts to ensure that Peter did not violate ethical standards. Note that lawyer supervisors as well as partners and managers do not have to guarantee that a paralegal will act ethically. They simply have to make reasonable efforts that this will occur. The preceding questions are relevant to whether Stanton exerted such efforts with respect to Peter. The answers will help determine whether Stanton violated 5.3b. Note also that Peter is not subject to discipline by the body investigating Stanton. This is very important to recognize and note. The model rules apply to attorneys. Peter is being questioned in order to decide whether Stanton should be disciplined. Peter might be fired by Adams and Adams. If Peter acted negligently, they might be sued by a client. See Chapter 4. If Peter engaged in the unauthorized practice of law, they might be prosecuted. See Chapter 4. However, Peter cannot be sanctioned by the disciplinary body investigating attorneys at Adams and Adams. Any lawyer in the firm who orders or ratifies the misconduct, Rule 5.3c1. Under Rule 5.3c1, any lawyer in the firm who orders the paralegal to commit the wrongdoing in question is ethically responsible for that conduct. The same is true if any attorney ratifies, that is, approves or endorses the wrongdoing after the paralegal commits it. There is no indication in the example that Elaine Stanton or any other lawyer at Adams and Adams ordered Peter not to file the importance pleading in court or ordered him to give confidential information about Thompson to the other side. Nor is there any indication that any lawyer at Adams and Adams approved of ratified Peter's conduct after it occurred. On the facts that we have, therefore, Rules 5.3c1 does not apply. Lawyers who run the firm, partners or other managers, and lawyers with direct supervisory authority. Rule 5.3c2. Finally, Rule 5.3c2 returns to the duty of lawyers who are partners, managers, and supervisors. The section of the rule applies if one of these lawyers knows the paralegal's misconduct at a time when its consequences can be avoided or mitigated, but fails to take reasonable remedial corrective action to do so. There is no indication in our example that Elaine Stanton or any other lawyer in the firm knew that Peter Vons was going to neglect to file the pleading, or that they were going to reveal confidential information. Hence, the lawyers could not take corrective remedial steps to avoid what Peter did, nor do the facts indicate what they could have done to lessen the damage mitigate once it occurred. On the facts that we have, therefore, Rule 5.3c2 does not apply. 6-27C Ethics Code in your state. Every state has a Rule 5.3 or an equivalent in its ethics code governing attorneys. For your state, see Appendix C. In addition, the paralegal codes and guidelines outlined in Exhibit 6-4 have provisions covering what Peter Vons did in our example. See also Appendix A for links to the paralegal and bar associations that have published these codes and guidelines. We turn now to other paralegal conduct that can result in ethics trouble for supervising attorneys and their paralegals. 6-27D Identification of paralegal status. A paralegal status as a non-attorney must be clear to everyone with whom the paralegal comes in contact. To learn how to avoid a misrepresentation of status intentionally or accidentally, we will examine the following issues: titles, disbarred or suspended attorneys as paralegals, disclosure of status, business cards, letterheads, websites, signature on correspondence, name on court documents. What titles can be used? Titles must make clear that the individual is a non-attorney. The main titles used in the field are paralegal and legal assistant. Variations include titles such as paralegal coordinator, senior paralegal, and probate paralegal. These titles are sufficiently clear. There is little danger that someone would think that a person with these titles is an attorney. A few states, however, have restrictions on who can use these titles. In California, for example, the titles can be used only by individuals who work under the supervision of attorneys and meet specified educational requirements. See Chapter 1 and 4. A few other states, like for example Maine, South Dakota, and Florida, impose similar title restrictions. A paralegal should not be called an associate or paralegal associate. The common understanding is that an associate is an attorney. As we have seen, special laws have created unique terminology for document service providers, DSPs, who provide services to the public without attorney supervision, like, for example, bankruptcy petition preparer, BBP, legal document assistant, LDA, legal document preparer, LDP, and limited licensed legal technician, LLT. These titles can be used by people who meet the requirements for their use. Can a disbarred or suspended attorney be called and function as a paralegal? When attorneys have been disbarred or suspended from the practice of law for ethical improprieties, they may try to continue to work in the law as paralegals for attorneys willing to hire them. Some states will not allow this because it shows disrespect for the court that disciplined the attorney, and because the individual is highly likely to engage in the practice of law by going beyond paralegal duties. Other states are more lenient but might impose other restrictions, such as not allowing a disbarred or suspended attorney to have any client contact while working as a paralegal. See Appendix C for restrictions, if any, in your state. Should paralegals disclose their non-attorney status to clients, attorneys, government officials, and the general public? Yes, this disclosure is necessary. Compare the following communications by a paralegal. I work with Ward Brown at Brown and Tams. I'm from Brown and Tams. I'm a paralegal. I am a legal assistant. I am not an attorney. The fifth statement is the clearest expression of non-attorney status. The first two statements are unacceptable because you have said nothing about your status. For most contacts, the third and fourth statements, paralegal, legal assistant, will be ethically sufficient to avoid any misunderstanding about your non-attorney status. Yet, some members of the public may be confused about what a paralegal or legal assistant is. If there is any possibility of doubt, use the magic words, I am not an attorney. Do not assume that a person with whom you come in contact for the first time knows you are not an attorney. The safest course is to assume the opposite. May a paralegal have a business card? Yes, every state allows paralegals to have their own business cards if their title is also printed on the card so that their non-attorney status is clear, and if the card is not used for unethical solicitation. At one time, some states wanted the word non-lawyer or non-attorney used along with the paralegal's office titles. This is rarely required today because paralegals are not allowed to solicit business for their employer. The card may not be used for this purpose. A paralegal's card can include the name and address of the law office where the paralegal works, but the primary focus of the card must be able to identify the paralegal rather than the employer. May the letterhead of law office stationery print the name of a paralegal? States differ in their answer to this question, although most now agree that non-attorney names can be printed on law office letterhead if their title is also printed so that their non-attorney status is clear. See Exhibit 6-12. Before 1977, almost no state allowed attorney stationery to print the names of non-attorney employees. The concern was that the letterhead would be used as a form of advertising by packing it with names and titles to make the office look impressive. This concern evaporated in 1977, however, when the Supreme Court held in Bates v. State Bar of Arizona, 433 U.S. 350, 1977, that a state could not ban all forms of attorney advertising. After this date, most states withdrew their objection to the printing of paralegal names on attorney letterhead, as long as no one would be misled into thinking that the paralegals were attorneys. In Michigan, it was recommended, but not required, that attorney and non-attorney names be printed on different sides of the stationery to enhance the clarification that the paraprofessional is not licensed to practice law. A few states adhere to the old view that only attorney names can be printed on law office letterhead, yet to the extent that this view is still based on a prohibition of attorney advertising, it is subject to challenge. Exhibit 6-12, example of law office letterhead with paralegal name. Holland and Hart LLP, attorneys at law. Denver, Aspen, Boulder, Colorado Springs, Denver Tech Center, Billings, Boise, Cheyenne, Jackson Hole, Salt Lake City, Washington, D.C., Suite 3200, 555 17th Street, Denver, Colorado 80202, 3979, mailing address P.O. Box 8749, Denver, Colorado 80201, 8749, telephone 303-295-8000. Source, courtesy of Holland and Hart LLP. Though ethically permissible in most states, it should be pointed out that not many law firms in the country print non-attorney names on their law office letterhead. May the website of the law office list the names and qualifications of the paralegals in the office. Yes, the same reasons that permit paralegal names to be printed on office stationery apply to listing paralegal names and qualifications on law office websites. May a paralegal write and sign letters on attorney stationery? There is never an ethical problem with a paralegal writing a letter that will be reviewed and signed by an attorney. Suppose, however, that the attorney wants the paralegal to sign their own name to the letter. Most states will permit this if certain conditions are met. For example, a title must be used that indicates the signer's non-attorney status, and the letter must not give legal advice. We saw in Chapter 4 that paralegals who pass paralegal certification exams are entitled to use the letters that indicate their achievement. CLA, CP, CRP, PP. See Chapter 4. In most states, however, it would not be appropriate to use these letters alone. David Johnson, CP, Mary Adams, CRP, Karen Vickers, PP. The general public would not understand what these letters mean, or worse, might think they are attorneys. Hence, a title should be used along with the letters. David Johnson, CP, certified paralegal. Mary Adams, CRP, core, registered paralegal. Karen Vickers, PP, paralegal. In most states, there are no limitations on the persons to whom a paralegal can send letters. Yet, in a few states, only an attorney can sign a letter to a client, to an opposing attorney, or to a court. This is an extreme position, so long as the paralegal's non-attorney status is clear. Legal advice is not given, and an attorney is supervising the paralegal. Restrictions on who can be the recipient of a paralegal signed letter makes little sense. Most states impose no such restrictions. May an attorney print the name of a paralegal on a court document? Occasionally, an attorney may want to print on a document the name of a paralegal who worked on the document in addition to the attorney's name and signature. The attorney may simply want to give a measure of recognition to the efforts of this paralegal. Most states permit this as long as there is no misunderstanding as to the paralegal's non-attorney status and no attempt is made to substitute a non-attorney signature for an attorney's signature. 6-27E. Doing what only attorneys can do. There are limitations on what attorneys can ask their paralegals to do. The failure to abide by these limits might subject the attorney to a charge of unethically assisting a non-attorney to engage in the unauthorized practice of law. UPL. The areas we need to examine are as follows: signing court documents, legal advice, non-legal advice, drafting documents, real estate closings, depositions, executions of wills, settlement negotiations, court appearances, counsel's table, administrative hearings, references to my client. May a paralegal sign a court document? We need to separate the question of when paralegals can sign their own name on court documents and when they can sign their attorney's name on them. In most states, the answer to the first question is never. Formal documents that are required in litigation, like for example, appellate brief, memorandum of law supporting a motion, or a pleading such as a complaint, must be signed by an attorney representing a party in the dispute. Formal documents that are required in litigation, like for example, appellate brief, memorandum of law supporting a motion, or a pleading such as a complaint, must be signed by an attorney representing a party in the dispute. With rare exceptions, the document cannot be signed by a non-attorney, no matter how minor the formal document may be. In most states, a paralegal can sign a letter on a routine matter to a clerk or other non-judge, but formal litigation documents require an attorney's signature. The answer to the second question, can a paralegal sign an attorney's name on a court document, is almost never. Of course, a paralegal should never sign someone else's name without authorization. Under limited circumstances, however, a small minority of states authorize non-attorneys to sign an attorney's name on correspondence or pleadings. Missouri, for example, allows paralegals to sign an attorney's name on a document if 1. The attorney supervised the production and content of the document, and 2. The paralegal indicates that they are signing the attorney's name, such as by placing the paralegal's initials next to the signature. May a paralegal give legal advice? Attorneys use their skills in the practice of law to help clients solve legal problems. Giving them legal advice is perhaps the most important of these skills. Legal advice is a statement or conclusion that applies laws or legal principles to the facts of a specific person's legal problem. See the discussion in Chapter 4 on the distinction between legal advice and legal information. Attorneys who permit their paralegal to give legal advice, or who fail to take the steps required by Model Rule 5.3 to prevent paralegals from giving such advice, are aiding the paralegal in the unauthorized practice of law, UPL, and hence are acting unethically. A number of paralegals have pointed out how easy it is to fall into the trap of giving legal advice. Paralegals should be alert to all casual questions because your answers might be interpreted as legal advice. Most of us are aware of the obvious, but we need to keep in mind that sometimes the most innocent comment could be construed as legal advice. A typical scenario, particularly in a small law office where paralegals have a great deal of direct client contact, is that the clients themselves will coax you to answer questions about the procedures involved in their cases and lead you into areas where you would be giving them legal advice. Sometimes this is done innocently because the attorney is unavailable and they are genuinely unaware of the difference between what you can do for them and what their legal counsel must do. They will press you for projections, strategy, applicable precedents, in short, legal advice. Sometimes you are placed in situations where you are not adequately supervised and your own expertise may be such that you know more about the specialized area of law than the attorney. We have all walked the thin line between assisting in the provision of legal services and actually practicing law. The consequences of legal advice in these situations can be serious. In addition to the sanctions against supervising attorneys described in Exhibit 6-3, insurance problems may exist. Suppose a client sues and alleges that the firm's paralegal gave legal advice. Will the firm's malpractice insurance policy cover this suit? No. According to the General Counsel of the Mississippi Bar Association, no available insurance policy will cover judgments resulting from a civil suit brought by an angry client based on the theory that a paralegal gave the client legal advice. In fact, if the paralegal gives legal advice, the predominant rule is that coverage is void for such act. Therefore, the paralegal is warned not to give the client advice, even if the paralegal knows the answer, and even though it may be an emergency situation. Why give legal advice constitutes Giving legal advice constitutes the unauthorized practice of law, and the unauthorized practice of law is not covered. There are a number of situations, however, in which a paralegal can give legal advice. First, a paralegal can tell a client precisely what the attorney tells the paralegal to say, even if the message constitutes legal advice. The paralegal, however, cannot elaborate on, interpret, expand, or explain this kind of message from the attorney. Example, Helen Vixen is a paralegal in the law office of Sam Klein, Esquire. Sam says to Helen, when the client calls, tell her that she will be in breach of contract if she fails to complete the shipment of the goods. Compare the following 3 scenarios. Situation 1, when the client calls, Helen says, Mr. Klein told me to tell you that you will be in breach of the contract if you fail to complete the shipment of goods. Situation number 2, when the client calls, Helen says, Mr. Klein told me to tell you that you will be in breach of the contract if you fail to complete the shipment of the goods. Helen then adds, the buyer will be able to collect triple damages for failure to deliver. Situation number 3, when the client calls, Helen says, Mr. Klein told me to tell you that you will be in breach of the contract if you fail to complete the shipment of the goods. The client says, does that mean that the buyer will be able to collect extra damages from me? Helen answers, yes. Only situation number 1 is proper. Helen is merely communicating what her attorney told her to say. In situation number 2, Helen has elaborated on what the attorney told her to say. The same is true in situation number 3. The second area where paralegals can give legal advice is when they are working in an area of the law where non-attorneys are authorized to represent clients, such as Social Security hearings. See Chapter 4 and 15. In such areas, the authorization includes the right to give legal advice. May a paralegal give a client non-legal advice? Yes, an attorney may allow a paralegal to render specialized advice on scientific or technical topics. For example, a qualified paralegal can give accounting advice or financial advice. The danger is that the non-legal advice may also contain legal advice, or the client might reasonably interpret the non-legal advice to include legal advice. May a paralegal draft legal documents? Yes, a paralegal can draft any legal document as long as an attorney supervises and reviews the work of the paralegal. Some ethical opinions emphasize these requirements by insisting that the document must lose its separate identity as the work of a paralegal and must leave the office as the work product of an attorney. The key point is that an attorney must supervise all paralegal work, including document preparation. May a paralegal conduct a real estate closing alone? May a paralegal conduct a real estate closing alone? All states allow a paralegal to attend a real estate closing with their attorney supervisor. States differ on whether paralegals can conduct a closing alone. Most states say they cannot. The sale of real property is finalized at the closing. Many of the events at the closing are formalities, such as signing and exchanging standard documents. Occasionally, however, some of these events turn into more substantive matters, where negotiation, legal interpretation, and legal advice are involved. Hence, in only a few states can paralegals attend alone and conduct the closing themselves. Chicago has one of the most liberal rules. Their paralegals can conduct the closing without the attorney supervisor being present. If no legal advice is given, if all the documents have been prepared in advance, if the attorney supervisor is available by telephone to provide help, and if the other attorney consents. In some states that allow paralegals to conduct closings, their supervising attorney must be available in the same building where the closing is held. May a paralegal conduct a deposition? No, paralegals can schedule depositions, can assist in preparing a witness who will be deposed, called the deponent, can take notes at the deposition, and can summarize deposition transcripts, but they cannot conduct the deposition. Asking and objecting to questions at a deposition are attorney-only functions. May a paralegal supervise the execution of an instrument? All states allow paralegals to act as a witness to the execution of instruments such as a will, but states differ on whether paralegals can supervise the execution on their own. May a paralegal negotiate a settlement? Most negotiations involve an exchange of opinions on how the law and facts apply to the legal dispute between the parties. Only attorneys can engage in such discussions on behalf of clients. If, however, the opponent is an insurance company, a few states allow a paralegal to negotiate with a non-attorney employee of an insurance company, such as a claims adjuster. May a paralegal make a court appearance? In the vast majority of courts, a paralegal cannot perform even minor functions in a courtroom, such as asking a judge to schedule a hearing date for an attorney. Only attorneys can act in a representative capacity before a judge. As we saw in Chapter 4, however, there are exceptions to this rule. In some specialized courts, such as small claims courts, you do not have to be an attorney to represent parties. In a few courts, paralegals can appear at answer calls on behalf of their attorney. These exceptions, however, are rare. May a paralegal sit at counsel's table during a trial? In many courts, only attorneys can sit at counsel's table during a trial. Yet in some courts, a paralegal is allowed to sit with the attorney if permission of the presiding judge is obtained. The paralegal does not take an active role in the trial. They provide general assistance for the attorney, like, for example, note-taking, organizing exhibits, and doing quick database searches for documents and discovery testimony if laptop computers are allowed in the courtroom and if such information is in the database. May a paralegal represent clients at administrative hearings? Yes, when this is authorized at the particular state or federal administrative agency. See Chapter 4 and 15. Can a paralegal refer to my client? Use care in your choice of pronouns, no matter how long you work on a particular case in a law office. The client is always the attorney's client. It's tempting for a paralegal in casual conversation to refer to my client. Traditional paralegals, however, do not have clients. Paralegals are assigned to work on the cases of the attorney's clients. Analyze this. You are sitting in your office working with your door open. You overhear one of the paralegals in the firm say the following to the firm's client on the phone. Yes, Miss Lucas, I would advise you to stop paying the monthly payments because the automobile you purchased is clearly a lemon. I would advise you to stop paying the monthly payments because the automobile you are purchased is clearly a lemon. Just go right to the dealership and park it in their lot. No one in their right mind would pay a penny for that car. Let me know how it works out with the car dealership. Has the paralegal acted ethically? Would the supervising attorney be responsible for the paralegal's actions and advice? Explain. 6-27F. Kinds of supervision. It is difficult to overestimate the importance of attorney supervision in the arena of ethics. According to the Supreme Court of one state, without supervision, the work of the paralegal clearly constitutes the unauthorized practice of law. UPL. Almost every ethical opinion involving paralegals and almost every attorney malpractice opinion involving paralegals stresses the need for effective supervision. The justification for the very existence of perhaps 95% of paralegal activity is this supervision. Indeed, one of the main reasons many argue that paralegal licensing is not necessary is the protective cover of attorney supervision. In a Spencer v. Steinemann 179 FRD 484 EDPA 1998, a paralegal made a serious error in failing to give proper notice on subpoenas that she issued. her attorneys was disciplined because of this error. A supervising attorney has an ethical obligation to establish appropriate procedures to ensure that those duties he or she delegates to subordinates are performed properly. In this case, the attorney did not assure himself that the paralegal had adequate training, nor did he adequately supervise her once he assigned her the task of issuing subpoenas. The court was not persuaded by the attorney's arguments that sanctions should not be imposed in view of the fact that the error was made by the paralegal and not by the attorney himself. As the court observed, an attorney may not escape responsibility by blithely saying that any shortcomings are solely the fault of his employees. What is meant by supervision? Legal and non-legal dictionaries provide the same definition: managing, directing, controlling, guiding, and overseeing something or someone. The extremes of supervision are easy to identify. Absentee supervision refers to the attorney who is either never around or seldom available. Once tasks are assigned, paralegals are essentially on their own. At the other extreme is shoulder supervision, practiced by attorneys who are afraid to delegate. When they do get up enough courage to delegate something, they constantly look over the shoulder of the paralegal. Both kinds of supervision are misguided. If you work for an attorney who practices absentee supervision, the potential for disaster is high. Unsupervised or minimally supervised paralegals may not find out about errors they have made until after the errors have caused harm to clients. You may feel flattered by the confidence placed in you. You may enjoy the challenge of independence. You may be highly compensated because of your success, yet you may be committing UPL. Shoulder supervision, on the other hand, provides safety at the expense of practicality. Perpetual step-by-step surveillance will ultimately defeat the economy and efficiency motives that originally led the office to hire paralegals. Shoulder supervision may satisfy the ethical duty of supervision, but no ethics code requires such overkill. Perhaps the most effective kind of supervision is environmental supervision, or what might be called holistic supervision. It is far broader in its reach than the immediate task delegated to a paralegal. It addresses this essential question: what kind of law office environment is likely to lead to a high-quality paralegal work without sacrificing economy or ethics? Environmental supervision requires hiring the right people, training those people, assigning appropriate tasks, providing needed resources, monitoring progress, reviewing the end product, and rewarding competence. 6-27G, supervising independent paralegals. Thus far, our discussion on supervision has focused on the traditional paralegal who works full-time in the office of an attorney. We also need to consider the freelance or independent paralegal who works part-time as an independent contractor for one attorney or for several attorneys in different law firms. Very often, this person works in their own office at home. See Chapter 2, How Can Attorneys Fulfill Their Ethical Obligation to Supervise Such Paralegals? Example, Gail Patterson is an independent paralegal who has their own freelance business. Gail offers paralegal services to attorneys who hire them for short-term projects, which they perform in their home office. Attorneys who hire Gail often do not provide the same kind of supervision that they can provide to a full-time paralegal who works in their office. Suppose, for example, that Gail commits an ethical impropriety such as revealing confidential communications. Because Gail works in their own office, the attorney who hired them may not learn about this impropriety in time to avoid or mitigate its consequences as required by Model Rule 5.3. Conflict of interest is another potential problem. Gail works for many different attorneys and hence many different clients of those attorneys. It is possible that Gail could accept work from two attorneys who are engaged in litigation against each other without either attorney knowing that the other has hired Gail on the same case. See the earlier discussion of this problem when we covered conflict of interest and the tainted paralegal. What kind of supervision is needed to prevent such problems? There is no clear answer to this question. It is not enough that the attorney vouches for and takes responsibility for the final product submitted by the independent paralegal. Ongoing supervision is also needed under Model Rule 5.3. Furthermore, before an attorney hires an independent paralegal for a task, the attorney must inquire about the paralegal's prior and current work in order to determine whether a conflict of interest exists. Extra ethical care is also needed by offices that are exploring the outsourcing of some tasks to a foreign country. Suppose, for example, that a company in India is hired to digest a transcript of testimony from a deposition or trial. The transcript can easily be sent to India as an email attachment. Yet how can the attorney be sure that the same company is not doing work for an opponent of the attorney's client? Also, what assurances does the attorney have that the outsourced office will maintain client confidentiality? In a case that sent shockwaves throughout the professional community, a pay dispute led to a threat from a worker in an outsourced firm in Pakistan to put confidential records online if the dispute was not satisfactorily resolved. Extra vigilance, therefore, is required in the selection and monitoring supervision of an outsourced company. 6-27H Ethical Codes of Paralegal Association. As indicated at the beginning of this chapter, there are no binding ethical rules published by paralegal associations, yet the major national associations have written ethical codes that you should know about. See Exhibit 6-4 for an overview of their structure and functions. For excerpts from these codes, see Appendix D. 6-28 Your Ethics or Your Job. In this chapter, we have stressed the importance of maintaining your integrity through knowledge of and compliance with ethical rules. There may be times, however, when this is much easier said than done. First of all, you may not be sure whether an ethical violation has been or is being committed. Like so many areas of the law, ethical issues can be complex. Or consider these possibilities. No one seems to care about whether an ethical problem exists. Your supervisor appears to be the one committing the ethical impropriety. The entire office appears to be participating in the impropriety. Compounding the problem is the fact that people often do not appreciate being told that they are unethical. Rather than acknowledge the fault and mend their ways, they may turn on the accuser, the one raising the fuss about ethics. See the Brown case covered earlier in the discussion on whistleblowing. Once the issue is raised, it may be very difficult to continue working in the office. You need someone to talk to. In the best of all worlds, it will be someone in the same office. If this is not practical, consider contacting a teacher whom you trust. Paralegal associations are also an excellent source of information and support. A leader in one paralegal association offers the following advice. I would suggest that if the canons, discipline rules, affirmations, and codes of ethics do not supply you with a clear-cut answer to any ethical question you may have, you should draw upon the network that you have in being a member of this association, getting the personal input of other paralegals who may have been faced with similar situations or who have a greater knowledge through experience of our professional responsibilities may greatly assist you in working your way through a difficult ethical situation. Of course, you must be careful not to violate client confidentiality during discussions with someone outside the office. Never mention actual client names or any specific information pertaining to a case. You can talk in hypothetical terms. For example, an attorney working on a bankruptcy case asks a paralegal to, once you present facts in this sterilized fashion, you can then ask for guidance on the ethical implications of the facts. If handled delicately, most ethical problems that bother you can be resolved without compromising anyone's integrity or job. Yet the practice of law is not substantially different from other fields of endeavor. There will be times when the clash between principle and dollar or egos cannot be resolved to everyone's satisfaction. You may indeed have to make a choice between your ethics and your job. Real-world perspectives. On-the-job observations, ethics plays an important role in a paralegal's daily job tasks. Being aware of those ethics and the limitations noted by these paralegals who practice in the fields of estate planning and real estate law. An estate planning paralegal noted that What I like best about estate planning is that you work with people on a very individual basis. I don't think that in many other areas of law you can get that one-on-one contact with the client. You're working with people while they are thinking about the most important things in their lives, their families, their wealth, and how to distribute it, and what they want to happen after they pass on. A lot of the clients contact me directly with their questions for the attorneys. Some of the widows, especially, are more comfortable calling me with their questions. They seem to think their questions might be stupid and they're embarrassed to ask the attorneys directly. I can take their questions and see the attorneys respond to them promptly. Bassett's Top Gun Patricia Adams, Legal Assistant of the Year, 6th Legal Assistant today. Notice that the comments always reference back to the attorney's responsibility to respond to clients' needs. The paralegal acknowledges having a good working relationship with clients, but always cedes the responsibility of legal advice to the attorney in the case. As noted in the chapter, real estate law has some gray areas for non-attorneys. The observation by the real estate paralegal below shows the ethical limitations that may be in place depending upon the jurisdiction of the practice. The paralegal's role in real estate transactions varies widely. They may be delegated work on a task-specific basis. Such as title examination or closing document preparation. Many times, paralegals handle the transaction entirely, involving the attorney only when legal issues arise. Legal statutes or bar ethics opinions, however, may limit the scope of paralegal use. J. Holmgren, The Road to Closing, 32 Facts and Findings 22. The message from the paralegal observations in this chapter is know your legal ethics codes and the parameters for non-attorney and paralegal practice in your jurisdiction. Keep your state ethical code close by and be mindful it is the attorney with whom you work who is ultimately responsible for what you do. They are the ones under the regulation of state bars and Supreme Courts. Don't forget you are not the attorney and should act accordingly. Chapter Review 6-29A, Chapter Summary, Ethics in the Real World. Number 1. Ethics are the standards of behavior to which members of an occupation, profession, or other organization are expected to conform. There are numerous ethical guidelines for which a paralegal must be aware. 2. An attorney at law is a person who engages in the practice of law. An attorney, in fact, is a person authorized to act in place of another, often in a business transaction. Enforcing ethics. 1. Ethical rules are enforced through sanctions. Sanctions for unethical conduct include disbarment, suspension, reprimand, and probation. 2. Attorneys are regulated primarily by the highest court in the state, often with the extensive involvement of the State Bar Association. The state legislature may also have some regulatory authority over attorneys. 3. The American Bar Association is a voluntary association of attorneys. No attorney must be a member. The ABA publishes ethical rules that the states are free to adopt, modify, or reject. The current rules of ABA are found in its Model Rules of Professional Conduct. Because paralegals cannot practice law and cannot become full members of a bar association, they cannot be punished by the Bar Association or other attorney regulatory body. For a violation of the ethical rules governing attorneys, however, can be punished if their paralegals engage in unethical conduct. Paralegal codes. Paralegal codes are written by courts, bar associations, and legislatures. Paralegal organizations also write codes of ethics for paralegals to follow. 2. The ABA issued the model guidelines for the utilization of paralegals. Some states have adopted guidelines, others have created their own. 3. NALA, NFPA, and NALS have adopted ethics codes. None have any real enforcement mechanism. They are primarily guidelines. Ethics Rules. Introduction. The primary focus of the chapter on ethics is the paralegal's perspective. Understanding the ethical rules is paramount in knowing how to avoid unethical situations and unethical behavior in the legal profession. Formation of the attorney-client relationship. An attorney-client relationship is formed when the attorney and client expressly agree to form a relationship, or when a reasonable person would believe that an agreement to provide representation exists. Limited scope representation. Limited scope representation is allowed if the client clearly understands the limited nature of the representation. Collaborative law is an example of limited scope representation. Competence. 1. Attorney competence consists of the knowledge, skill, thoroughness, and preparation reasonably necessary to assist a particular client. 2. To achieve competence, attorneys will use on-the-job training as well as clinical training in school. Continuing legal education, CLE, is another means to achieve competence in the legal profession. 3. Paralegals must maintain a level of competence on the job. It is important to ask more experienced paralegals and the attorney supervisors, for instance, in learning the job. Like attorneys, CLE is another way to achieve competence for paralegals. 4. Digital competitions is digital competition. Digital competence. 4. Digital competence is critical in today's legal world. Staying abreast of the advances in technology is required to maintain competence in the legal profession. Diligence and unwarranted delay. 1. Attorneys must act with reasonable diligence and promptness, avoiding unwarranted delay in representing a client. As a paralegal, be aware of being overloaded with work, as you do not want to be part of undue delay issues in a case. 2. Learning or creating office systems can be an important aspect of your job. It shows diligence and may avoid unwarranted delays. Learn as much as you can about office systems in attempting to be diligent in the job. Clients may ask questions about a case when the attorney is available. Do not cross the line of rendering legal advice. Fees. 1. Fees must be reasonable as determined by factors such as time, labor, complexity, and what is customary. Fee arrangements with clients should be in writing. Most states require contingent fees to be in writing. Expenses such as court costs and out-of-pocket expenses can be charged to the client. 2. Contingent fees are proper. Contingent fees are proper in most cases so long as the client understands the fee arrangement. Contingent fees are not allowed in criminal cases and in some family law cases. 3. Under some circumstances, attorneys in different offices can split fees. They must not, however, split the fees of particular clients with non-attorneys. Paralegal salaries, pension, benefits, and bonuses can be paid out to the fees generated by the firm as long as these payments are not tied to the fees of particular clients. 4. A paralegal fee is a fee that an attorney can collect for the non-clerical work of the attorney's paralegal. A statutory fee case is a case applying a special statute that gives a judge authority to order the losing party to pay the winning party's attorney and paralegal fees and costs. 5. Avoid block billing, double billing, time padding, and task padding. These types of billing practices run afoul of the ethical codes of conduct for attorneys. Misconduct by attorneys. 1. Resist the pressure to participate in unethical behavior because of the pressure that may be placed on you by an attorney. Additionally, it is unethical to misrepresent your identity, pretexting, in order to gain access to someone's web page through friending or other method of connecting. 2. When being asked to notarize a document, be sure you actually see the person sign the document before you notarize it. Do not notarize a document before it is signed. 3. Do not participate in insider trading by virtue of the confidential information you may receive in a corporate or legal environment that is illegal. Obstructing access to evidence. Do not destroy or obstruct access to evidence in a case that could result in a charge of spoliation and have civil consequences. Crime or fraud by clients. Attorneys can discuss the legal consequences of any proposed conduct of the client, but if the attorney knows that future conduct of a client would be criminal or fraudulent, the attorney must not give the client any advice or other assistance on such conduct. Frivolous positions and harassment. It is unethical to assert a frivolous claim or defense. A claim that is brought solely to harass an opponent is improper. Safekeeping property. Attorneys must not commingle general office funds or an attorney's personal funds with funds in client trust accounts. Also, the client's record and file are the property of the client. The files must be kept intact for a period of time. After the representation ceases, check your state's requirements or office policies. False evidence and statements. Failure to disclose. Attorneys must not offer false statements to a tribunal, nor offer evidence known to be false. The attorney must tell the tribunal about a known case, statute, or other authority that will hurt the cause of the attorney's own client if the attorney knows that the opposing attorney has failed to tell the tribunal about this authority. Confidentiality. Confidential information is information related to the representation of a client, whatever its source, including the fact that someone is a client. Attorneys can reveal confidential information under certain circumstances, such as when there is informed consent and when the attorney reasonably believes disclosure is necessary to prevent reasonably certain death or substantial bodily harm. Additional exceptions are when the attorney prevents substantial injury to financial or property interest implied consent, and when the attorney and client are suing each other. 2. The attorney-client privilege protects all communications made in confidence between an attorney and client if the purpose of the communication was to obtain legal services. The attorney work product rule provides that notes, working papers, memoranda, or similar things prepared by or for an attorney in anticipation of litigation are not discoverable by an opponent, absent a showing of substantial need. They are protected by privilege. 3. Inadvertent disclosure can sometimes waive the attorney-client privilege and confidentiality. Courts look to the reasonable precautions the attorney took to prevent the closure and the length of time to discover the disclosure. 4. The attorney-client privilege and confidentiality applies to paralegals. Ethics codes from states and paralegal organizations govern the conduct of paralegals. When hired, a paralegal may be required to sign a confidentiality agreement as a condition of employment. 5. A paralegal should not discuss cases outside of the office, regardless of whether the case is public or not. Precautions should always be used to protect confidentiality, such as closing an office door when in conference, avoiding sending metadata, sending encrypted emails, and ensuring the names of the clients are not visible when transporting documents, to name a few. Conflict of interest. 1. A conflict of interest is divided loyalties that actually or potentially harm or disadvantage someone who is owed undivided loyalty. An attorney's independent professional judgment might be compromised when the attorney represents parties who have adverse interests and when the attorney's personal interests interfere with the client's interest. 2. The major categories of conflict of interest are concurrent representation, successive representation, conflict between a client's interest and personal interests of the attorney, conflict due to inconsistent legal positions, positional conflict, conflict between a current client and a non-client, conflict attributed to all attorneys in an office because of the actual conflict of one of the attorneys in the offices, vicarious conflict, and conflict when an attorney switches jobs, migratory conflict. 3. Personal conflicts include business transactions with a client as well as financial assistance to a client. Another type of personal conflict that may be created is when a client gives a gift to an attorney. Another personal conflict of interest that may occur is when the client and attorney enter into a romantic relationship. Such a relationship is prohibited under the ABA model rules unless the relationship was already established prior to the engagement of the attorney. 4. Of particular note are migratory conflicts, which can cause disqualification. Attorneys or paralegals who are in an office can be tainted because of a conflict of interest. Vicarious disqualification due to a job switch might be avoided by client consent or screening. If a paralegal did any work on a case at the former office, there is a conclusive or irrebuttable presumption If a paralegal did any work on a case at the former office, there is a conclusive or irrebuttable presumption that they obtained confidences and secrets about that case while there. There is also a presumption that the paralegal shared this information with their new firm, but this is a rebuttable presumption as well. 5. To determine whether a conflict of interest exists within an office, a conflicts check is performed. This is done through the law firm's database by checking the names of clients, companies, and other related information. They may reveal a conflict. Most law firms have software systems that perform the conflicts check. Learning how to perform a conflicts check and using the software system is an important task a paralegal must master. Communication with the other side. Paralegals and attorneys cannot communicate with an opposing party if represented by an attorney. The permission of the party's attorney is needed to communicate with that party concerning the subject of the case. This is known as the anti-contact rule. Solicitation. 1. In-person, live, telephone, or real-time electronic solicitation of clients is unethical if a significant reason for the solicitation is to seek fees or other financial benefit unless the contact is with A. another attorney, or B. someone with whom the attorney has a family, close personal, or prior professional relationship. Paralegals are subject to the same rules as attorneys relating to solicitation of business. 2. Written, recorded, or standard, not real-time, electronic solicitation of clients is ethical unless A. the attorney knows that the prospective client does not want to be solicited, or B. the solicitation involves coercion, duress, or harassment. Solicitation, when permitted, must not contain untruthful or misleading statements. Advertising. Attorneys may advertise in the newspaper, on television, online, or through other media as long as the advertisements are truthful and do not mislead the public, such as by creating unjustified expectations of the results the attorneys will be able to obtain. Advertisements must include the name of at least one attorney who is responsible for the content. Attorney websites are used to convey information to the public, but usually have disclaimers that reviewing the website does not establish an attorney-client relationship. Payment for referrals or recommendations. An attorney cannot give someone compensation payment or anything of value for referring business to the attorney or for recommending the attorney. Reporting professional misconduct. 1. Attorneys who know that another attorney has violated the ethical rules must report this attorney to the appropriate disciplinary body if the violation is serious enough to cast substantial doubt on the attorney's honesty, trustworthiness, or fitness to practice of law. 2. A paralegal can report misconduct to bar associations or law enforcement, disclosing concerns to management, human resources, or a partner of the suspected conduct is appropriate. The paralegal must avoid involvement in the unethical conduct and attempt to seek guidance without breaching any codes of confidentiality. Pro bono services. Attorneys and paralegals have a professional responsibility to provide pro bono services to those who cannot afford legal services for free or at a reduced rate. The ABA has a suggested number of hours for pro bono services by attorneys. Withdrawal. 1. There are two types of withdrawal, mandatory and permissive. Under mandatory withdrawal scenarios, attorneys must withdraw from a case if the client fires the attorney, if continuing on the case violates ethical rules or other laws, or if competent representation is jeopardized because of the attorney's physical or mental health. 2. Permissive withdrawal may occur when there are disagreements between the attorney and client or for non-payment, for example. This type of withdrawal is discretionary and will not be permitted if the withdrawal will somehow harm the client's interest. 3. When withdrawal is permitted, the attorney should send a letter of disengagement. This letter memorializes the ending of the attorney-client relationship and the reasons for the disengagement. Appearance of impropriety. Statements have rules regarding the appearance of an impropriety. They are not specific any longer and rely on the violation of the specific ethical codes of conduct. Unauthorized practice of law, UPL. An attorney cannot assist a non-attorney in the unauthorized practice of law. This can occur by a failure to supervise and failure to prevent a paralegal from rendering legal advice. Permitting a paralegal to sign a court document also may be considered the unauthorized practice of law. Paralegals. 1. Ethical opinions, rules, or guidelines exist in almost every state on the proper use of a paralegal by an attorney. All states have adopted Model Rule 5.3 or its equivalent, which requires a paralegal supervising attorney to make reasonable efforts to ensure that the paralegal's conduct is compatible with the professional obligations of the attorney. 2. The titles paralegal and legal assistant can be used because they do not mislead anyone on the person's non-attorney status. However, disbarred or suspended attorneys generally cannot use the title paralegal. If there is no misrepresentation of status, paralegals in most states can have their own business cards, can have their names printed on law firm letterhead, can sign most law office correspondence, can give non-legal advice, can draft legal documents, can assist an attorney at a real estate closing, and can represent clients at agency hearings if authorized by the agency. 4. With few exceptions, paralegals in most states cannot give legal advice, conduct a deposition, sign formal court documents, or make an appearance in court. The key to effective and ethical paralegals in a law office is environmental supervision by attorneys, which requires hiring the right people, training those people, assigning appropriate tasks, providing needed resources, monitoring progress, reviewing the end product, and rewarding competence. Your ethics or your job. Determining and reporting ethical violations is not an easy task. Find someone to talk to and present the facts that involve the unethical behavior. Sometimes the response may not be as expected, and therefore a paralegal may be in a position to have to choose between ethics and the job. Chapter Review 6-29B Key Terms. Ethics, agent, attorney in fact, power of attorney, sanctions, integrated bar association, model rules of professional conduct, MRPC, probable cause, multidisciplinary practice, MDP, paralegal codes, meritorious, letter of non-engagement, collaborative law, alternative dispute resolution, ADR, informed consent, dilatory, minimum fee schedules, fee splitting, forwarding fee, block billing, double billing, padding, time padding, task padding, client security fund, pretexting, attestation clause, insider trading, pirated software, spoliation, Federal Rules of Civil Procedure, FRCP, fiduciaries, material, confidential, privileged, work product rule, discoverable, legal malpractice, concurrent representation, co-plaintiffs, co-defendants, transactional matter, successive representation, overreaching, undue influence, bias, positional conflict, tainted, vicarious conflict, vicarious disqualification, screening, ethical wall, quarantine, conclusive presumption, rebuttable presumption, career client list, conflicts check, anti-contact rule, ex parte communications, solicitation, pecuniary, ambulance chasing, barratry, runner, whistleblower, wrongful discharge, motion to dismiss, at-will employee, diversity of citizenship, notice of appearance, cured, good cause, letter of disengagement, model rule 5.3, tickler, ratify, complaint, depositions, deponent, execution, instruments, subpoenas. Chapter Review 6-29C Review Questions. What are ethics? To what extent do attorney codes of ethics apply to paralegals? Name 4 categories of attorney sanctions for unethical conduct. 1. When is an attorney-client relationship formed? 2. What standard is used to determine attorney competence? In what ways can paralegals achieve and maintain competence? 3. What factors determine the reasonableness of an attorney's fee, and when are contingent fees unethical? 4. When is fee splitting between attorneys allowed, and what is the rule on splitting fees with non-attorneys? 5. What are block billing, double billing, time padding, and task padding? 6. What is a Rule 11 certification under the FRCP? What is a frivolous claim or defense? 7. What is a client trust account? Give 2 examples of commingling of client funds. 8. What is confidential information, and when is an attorney allowed to disclose confidential information of clients? 9. Distinguish between the ethical duty of confidentiality and the attorney-client privilege. List steps paralegals can take to avoid breaching client confidentiality. 10. What is a conflict of interest? What is a conflict check? List 7 major categories of conflict of interest. 11. When is attorney advertising ethical and unethical? 12. What is the unauthorized practice of law, UPL? Name 4 ways in which an attorney can be charged with aiding a paralegal in the unauthorized practice of law. 13. What obligations does Model Rule 5.3 place on attorneys who are direct supervisors of paralegals? What obligation does Model Rule 5.3 place on partners or other managers of an office? 14. What are some of the major guidelines on what attorneys can and cannot allow their practice? 14. What are some of the major guidelines on what attorneys can and cannot allow their paralegals to do? What are the major components of comprehensive supervision of paralegals? Chapter Review 6-29D Assignments Critical Analysis 6.1. Does a paralegal have an obligation to report unethical conduct? If so, to whom should the report be made? 6.2a. Paul Emerson is an attorney who works at the firm of Rayburn and Rayburn. One of the firm's clients is Designs Unlimited Incorporated, DU, a clothing manufacturer. Emerson provides corporate advice to DU. Recently, Emerson made a mistake in interpreting a new securities law. As a consequence, DU had to postpone the issuance of a stock option for 6 months. Has Emerson acted unethically? B. Three individuals in Connecticut hire a large law firm. B. 3 individuals in Connecticut hire a large New York law firm to represent them in a proxy fight in which they are seeking control of a Connecticut bank. They lose the proxy fight. The firm then sends these individuals a $358,827 bill for 895 hours of work over a 1-month period. Is this bill unethical? What further facts would you like to have to help your answer? What further facts would you like to have to help you answer this question? C. Victor Chow and Len Patterson are full partners in the law firm of Chow, Patterson, and Kelly. A client contacts Len Patterson to represent him on a negligence case. Patterson refers the case to Victor Chow, who does most of the work. Under an agreement between them, Patterson will receive 40% and Chow will receive 60% of any fee paid by this client. Patterson does not tell the client about the involvement of Chow in the case. Are there any ethical problems? D. An attorney establishes a bonus plan for paralegals in their law office. A bonus will be given to those paralegals who bill a specified number of hours in excess of a stated minimum. The amount of the bonus will depend on the amount billed and collected. Determine whether this practice presents any ethical issues. If so, identify the ethical issues of the attorney's practice. E. Leonetta works in a law firm that charges clients $225 an hour for attorney time and $100 an hour for paralegal time. Leonetta and another paralegal, Frederica, are working with an attorney on a large case and sees all of the timesheets that the 3 of them submit to the firm's accounting office. Leonetta suspects that the attorney is padding their timesheets by overstating the number of hours they work on the case. For example, the attorney lists 30 hours for a 4-day period when they were in court every day on another case. Furthermore, Frederica's time is being billed at the full $100 an hour rate, even though they spend about 80% of their time typing correspondence, filing, and performing other clerical duties. Leonetta also suspects that the attorney is billing out their time at the attorney rate rather than the paralegal rate normally charged clients. What are the ethical issues created by the attorney's actions? What should Leonetta do? F. Vince Jared is an attorney who works at the firm of Johnson & Johnson. He represents Ralph Grand, who is seeking a divorce from his wife, Anita Grand. In their first meeting, Jared learns that Ralph is an experienced carpenter but is out of work and has very little money. Jared's fee is $250 an hour because Ralph has no money and has been having trouble finding work. Jared tells Ralph that he will not have to pay the fee if the court does not grant them the divorce. One day, Jared learns that another of their clients, Helen Oberlin, is looking for a carpenter. Jared recommends Ralph to Helen and hires him for a small job. 6 months pass. The divorce case is dropped when the Grands reconcile. In the meantime, Helen Oberlin is very dissatisfied with Ralph's carpentry work and claims Ralph didn't do the work they were contracted to do. Helen wants to know what to do about it. Helen tries to call Jared at Johnson & Johnson, but is told that Jared does not work there anymore. Another attorney at the firm, Georgia Quinton Esquire, helps Helen. Are there any ethical problems presented? Explain your response. G. Marlon Fenton is a paralegal who works for Tom Dawson, Esquire, a solo practitioner. Marlon works extensively on workers' compensation cases. Tom has been tied up for months in a complicated mass tort case. One day, a workers' compensation client calls Marlon to ask whether their injury qualifies for extended benefits under the state's workers' compensation law. Marlon puts the client on hold and calls Tom during a recess of the tort trial. When Marlon asks Tom the question, they reply, "I don't remember the answer to that, but it's in the code. Just check under injuries or filings and tell the client what you find. Besides, you know more about this area of law than I do." Marlon does so. Are there any ethical issues presented under these facts? If so, identify the issues, if any, based on Marlon's conduct. H. A paralegal quits the firm of Smith and Dudley. When they leave, they take client documents they prepared while at the firm. The documents contain confidential client information. The paralegal is showing these documents to potential employers as writing samples. What is the ethical liability of attorneys at Smith & Dudley under Model Rule 5.3? I. Peter is a paralegal at Smith & Smith. One of the cases they worked on is Carter v. Horton. Carter is the client of Smith & Smith. Peter does some investigation and scheduling for the case. Horton is represented by Unger, Oberdorf, and Simon. The Unger firm offers Peter a job working in its law library and in its computer department on database management. Peter takes the job. While at the Unger firm, Peter can see all the documents in the Carter v. Horton case. At lunch, a week after Peter joins the firm, they tell one of the Unger attorneys, Jack Dolan, about an investigation he conducted while working for Smith & Smith on the Carter case. Jack is not one of the Unger attorneys working on Carter v. Horton. 2 weeks after Peter is hired, the Unger firm decides to set up an ethical wall around Peter. Peter is told not to discuss Carter v. Horton with any Unger employee. All Unger employees are told not to discuss the case with Peter. The files are kept away from Peter, etc. The wall is rigidly enforced. Nevertheless, Smith & Smith makes a motion to disqualify Unger, Oberdorf, and Simon from continuing to represent Horton in the Carter v. Horton case due to Peter's presence at the Unger firm. Should this motion be granted? J. Sam is a paralegal in the law firm of Orson and Jacobs. Rachel is a prospective client. Calls one day. Sam answers the phone. Any ethical problems based on the following conversation? Rachel, how much does the firm charge to take a case? Sam, $200 an hour. What kind of case is it? Rachel, I was injured as a passenger in an automobile accident. Sam, then the firm will probably take the case on a contingency, meaning that you pay nothing unless we win. Projects 6.3. Compile a bibliography of sources covering legal ethics applicable to attorneys and paralegals in your state. The bibliography should include paper book resources and online resources, include ethics codes, guidelines, opinions, treaties, articles, and related material. You can also include materials that are national in scope, but the focus of the bibliography should be legal ethics in your state. Check bar associations. Check bar associations for legal opinions, paralegal organizations, and disciplinary cases. Place in your portfolio binder. Chapter Review 6-29E Core Skills Assignment. Core Skill Writing 6.4. Create a Facebook page for a law firm that specializes in cannabis regulation. Research the area of law, including what is required to set up a company, bank account, and the restrictions associated with the sale of cannabis. Be creative in setting up the page. Core Skill Research 6.5A. In Google Scholar or similar site, perform the search paralegal conflict of interest to find a court opinion written by a state court in your state in which one of the issues involved paralegals and a conflict of interest. If none exists, pick another state to answer these exercise questions. What is the name of the case and citation? What is the name of the judge who wrote the opinion? In what way did the opinion involve a paralegal conflict of interest? Alternatively, perform the search paralegal unauthorized practice of law to locate a case in your state in which one of the issues involves the unauthorized practice of law. What is the name and citation of the case? What is the name of the judge who wrote the opinion? How was a paralegal involved in the unauthorized practice of law? B. Perform the same search to find 2 articles on paralegal conflicts of interest or paralegal unauthorized practice of law. What is the citation of the articles? Identify the website where the article was found. Core Skills Computers 6.6a. Determine how to perform a conflict of interest check. List the steps that are necessary in performing the conflicts check. B. Using Google or similar search sites, determine the procedure in creating an ethical wall when a paralegal or attorney has previous involvement in a case. C. What software programs can a law firm use to perform a conflicts check? Core Skill Collaboration 6.7. Draft your own paralegal code as a class project. Use any of the material in Chapter 6 as a resource. First, have a meeting in which you make a list of all the issues that you think should be covered in the code, like, for example, what job titles can be used, when a job title must be disclosed, and what tasks a paralegal can and cannot perform. Divide up the issues by the number of students in the class so that every student has roughly the same number of issues. Each student should draft a proposed rule on each of the issues to which they are assigned. Accompany each rule with a brief commentary on why you think the rule should be as stated. Draft alternative versions of the proposed rule if different versions are possible, and you want to give the class the chance to examine all of them. The class then meets to vote on each of the proposed rules. Students will make presentations on the proposed rules they have drafted. One member of the class should be designated the code reporter, who records the rules accepted by the class by majority vote. After you have completed the code, place the final product in your portfolio binder. The job search 6.8. Locate a job listing for a conflict specialist. Important example, i.e., a person who assists a law office determine whether a prospective client would cause a conflict of interest at the office. What does the job entail? And what are the qualifications for the position? Give the site address where you found this information. Chapter Review 6-29F Portfolio Binder Assignment 1. You are an independent paralegal contractor such as a DSP. You want to increase your business exposure within the legal community. Having a media campaign and advertising campaign seems like a worthwhile investment. Create a social media campaign with advertising of your services and specialties. 2. As part of your media campaign, determine how often you believe you will need to post on your social media sites and the content. Create your plan of action for your company's media blitz. Be creative, but stay within the confines of your ethical responsibility. When your campaign is completed, place in your portfolio binder.